my lord had given a date for it to be listed. Not come up.
ಬಂದಿಲ್ಲ ಚೆಕ್ ಮಾಡ್ರಿ.
Fresh matter, my lord.
ಯಾಕೆ ಬಂದಿಲ್ಲ?
16th I had moved. My lord had given a date for today.
ಚೆಕ್ ಮಾಡಿ ಯಾಕೆ ಬಂದಿಲ್ಲ ಅಂತ. Call that person.
16th, 14ನೇ ತಾರೀಕು.
Day before yesterday,
the date is
directed the
date
to
is
post this matter. In spite of that
26th.
matter was
ಕೊಡಿ
not-
ಕೊಡಿ ಅದು
ಅದು mediation ಹೋಗ್ಬಿಡುತ್ತೆ ಅಷ್ಟೇ ಏನಿಲ್ಲ.
ಆಯ್ತು ಕೊಡಿ.
ಪಾರ್ಟಿ ಸಮಾಪ್ತಕ್ಕೆ ಇಟ್ಕೊಂಬರುತ್ತೆ ಅಷ್ಟೇ.
ಲಿಮಿಟೇಷನ್.
Mediation.
My lords,
Yes. Tomorrow. ಆಯ್ತು.
one matter, my lords.
RFA tomorrow, you please circulate all the memos.
My lords, RFA, my lords, end of the list, my lords.
ನಾಳೆ admission sir.
My lords, one fresh matter, my lords, end of the list, my lords. We have moved the memo, my lords, the memo. has been
RFA.
moved. Yes, my
ತಗೊಳ್ಳಿ ಯಾಕೆ ಬಂದಿಲ್ಲ ಕರೀರೋದು ಯಾರು?
My lord,
You had moved yesterday.
we have moved the
My
memo
lords,
yesterday
FD
and day before yesterday also.
FDP proceedings pending 7 years, your lordship. Maybe more.
Yes,
RFA 2024.
tomorrow.
First.
ಕರೀರಿ. Documents.
Adjournments phase wise. List number 1. See page number 8, serial number 33 to 37. Page number 9, 37 to 42. Page number 10, serial number 43
Number
to
41, RFA 1308. I am seeking short adjournment, your lordships.
For
The-
what, madam?
The arguing counsel has come down with a throat infection. It may be taken up in the next
It's
week.
all right. This is for admission.
It may be taken up in
No,
the
no,
next week, your
no
lordship.
adjournment. It is for admission.
Short adjournment, your lordships.
It is for admission, madam.
I
So
understand.
therefore, please
The
don't
arguing
ask for
counsel
it.
has come down with a throat
Yes, next,
infection, your
next,
lordship.
next.
page number 9, serial number 37 to 42. Page number 10, serial number 43 to 49. Page number 11, serial number 50 to 55. Page number 12, serial number 56 to 59.
Serial number 58 for estimate number 1. So I have no TCR. So apply before this honorable court on 7th March. Still I have not got it. So I seek adjournment, your honor.
Paper books dispensed. TCR ಬಂದಿಲ್ವೇನ್ರಿ ಇದು?
ಇಲ್ಲೇ ಹಾಕಿದ ಅಪ್ಲಿಕೇಶನ್.
ಹ? ಬಂದಿರುತ್ತೆ ಅಂದ್ರೆ? ಆಯ್ತು ಚೆಕ್ ಮಾಡಿಸಿ. What do you want?
I seek adjournment, your honor.
Learn counsel for the appellant seeks time list on sounds.
Do not sign for respondent number 1 and for respondent number 2.
Subair. Learn counsel for the respondent number 1 seeks time list on sounds. Please intimate the other side.
Yes, your honor. I will intimate because I have no contact number of themselves. I will.
That is your problem, mister. You should intimate. When you are moving the matter at 10:30, please intimate the other side.
Your honor, I will wait here itself. When they come, I will intimate them.
Huh?
Don't fail. I will intimate them when they hear.
If he comes and says that you are not intimated, I will take it up.
Yes, your honor.
It is your risk.
Yes, your honor.
Page number 13, serial number 60 to 64.
62, your honor. My lord, kindly, I'm for the appellant and kindly seek a short adjournment, your honor. One long date may be given, your honor.
Counsel for the appellant seeks time list on sounds.
My lord, say number 64, my lord, sir. 2 weeks time, I'm infected with herpes, my lord, sir. Doctors, 64 hours.
Infructuous, sir.
No, my lord, sir. Sure, I am infected with herpes, my lord, sir. So doctors advise for 2 weeks, my lord, I should not.
Learn counsel for the appellant seeks time list on so and so.
2nd
But
April.
interim order may kindly be extended, my lord.
Interim orders extended. Please intimate the other side.
I have intimated, my lord,
Page
sir.
number 14, serial number 65 to 68. Page number 15, serial number 69 and 70.
My lord,
70 pronouncement already.
my lord, serial number
54, my lord. 54. Requested the other side. Next week, my lord, I think
54,
54. Requested Mr. Muralidhar in the morning.
ಇದು ಲಾಸ್ಟ್ ಟೈಮ್ ಬಂದಿತ್ತಲ್ವಾ ಇದು?
ಬಂದಿತ್ತು. I informed, I interacted with my clients also.
Settlement. Learn counsel for the appellant seeks time list on sounds.
My lord, serial number 15.
Please, madam. 2nd
My
April.
lord, serial number 15. I appear for respondent number
15.
15, my lord.
Please wait. Yes.
2nd April. List number 1 for order, serial number 1, Appellant Hombalamma. Appellant party in person Hombalamma.
Hombalamma. There is no representation for the appellant is absent. Even though the notice issued by the court is held sufficient. Office objections are not complied till date. And so appeal is dismissed for non-prosecution.
Serial number 2.
Office objections, counsel to sign the appeal memo, date of disposal was. Office objections are overruled. Issue emergency notice to the respondent.
Serial number 2. Nataraj Ballar.
For appellant. ಇದರಲ್ಲಿ ವ್ಯಾಲ್ಯೂಯೇಷನ್ ಸ್ಲಿಪ್ ಹಾಕಿಲ್ಲ ಅಂತ ಹೇಳಿದ್ದಾರೆ. ಪೇಜ್ ನಂಬರ್ 57 ವ್ಯಾಲ್ಯೂಯೇಷನ್ ಸ್ಲಿಪ್ ಹಾಕಿದೀವಿ.
ಎಷ್ಟಿದೆ ವ್ಯಾಲ್ಯೂ?
ಅದು 200 ರೂಪೀಸ್. ವ್ಯಾಲ್ಯೂ ಬಂದು 30 lakhs ತೋರಿಸಿದೆ, 33 lakhs ತೋರಿಸಿದೆ. ಇಟ್ಸ್ ಎ ಟ್ರಸ್ಟ್ ಪ್ರಾಪರ್ಟಿ.
33 lakhs.
ಇದು ಟ್ರಸ್ಟ್ ಪ್ರಾಪರ್ಟಿ ಇದೆ. ವಿ ಆರ್ ಡಿಫೆಂಡೆಂಟ್ಸ್. ಅವ್ರ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ plaintiff have filed only 200 rupees of court fee.
No, what is the suit for?
Suit for declaration.
Declaration.
Trust.
Suit property is valued at 33 lakhs.
Yes, madam.
ಎಲ್ಲಿದೆ ಅದು?
ಪೇಜ್ ನಂಬರ್ 71 ಅಲ್ಲಿ ಇದೆ.
71.
paragraph. The plaintiff submits that the suit schedule property have been sold by the first defendant for the sum of 33 lakhs. And accordingly, as per the section 27 of Karnataka Court Fees and Suit Valuation Act 1958, a court fee of 200 has been paid by this plaintiff being maximum court fee.
In view of the averment made in paragraph number 23 of the plaint filed in OS number 1/2015, from which this appeal arises, the office objection regarding for filing a certified copy of the.
It is filed.
ಅದು ಮಾಡಿದಿರಾ?
ಅದೇ ಇವಾಗ ಓದಿಲ್ಲ.
Non furnishing the detailed valuation slip is overruled. It is held that the valuation of the appeal for the purpose of court fee is a sum of rupees 33 lakh. Court fee and jurisdiction is a sum of rupees 33 lakhs. And hence the appeal is to be tried by a division bench of this court. This appeal before the division bench. Counsel for the appellant is directed to furnish a second set of.
Second set already furnished.
If not already furnished.
Serial number 3.
Maximum notice may be issued. 3 years earlier.
How can I issue notice, Mr.? Matters to come before division. Have some comprehension in what you are submitting. Yes.
Serial number 3. Dikshit Vaya.
I am appearing for appellant in this case, my lord. My lord, I press 1 week time to comply the office objections, my lord.
You do it today, otherwise we are dismissing it.
My lord, at least 2 days time, my lord. Kindly.
Oh, sorry. 6th time.
Please, my lord,
the office objections are not complied even after granting 6 opportunities. Hence, appeal is dismissed for non-prosecution.
My lord, please. 2 days, my lord, time.
ಇವೆಲ್ಲ ಕಂಪ್ಲೈ ಮಾಡಿ ಮೂವ್ ಮಾಡಿ ಐಎ ಮೂವ್ ಮಾಡಿ ನೋಡಿ ನಿಧಾನಕ್ಕೆ ಮಾಡಿ.
Serial number 4. Babu DR.
Same order. Shankar Narayan Bhatt.
Number 5.
I have complied the office objection.
Non-compliance ಏನಿದು?
That's one. The objections.
Number 1, LR details to be stated in cost title of the appeal.
I have stated in paragraph number 2.
Do it within 1 week, Mr. 1 week time is granted to do the.
I have stated in paragraph number 2 about that.
ಆಯ್ತು, ಕೌನ್ಸಿಲ್ ಸಬ್ಮಿಷನ್ ಬರ್ಕೊಡಿ ಏನು ಅಂತ.
ಅಲ್ಲಿ ಬರೆದು ಕೊಟ್ಟಿದ್ದೆ, ಅದಕ್ಕೆ ಅವರು ಇದು ಮಾಡಿರ್ಬೇಕು ಅಷ್ಟೇ.
ನೋಡಿ, there are about.
Yes,
4 objections.
Detailed memo of valuation to be
That-
filed
that's
along
also
with
I have
guidance
filed,
to
page number-
verify the value for purpose of jurisdiction.
I have filed in page number 10, I have, it's a detail I have
The
given.
application to be filed in respect of defend number 1.
Defend number 1, so LRs are already record, therefore I have said no further application is required.
When did defend number 1 die? After the suit or after the
During
judgment?
the pendency of the suit, she died, but the court, even the memo was filed, court, by mistake, they have not noted it. And this is a partition suit, and all other parties before the court are their LRs. That's what I have stated in para 2 of my appeal memo. In para no, I stated, original first defendant Munyamma died on 15/2/22, leaving behind the appellants and the respondent 1, 2, and 4 as her LRs and succeeded to her estate. Separate application was filed. No separate application is filed except filing memo reporting the death. That the part is on record.
Yelli the memo?
Memo, in the lower court it was filed, Mila, not in this court. Here I have mentioned in
Where
the.
is that memo? Where have you given your counsel submissions? Where have you given your submissions?
And
I think it is a death certificate of the deceased of the defendant number 1 is placed on record, which indicate the defendant number 1 died on 11/5/2022. That is prior to the decree in OS number 26652 of 2012. It is also claimed by the learned counsel for the appellants that a memo was filed before the trial court to implead the legal representatives of the deceased
Already on
defendant.
record there, partition suit.
ಅಲ್ರಿ ಮೆಮೋನಲ್ಲಿ ಕೊಟ್ಟಿದ್ರಿ ಅಂತ ಹೇಳ್ತಿದ್ದೀನಪ್ಪ.
Sorry.
To mentioning the names of the legal representatives of the defendant number 1 and inadvertently, the trial court has not taken any steps in that regard. Full stop. He submits that the legal representatives of the defendant number 1 are now already on record in this appeal, and therefore office objection serial number 2 and 5 be overruled. He also submits guidance value ಕೊಟ್ಟಿದ್ದೀರಾ?
ಹೌದು ಕೊಟ್ಟಿದ್ದೀನಿ, page number 10 ನಲ್ಲಿ.
A guide memo along with guidance value of the property in question is furnished, and a detailed valuation is set out. Valuation of the appeal is mentioned in the appeal memorandum. The office is directed to check and verify office objection number 3 and 4 in the light of the submissions of the learned counsel for the appellant. List on date kodi for admission on date kodi.
2nd April. Serial number 6. Balakrishna
V. Balakrishna, 7th time ejectment. There is no representation for the appellant. Even after granting 7 opportunities, no steps are taken to comply the office objections. Hence, the appeal is dismissed for non-compliance of office objections.
Serial number 7.
Mohan Kumar HG.
For petition,
Seventh.
my lordship, there is a chance of settlement, my lordship. There is a chance of settlement, my lordship. Kindly refer the matter to the mediation, my lordship.
No. Dismiss.
Your lordship, one humble submission.
You settle ಮಾಡ್ಕೊಂಡು first ಇದು ಮಾಡಿ ಕಂಪ್ಲೈ ಮಾಡಿ.
Coming course of the day ಮಾಡ್ತೀರಿ sir. Kindly pass.
Learn counsel pass over. Pass over.
Serial number
Delhi
8.
Cuckoo.
Delhi Cuckoo.
A memo is filed by the
Memo filed by me.
By the appellant to delete the respondent number 9 from the array of parties. In view of the memo, R9 is ordered to be deleted at the request and risk of the appellant. Counsel for the appellant is directed to amend the cause title and indicate the deletion of respondent number 9.
Now itself I'll do it.
Do it now.
My lord did.
Date and proof for death of defend number 6 ಏನೋ ಸತ್ತೋಗಿರೋದು ಪ್ರೂಫ್ ಕೊಡ್ಬೇಕಂತಲ್ಲ.
ಅದೇ ಅವ್ರೇನೆ ಅದು ಡ್ಯೂರಿಂಗ್ ಪೆಂಡೆನ್ಸಿ ಆಫ್ ದಿ ಸೂಟ್ ಅಲ್ಲೇ ತೀರ್ಕೊಂಡ್ಬಿಟ್ಟಿದ್ದಾರೆ. ಅದು
R9. In view of the deletion of R9, office objection, objections raised by the office that the appellant has not produced the proof of death of R9 is overruled. Yes.
My lord, the admission date may be.
This for admission on date. MD Raghunath.
Serial number 9, MD Raghunath.
Lord, for these IAs are served on me. It says that it is served through
What
RPI,
IAs?
but I have not received.
What are these
The
IAs?
respondent has filed some applications. Party in person.
Yes, Your Honor, I'm the party in person for respondent to 1 and 2.
So what applications have you filed?
To eviction of the stay, Your Honor.
What is the suit for?
It is an eviction
Lord,
suit.
execution is filed. I filed
For
an
the eviction.
application under Order 21, Rule 97, seeking obstruction of the decree, please, my lord. Lord, my application is rejected and I come before this honorable court. Initially, interim order is granted, which is in subsistence. Lord, my contention is, during pendent, a suit for ejectment is filed by respondents 1 and 2 against the third respondent. There is a decree of ejectment confirmed by this honorable court in appeal. But during pendency of the appeal, the respondents 1 and 2 have sold the property to X. X leases out the property to me. I am in possession of the property.
X is leased out.
Yes, please, my lord.
To you.
Mr. Dastagir is the person who has purchased the property. He has leased out the property to me. I am in physical possession as a tenant under Mr. Dastagir.
Yes.
Since they brought the delivery warrant to evict me, I had no other recourse except to file an application for obstruction. Now, trial court rejects my application on the ground that I am claiming under the JDR. Therefore, I am not entitled to. I am not claiming under JDR at all.
Your Honor, if I may
So where's
respond.
your application for?
Lord, the application.
What is your contention?
Lord,
Kindly not to seek any relief as against object.
At page 29, my lord.
Para 2 of the order, Odi.
Para 2, please. The applicant objector has filed IA-6 and
MR Sharif antide.
But correct. But I claim under Dastagir. Sorry, I'm sorry, Sharif. I'm sorry, my lord. I stand corrected. The said property was purchased by owner Mr. M.R. Sharif, son of A.R. Sharif, from his previous owner, Lalita, wife of Medappa, decree order 1 herein, under registered sale deed dated 22/6/2018. As such, being the fact the decree order colluding with each other are trying to oust the objector out of the scheduled premises, and the objector has
What
filed
is there to show that they have sold it to M.R. Sharif?
Lord, court did not go in for inquiry, please, my lord.
ಆಯ್ತು ನೀವೇನು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ದೀರಾ?
That opportunity is also not granted.
Not opportunity, at least some, just because you filed an application, that doesn't mean that it should go for trial. What is the material that you have produced to show that the respondents 1 and 2 have sold it to Sharif on 22/6/2018?
Registered sale deed, my lord, if records are called for, my lord, I think we would have produced it. Allah, trial court, Nanatra ide. I have the sale deed copy.
Yes, Your Honor. Medappa and Srimati K.S. Lalita.
I have the sale deed copy.
If I may respond?
Yes.
Your Honor, the rental agreement that they have signed for is dated.
Did you understand what happened?
Yes,
What was
Your
the
Honor.
discussion?
Yes, Your Honor.
As your mother, Lalita is your mother?
Yes, Your Honor.
As your mother sold the property to Sharif?
Yes. No, Your Honor.
On
It's a fake registration. I have a FSL report. I've already submitted it, which confirms that this is a fake registration, and the signatory or the signature that.
Who has to decide that whether it is fake or not?
Yes, Your Honor. That may not be the question, but let me respond in another manner. So the rental agreement that they've produced is dated 21/3/2023.
Yes.
Yeah. And in the encumbrance certificate that I have already produced, also available with me, is that Mr. Sharif has already sold it to another person called Afzal on dated 3 July 2018 again, right? So in that manner, the rental agreement dated 21/1/2023 is invalid because he doesn't.
Why do you say so?
Because he doesn't have any legal authority, because he's already sold the property to someone else.
Yes.
Before that date, right? So this agreement that they produced.
They're not on that.
Right, sir.
He says that your mother has sold the suit property to Sharif on 22/6/2018.
It is not sold, Your Honor. There's a legal criminal case pending which confirms that.
But the court has to look into that.
Yes, Your Honor. Yes,
The
Your Honor.
court cannot simply
Yes, Your Honor.
rubbish it.
Yes, Your Honor. I've submitted the FSL report for the confirmation.
FSL report yaru?
Police in the submit agirod, sir.
Should it not be tested before the court?
Yes, Your Honor. I have submitted for your consideration.
But tested under there's a procedure.
Yeah.
You have to go into the witness box. Somebody will have to depose. You will have to establish that it is fake.
Okay, Your Honor.
Now, when there's a registered instrument,
right,
that instrument will have to be annulled in some manner. Otherwise, just the way Sharif has sold it to somebody, somebody has sold it to somebody.
Yes, Your Honor.
Without you knowing,
right,
your property will be encumbered again and again and again and again. So
That's
that chain has to be cut.
Yes, Your Honor.
If that chain has to be cut, the court has to give a finding
That's
that
true.
this sale deed which is put up by the tenant is a fraudulent document.
That's true, Your Honor. So if my other consideration is also the fact that at the time of the agreement, rental agreement that they're producing, the whole basis of their suit is that they have a rental agreement from current owner, which is invalid because the owner, he wasn't the owner at the time of the rental agreement.
Yes.
So in that case, doesn't the application itself become null and void because they do not have the authority to even sign the
But if
rental
you have
agreement?
sold it,
I haven't sold. Okay.
if you have sold, see, right or
Got it.
wrong, there is some document to show that your mother has sold the property to Sharif.
Okay.
It might be a wrong document
Yes,
or a
sir.
fraudulent document or a bogus document.
Yes, sir.
That document has to be annulled in the manner known to law.
Yes, sir.
So in execution, if the court were to give a finding
Right.
that this document is fake or fabricated, without that, how can the court simply reject the application and say that
Because this same rental agreement has been attempted 5 times before. The same person has issued rental agreement to the previous, the third respondent, which
what is the
also-
date of the decree?
So there was already an RFA which was
Please
there.
tell us what is the date of the decree?
2/1/2019.
2/1/2019.
Yes, Your Honor.
Correct?
Yeah.
Before the decree was passed, the allegation is that your mother has sold it to one Mr. M.R. Sharif. That is on 22/6/2018.
Okay.
Before the decree, the property is already sold to Sharif.
Okay.
Is the allegation.
Yes, yeah. Which is, yeah, okay. I
Now,
get it. Yeah.
There is a registered sale deed to show
Yes, Your Honor.
that is document is registered.
Yes, Your Honor.
There is a registration to show that this sale deed is registered.
Yes, it's there.
So therefore, this sale deed has to be annulled, alva. Somebody
Yes.
has to comment on the sale deed.
Yes, Your Honor. For that, there is a criminal case. We've already.
ಕೇಸ್ ಅಲ್ಲ ಸಿವಿಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಆಗ್ಬೇಕಿದು.
Civil court allow.
ಕ್ರಿಮಿನಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಸೇಲ್ ಡೀಡ್ ನ ಸೆಟ್ ಅಸೈಡ್ ಮಾಡಕ್ ಬರೋದಿಲ್ಲ.
Okay.
ಇನ್ ದ ಸಿವಿಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಮಾತ್ರ ಸೇಲ್ ಡೀಡ್ ಸೆಟ್ ಅಸೈಡ್ ಆಗೋದು.
Your Honor, ಇವರು ಅಪ್ಲೈ ಮಾಡೋದಕ್ಕೆ ಅಥಾರಿಟಿನೇ ಇಲ್ಲ ಅಲ್ಲ, Your Honor.
ಏನು ಅದಕ್ಕೆ ನೀವು ಒಬ್ರು ಲಾಯರ್ ಇಟ್ಕೊಳ್ಳಿ.
ಇಲ್ಲ sir, I understand what you're
saying. What do you
saying.
do for a living?
I work in a private company.
What do you do? Are you an engineer?
Accountant.
Accountant. Then
I've tried this multiple times. It takes way too long for us to go through the lawyer procedures. So
please-
that's why I'm doing it myself.
see, when you're not informed, either you should learn on
Yes,
your own
I completely
or
understand.
go to somebody who knows it.
Your Honor, this same rental agreement issued by the same person to different people has been rejected by the Honorable High Court twice and thrice by the Civil High Court. So I thought in this case it will be the same because it's. I thought it will be a.
But why don't you get what the court is telling you?
I
Why
get.
don't you
I
understand?
completely understand where you're coming from.
What is it? What is it? The court is trying to convey.
You're told that there is an already registered agreement available which has to be nulled and void, and that has to be actioned upon, which makes complete sense. We are working on it. But in this case, their application itself doesn't hold any ground because it doesn't have any legal bearing.
Okay, I'll break it down further.
I can understand.
Suppose if your mother has sold it to Sharif
Yes, sir.
and Sharif has leased it to him, can you evict him?
But if Sharif has already sold it before,
Forget that.
After that, he signed
Forget
it.
that. You have not leased it to him. You have not leased it to him.
No, I haven't.
He claims that Sharif has leased it to him.
It's just two brothers making mockery of the procedures available through the High Court.
That mockery, somebody has to call it bluff.
Yes, Your Honor. How do I do that, Your Honor?
So therefore, we'll have to send the matter back to the executing court.
Okay.
And we'll have to direct the executing court to conclude this within maybe 2 months, 3 months, or 6 months.
It's already 12 years since the case is going on, Your Honor. I would
ನೀವು ಈ ತರ
request-
argument ಮಾಡಿದ್ರೆ 6 years ಆಗುತ್ತೆ, 60 years
I
ಆಗುತ್ತೆ.
would request you to please do the same. I can completely agree with it, but please ask them to action at an earlier state. That's all I'm asking, Your Honor.
Where's the registered sale? ಇದೆಯಾ copy ಇದೆಯಾ sale deed? Do you have a copy of the sale deed? ಕೊಡಿ. Yes, you. Power of attorney.
Yes, my lord. That also is registered.
Power of attorney is also registered.
I think so. One nimisha. Yes, please. Registered power of attorney. Sir.
Please read the finding of the executing court.
Please, my lord.
Para 9 in the OD.
Please, my lord. On
Please
perusal
read
of the
from para
pleadings
9
and-
of the order.
Please, my lord. Page 11, in page 19. On perusal of
You
pleadings.
have a
and-
copy?
I have it, but I didn't carry it.
You didn't bring it.
I remember it, please go ahead.
You remember the whole thing?
No, but I know the gist of it, so.
How can you come to the court without the papers?
I'm sorry, Your Honor. I was prepared with the documents that I had to submit, so.
It's over there. Yes, please.
Please,
read.
my lord. On perusal of pleadings and documents placed with the objector and decree holder, it clearly appears that objector is claiming a right under one M.R. Sharif, alleged to be the owner who has purchased the property from the decree holder by registered sale deed dated 22/6/18. It is clear that objector has not claimed his independent right in respect of the scheduled property, but as a tenant under M.R. Sharif. In the judgment passed by the Honorable High Court in RFA 447 of 19, dismissed the appeal of JDR and confirmed the order passed by the court in OS 4934 of 12. Further, the Honorable High Court has also directed JDR not to enter into any transaction or execute any document in favor of Sharif or anyone else in relation to the suit.
Yeah, JDR. Further, the Honorable High Court has-
JDR shall not enter into any transaction or execute any document.
Yeah, the OS 4934.
That is the original suit for ejectment.
No, ejectment is 4933.
This is the execution case, execution order.
So I think it must be some injunction suit, please, my lord. Further, the Honorable High Court has also directed JDR not to enter into any transaction or execute any document in favor of Sharif or anyone else in relation to suit scheduled premises, nor induct Sharif into occupation of suit scheduled property. The counsel for DHR also relied upon judgment passed in Honorable High Court of Karnataka in RFA 100321 of 19, and so on, so wherein the Honorable High Court has held that application filed without having prima facie right or interest is liable to be rejected at the initial stage. The court may not entertain third-party application for such other reasons as court thinks not entertainable. In the landmark judgment of Apex Court in Silver Line Forum, wherein the Apex Court has held that it is incumbent on the execution court to adjudicate upon complaints of resistance in respect of execution of decree. Further, it is held that adjudication mentioned under Order 21 Rule 97(2) need not necessarily involve a detailed inquiry or collection of evidence. The court can make the adjudication on admitted facts or even on the averments made by the registrar. Of course, the court can direct the parties to adduce evidence for such determination if court deems fit necessary. On the basis of above findings and propositions of the law laid down by Honorable Apex Court and High Court of Karnataka, this court is of the view that question of determining the ownership of property to adjudicate the application is not necessary, as the objector himself has categorically admitted that he is claiming right as a tenant under
ಎಲ್ಲಿದೆ
JDR.
RFA 448 ಇಲ್ಲಿದೆ. Where is the order passed in RFA 448?
That is not produced, please, my lord. I am not a party to that proceedings.
No, your
No, my vendor is, my lessor is also not a party.
Lessor had filed an application in that appeal. That application was rejected. Come to para 13 of the order.
Please, bro. Further, the decree holder has also produced copy of IA, whereby Mr. M.R. Sharif has made an application before Honorable High Court of Karnataka in RFA 448 of 19, and the said application was dismissed. Therefore, the right of Sharif in respect of such property has not been established, and accordingly, the objectors being tenant under Sharif failed to establish independent right in respect of suit scheduled property, and therefore application under IA 6 filed by objector deserves to be rejected.
Where is your application?
My lord, my application is at page 27. My lord.
Page 20?
Sorry, 29. Please, bro, 29. It is submitted execution petition filed by decree holder is neither maintainable either in law or on facts, and more so, the present petition is not at all maintainable for the reason decree holder is not at all the owner of the property and JDR is not at all in possession of the property. As such, execution petition has to be dismissed as not maintainable. It is further submitted that objector herein is in peaceful possession and possession of the southern portion of side property bearing number 4, 5, 6, 7, 8 and 4, 5, 6 and 7. Measuring 30 by 140 feet, in all measuring 4,200 square feet out of 60 by 150, situated in number 146/6 and 146/7, bearing number so and so. As a tenant, as per tenancy lease agreement, lease cum rental agreement dated 21/1/2023. Copy of the said lease cum rental agreement dated 21/1/2023 is herewith produced at document number 1. It is submitted that owner of the objector herein, M.R. Sharif, has purchased the site from its previous owner, Srimati Lalita, wife of Medappa, that is decree holder number 1, under registered sale deed dated so and so, registered in the office of so and so. The copy of the said sale deed is herewith produced at document number 2. It is submitted the objector herein is in peaceful possession and enjoyment of the scheduled property as a tenant on rental basis, monthly rent of rupees 15,000, and has paid 10 lakhs as advance amount to M.R. Sharif, and since then running scrap granite business and has invested more than 25 lakhs for the business purposes. It is submitted that when such being the factual situation, decree holder 2 colluding with each other are trying to oust the objector out of the scheduled premises with a malified intention. As such, objector has approached the Honorable City Civil Court Mayhall in OS 254.
Who is the latest purchaser now? From Sharif?
Afzal Khan.
Afzal Khan. From where did you get that?
From the EC that I have. Encumbrance certificate.
I am not aware of it. I am only a tenant. I have been paying rents and I have paid 10 lakhs as security deposit.
Where is this property?
Not this property.
Tanisandra.
Tanisandra?
Yes, Your Honor.
Nagavara
village.
So let all these people be brought on record.
Please,
execution.
Let the execution court decide.
Sharif and what's his name? Afzal Khan. Ellarnu party madli.
Please, ma'am.
Let the trial court, executing court,
decide all questions.
Could the Afzal Khan the address idya?
Address.
Do you have his address?
No, I just have the encumbrance certificate. I don't think there is an address on it.
No.
Get his address also, mister.
But yeah, the agreement
will have to apply for certified copy of it.
No, get the address of this Afzal Khan also. So that everybody's
makes sense.
Case is considered. ಬಾಡಿಗೆ ಕೊಡ್ತಾ ಇದ್ದೀರಾ?
I am being paying to my landlord.
Please deposit the rent in the court.
Henceforth.
Whatever.
Your Honor, if I may ask, does that mean that the stay that is currently provided would be vacated and.
So the case will be sent back to the executing court.
Okay.
So that the court will decide
Take the
about the legality of the sale deed
Yes, Your Honor.
brought about in favor of Mr. M.R. Sharif.
Okay, Your Honor.
And the consequent sale in favor of Afzal Khan.
Okay, Your Honor.
So let the court decide the legality of all those documents.
Right, Your Honor.
So that your right is properly protected.
Thank you, Your Honor.
And you continue to deposit the rents before the court.
Please, my lord.
What is the rate?
15,000 per.
15,000 for 9,000 square feet.
Allah, because I have paid 10 lakhs as advance. It's a vacant site wherein I'm doing
Deposit
granite.
the monthly rent henceforth before the court.
Please.
Is there a market rate that we can ask for, Your Honor?
You can ask it later.
Sure, Your
Barkul. Can you close it?
Does this
Or you please get the details of this Afzal Khan also
Sure,
tomorrow.
I can, yes, Your Honor, I can get the sale deed.
This tomorrow.
Okay.
For dictation. Yes.
Serial number 10.
Thank you, Your
V.
Honor.
Shivkumar.
V.B. Shivkumar.
The bank had brought the property for
Waiting
auction
service of first time notice in respect of R4.
But
Notice
R4
arrived.
is served, my lord. Some advocate has filed wakalat, made
Yaru.
a verification.
Yeah.
Some Raghuram Reddy or somebody has filed it.
Note then R4 ಯಾರು ವಕಾಲತ್
ಹಾಕಿದ್ದಾರೆ. There is a representation of
Suit is
R4.
decreed or dismissed?
It is dismissed, suit is dismissed. But the only question that was raised was that the bank, which is the fifth respondent before the court, could not have taken a mortgage of the property on a life interest of the mother. And therefore the suit was questioned before the court. The surface proceedings were initiated. That question could not have been gone by the debt recovery tribunal. Now the property is brought for auction sale. Court does not go into that question and rejects the application under 7 to 11. Now the property is brought for sale.
Yeah, B.S. Karthikeyan.
Please, my lords. My lords. Also, my lords, the court has failed to, the bank has failed to observe. I'm for respondent 1 to 3, my lords.
Who appears for this Axis Finance Limited?
But notice has gone, my lord, they have to appear.
Service ಆಗ್ಬೇಕಲ್ವಾ? Service ಆಗದೆ ಹೆಂಗೆ?
I think they are served, my lord, and only thing
ನೋಡ್ರಿ
is
R5
it's to put
ವಕಾಲತ್
up.
ಹಾಕಿದಾರ. List after service of notice to the respondents 4 and 5.
There's some urgency, my lord, because
ಏನ್ ಮಾಡ್ತೀರಿ? ನೋಡ್ರಿ ಸರ್ವ್ ಆದ್ಮೇಲೆ ಮೂವ್ ಮಾಡಿ immediate.
Serial number 11. Harsha Kumar Gowda.
Serial number 9 ಅಲ್ಲಿ interim order granted as extended.
Serial number 11. Harsha Kumar Gowda.
My lord, file the better affidavit in support of the IA number 1 of 2025 for the condonation of the delay, my lord. The appellants are the defendants, my lord. The suit is ex parte decreed, my lord.
5,332 days.
Yes, my lord. The last week, my lord, the matter was heard.
Suit is for what?
Suit for specific performance, my lord. The
Ah.
suit is ex parte decreed, my lord. And I have challenged the ex parte decree under order 9 rule 13, my lord. It has been dismissed, my lord.
ಯಾವಾಗ 9 rule 13 ಯಾವಾಗ dismiss ಆಯ್ತು? ಅದೆಲ್ಲ ನೋಟ್ ಮಾಡ್ಕೊಳ್ಳಲ್ವಾ?
Yes, my lord. My lord.
Don't prepare notes, is it?
Sorry, my lord. My lord, on 24 to 2016, my lord.
ಡಿಕ್ರಿ ಆಗಿದೆ ಯಾವತ್ತು? ಸೂಟ್ ಡಿಕ್ರಿ ಆಗಿದೆ ಯಾವತ್ತು?
My lord, the suit is decreed on
27/2/2009.
and against which I have preferred the miscellaneous first appeal, my lord.
ಅದು ಯಾವತ್ತು?
That is dismissed on 4/3/2024, my lord.
4/3/24.
24, my lord.
What happened to MFA?
MFA is also dismissed, my lord.
Ah.
Against which the SLP was preferred before the Supreme Court, my lord. It has been dismissed on
So
third
therefore, we'll have to proceed on whatever evidence is available. We'll have to proceed on whatever evidence is available.
Yes, my lord. But my lord, one opportunity may be given, my lord.
Your 9 rule 13 is dismissed.
Yes, my lord.
MFA dismissed.
But my lord, that is
court
different
holding you
jurisdiction.
ex parte
Jurisdiction is different, my lord. jurisdiction is different, my lord.
You know,
That is the proceedings on the order 9 rule 13, my
you
lord.
have two remedies.
Yes, my lord. One to
There's an ex
file
parte decree, there are two remedies. One is file an appeal
and
or 9 rule 13. You have availed the remedy of 9 rule 13
but these two remedies are the two different forums, my lord.
in different forms, Sandra.
My lord, that
The
is
order placing you ex
my
parte
lord,
is upheld.
decree has not been challenged, my lord. I have sought only to set aside the ex parte decree,
Correct.
my lord. That has been dismissed, my lord. Now on the merit I am challenging, my lord.
So based on the evidence available on record,
Yes, ma'am.
we have to see whether the decree passed by the court is just or not. Aste.
Yes.
We cannot again give you one more opportunity. You fail there, you can't succeed here. If you fail in the 9 rule 13, you cannot succeed here.
Yes,
You have to succeed on the merits, on whatever evidence that you have adduced or they have adduced. Whether the evidence produced by the plaintiff, furnished adduced by the plaintiff is sufficient to grant a decree of specific performance. You have to justify that.
Yes.
Yes.
But the suit summons was served, but the two brothers, they are staying in the same house. And some suit summons was served on one Mr. Ramesh, but the second defendant.
Now we are not going into that question.
No, he appeared. And one of the defendants appeared before the brother appeared before the trial court, and his advocate filed a memo stating that he will also file wakalat on behalf of the first defendant. And they have not appeared thereafter. Then we let the evidence. We examined another witness. Two witnesses have been examined. Then trial court has decreed the suit. Thereafter, they filed a miscellaneous dismiss, appeal dismiss, and their ground is notice has not been served.
No, but then
both courts have held, this honorable court and the trial court has held that when both of you are staying in the same house, your brother has appeared, advocate has given a memo.
Shouldn't the decree be tested now on whatever evidence that is adduced?
Yes.
Shouldn't the decree be tested? I think placing them ex parte, now this court has confirmed it.
Yes.
So now they cannot again ask for one more opportunity.
Yes, right.
But the evidence adduced by you,
yes,
should it not be tested to justify whether it justifies a decree or not?
But the first thing is they have to overcome that delay part. Unless the delay is condoned, the question of considering the case on merits may not arise, is my respectful submission. Yes. Even otherwise, I would like to bring it to large kind notice. Even on merits, and agreement to say they have not.
And merits will consider later. Delay may lead.
The delay may 5,500 days delay is there, but they have two remedies as your lordship is already pointed, and simultaneous remedies also permitted. Sometimes what happens is they may not succeed in the merit, but they may succeed in the order 9 rule 13. They may having some reason for condoning there. Suppose if there is no reason to condone the delay, I mean the setting aside the ex parte, on merits also it can be considered, provided they avail both remedies simultaneously. That is how it is very.
How can they avail both remedies simultaneously?
What the Honorable Supreme Court has said.
No, please come to.
There is a,
no,
considering
they
the
can't avail
provision.
simultaneous remedy.
That is.
So they should file 96.
Kindly see this the judgment of the Honorable Supreme Court.
So 96 file ಮಾಡಬೇಕು order 9 rule 13 file ಮಾಡಬೇಕು ಅಂತ ನೀವು
ಮಾಡಬಹುದು ಯಾವಾಗ ಅಂದ್ರೆ suppose he is placed ex parte, only ground, that is the only ground for setting as an ex parte
please come to explanation to order 9 rule 13.
Explanation 1 and 2
ಓದ್ಬಿಡಿ
ಅದನ್ನೇ ಕನ್ಸಿಡರ್ ಮಾಡಿ
ಒಂದ್ಸತಿ ಓದ್ಬಿಡಿ explanation ಓದಿ.
Please take explanation 1. Provided that where the decree is of such a nature that it cannot be set aside as against such defendant only, it may be set aside as against all or any of the defendants also, provided that no court shall set aside the decree passed ex parte merely on the ground that there has been irregularity in service of summons, if it is satisfied that the defendant had notice of the date of hearing and had sufficient time to appear and answer the plaintiff's claim. explanation 2, where there has been an appeal against the decree passed ex parte under this rule, and the appeal has been disposed of on any ground other than that the ground that the appellant has withdrawn the appeal, no appeal shall lie under this rule for setting aside an ex parte decree.
So therefore,
This
appeal
is-
file
there are two things, my lord. One is, suppose a person file an appeal without going to Order 9 Rule 13, file an appeal, if he fails on merits, on merits if he fails, then there is no question of Order 9 Rule 13. Suppose Order 9 Rule 13 if he fails, and he has a remedy of the appeal also. I'm not saying that, but the question is, the limitation is, the reason is the Honorable Supreme Court has said, if you feel that you are not entitled to get a decree certified under Order 9 Rule 13, your remedy is also under Section 96. Therefore, simultaneously you file it. If you fail,
Simultaneously ಹೆಂಗ್ file ಮಾಡಕ್ಕಾಗುತ್ತೆ
that's
sir?
what the Honorable Supreme Court has said in that
No,
judgment.
let me, correct me if I'm wrong.
Yes.
When he files an appeal under 96,
Yes.
he'll be challenging the order placing him ex parte and also the decree.
Yes. And when that case, yes.
And also the decree.
That is then only one.
Only one. But if he files a 9 Rule 13, it is only the order placing him ex parte that will be looked into.
Yes.
Nothing more.
Correct.
Merits ಮೇಲೆ ಹೋಗೋದಿಲ್ಲ.
ಹೌದು ಹೋಗೋದು.
9 Rule 13 ನಲ್ಲಿ merits ಮೇಲೆ ಹೋಗಲ್ಲ.
Correct.
Only the order placing him ex parte will be looked into.
Correct.
That is all.
ಹೌದು.
So how do you say that after he loses 9 Rule 13, he cannot challenge it by way of an appeal
But then
on merits?
No, Lordship, may kindly see, it made it years and years. And delay.
The years and years,
No,
that's a
Lordship,
different-
that is also a point. Even for the condoning the delay and a particular, the right of the parties, there must be reasonableness. Here is the case, Lordship, may kindly see, when the decree, it is not as if in this particular case, general thing is little different, but in this particular case, brother appeared, engaged an advocate, and he has filed a memo before the trial court saying that I will appear for another
ಆಯ್ತು,
party
9 Rule
also.
13 ಅದಕ್ಕೆ dismiss ಆಯ್ತು.
Dismiss ಮಾಡಿದ್ರು.
9 Rule 13 ಅದಕ್ಕೆ dismiss. Merits ಮೇಲೆ ಯಾಕೆ challenge
Merit ಮೇಲೆ, my lord, the question is, we have already filed, the trial court has given finding on merits also. We have examined, trial court has declared the suit, and that has not been, then one more thing, Lordship, can you see, when a person appeared and abandoned the suit, he is not entitled for setting aside the ex parte. For years together, he appeared, he not pursued the matter, and there is no ground also, my lord, to, what is the ground he has made out before the trial? The only thing is, no notice has been served.
Yes.
And that for 347 days delay is also there, even otherwise, after passing of the order passed by the Honorable Supreme Court.
Supreme Court order ಯಾವತ್ತು? 3/1/25.
3/1/25, my lords.
Nine Rule 13 was filed within limitation.
ಅದು ಇಲ್ಲ.
ಅದು ಕಂಡೋನ್ ಆಗಿದೆ. ಮತ್ತೆ
9 Rule 13 ಡಿಲೇ, ಇಬ್ರು ಅಪಿಯರ್ ಆಗಿದ್ರು, ಮತ್ತೊಬ್ಬ ಅಪಿಯರೇ ಆಗಲಿಲ್ಲ, and he filed a suit for partition, that has also been dismissed. But there is no justification to condone the delay. Is there my respectful submission?
Here 1 of 25 is filed for condonation of delay of 5332 days in filing this appeal.
Supreme Court decision. But in the identical matter, my lord, there is
It
a
is-
sufficient cause.
It
The
is
delay may be condoned.
stated in the affidavit accompanying the application that the suit summons was not served on the appellant, on the deceased appellant. So it's not served on the defendant number 1, Cheluvaraju.
Oh, Cheluvaraju, defendant
number 1 was not served on the defendant number 1, comma, deceased appellant herein. Full stop. It is claimed that the LRs of the deceased defendant number 1 came to know of the decree passed in the suit on 10/7/2010, and immediately thereafter they filed a miscellaneous petition under Order 9, Rule 13 to set aside the ex parte decree. Full stop. However, the said miscellaneous petition was dismissed on 24/2/2016. Full stop. Ado kelsa ಮಾಡಿ. The LRs are filed ಅಂತ ಹೇಳ್ಬಿಡಿ. The deceased defendant number 1 filed miscellaneous so and so, which was dismissed on 24/2/2016. During the pendency of the miscellaneous proceedings, the defendant number 1 died. Full stop. Later, the order passed in miscellaneous petition 77/2010 was challenged before this court in MFA 7688 of 2016, which was also dismissed on 4/3/2024. A special leave petition bracket civil 266 of 2025 was filed challenging the aforesaid orders, which too came to be dismissed on 3/1/2025. The appellants therefore contend that from 27/2/2009 till 3/1/2025, they were pursuing the proceedings before the various courts for setting aside the ex parte decree granted in OS number so and so. OS number 150 of 2007. Full stop. It is claimed that after the dismissal of the SLP, the appellants could not file the appeal in time, as the appellant number 1 is appellant number 1 being a widow was facing financial difficulties. Full stop.
They filed a suit for partition also.
Really, ಅದೆಲ್ಲ ಮಾಡ್ತಾರೆ ಏನ್ ಮಾಡಕ್ಕೆ? These are all natural.
ಅಲ್ಲ ಕರೆಕ್ಟ್.
Better affidavit ಇಲ್ರಿ ಇದೆ. Where is your better affidavit?
We have a 200% case, therefore the case for continuation.
ಎಲ್ಲಿದೆ ಅದು better?
On 24/3 it has been filed.
And if a further affidavit is filed by the appellant number 1 stating that stating that ಇದು 811 ಏನಿದು?
That is the suit for partition, my lord.
You got a son?
Yes, my lord.
You got a suit for partition filed through your son?
Yes, my lord. That has, after dismissal of the SLP, my lord, they have filed the rejection of plaint, my lord.
So she contends that during the pendency of the proceedings before this court, before the in miscellaneous number so and so, a suit in OS number 811/2024 was filed for partition, filed by her son for partition.
Her son and also the son of other person who was placed ex parte, both.
And the son of the other brother.
Yes. Daughter, not a son, daughter.
Daughter
of the first
other brother. ಅದೇನೇ suit ಅದು?
Same suit, my lord.
It is still pending.
Plaint rejected, yes.
Plaint is rejected. Huh?
Plaint rejected.
In which, the respondent herein filed an application for rejection of the plaint, consequent to which, the trial court, after hearing the parties, dismissed the suit, rejected the plaint on 2/12/2025. Full stop. The appellant has claimed that she thereafter consulted an advocate who advised her to file a regular first appeal. Full stop. It is therefore contended that there is a delay of 5332 days in filing this appeal, which was due to a bona fide reason and not intentional. Full stop. This application is opposed by the respondents. Objection hakidire?
Yes, my lord.
Objections by the respondents, where they contend that where he has contended that where he has admitted that after a decree in OS number 150 of 2007, a miscellaneous petition under Order 9 Rule 13 of CPC was filed in miscellaneous 77 of 2012, which was dismissed on 26/2/2016 and was confirmed by this court in MFA 7688 of 2016 on 4/3/2024 and by the Honorable Supreme Court on 3/1/2025. It is therefore contended that the appellants have no right to file an appeal challenging the judgment and decree under section 96 of CPC. It is therefore claimed that the appeal is not maintainable and is liable to be dismissed. Now, why do you keep on repeating the same thing again and again and again and again? Miscellaneous hakadru, miscellaneous hakadru, miscellaneous hakadru, MFA hakadru, MFA hakadru. Why do you repeat? One sati helu saakalla.
One sentence.
How many times you mention the same thing? It is also admitted that a suit in OS number 811/2024 was filed for partition separate possession and that the plaintiff in the said suit was rejected.
Rejected ಅಲ್ಲ ಸಾರಿ.
Rejected,
Dismissed. ನಾನು ಅದು ಬೇರೆ ಇದ್ರ ನೋಡಿದೆ. Dismissed.
7 Rule 11 ಹಾಕಿದ್ದೀರಾ ಅಂತ ಹೇಳ್ತಿದ್ದಾರಾ?
ಹೌದಲ್ಲ 7 ರೂಲ್ ಇದರಲ್ಲಿ ಡಿಗ್ರಿ ಕಾಪಿನ ಹಾಕಿದ್ದಾರೆ. ಆರ್ಡರ್ 7 ರೂಲ್ ಇದ್ರದ್ದು ಪೇಜ್ ಅನಕ್ಷರ R5 ಪೇಜ್ 44.
And the suit was dismissed, rejected, but the suit was dismissed. Today order dated 2/12/2025. It is contended that the respondent has filed an execution petition 138 of 2024 where the appellants have entered appearance. Therefore, it is contended that the appellants are unduly delaying the fruits of the decree to the respondent by filing one or the other petition, and that the reason for condonation of delay is not satisfactory. Full stop. The learned senior counsel for the respondent, reiterated the above submissions and submitted that the appellants were bound to file an appeal soon after the decree was passed, while they were pursuing the petition under 9 Rule 13. Full stop. He contends that this is the position of law reiterated by the Honorable Supreme Court in Banu Kumar Jain versus Archana Kumar and another 2005 Part 1 SEC 787. He therefore contends that the appellants were bound to file the appeal within the time stipulated and cannot renew their request for challenging the judgment and decree passed by the trial court by filing an appeal under section 96 of the Code of Civil Procedure. Full stop. He therefore submits that the cause shown for condonation of an enormous delay of 5332 days is not satisfactory and not justified, and hence the same is liable to be rejected. Next, I consider submissions
even
of
after the Supreme Court order that there are 347 days, even according to them.
He submits that even after the judgment of the Supreme Court, the appellants have not filed the appeal in time, and that from that day till the date the appeal was filed, there was a delay of 347 days, which was neither explained by acceptable reason. Full stop. I consider submissions of the learned counsel for the appellant and the learned senior counsel for the respondent. Next para. It is not in dispute that the suit filed by the respondent for specific performance in OS number 150 of 2007 was decreed ex parte on 27 to
On 27
2009.
to 2009.
27 to 2009. Full stop. The deceased defendant number 1 filed a petition under Order 9 Rule 13 to set aside the ex parte decree in miscellaneous 77,
77 of 2010.
in miscellaneous 77 of 2010, which was dismissed with a order dated 24 to 2016. During the pendency of this proceeding, the defendant number 1 died. Thereafter, MFA number so and so was filed.
7688 of 2016.
7688 of 2016 was filed, which was dismissed on 4/3/2024.
Yes.
A special leave petition was filed there against, which was dismissed on 3/1/2025. Therefore, between 27 to 2009 till 3/1/2025, the appellants were pursuing the remedy under Order 9 Rule 13 of CPC. Full stop. When suit is decreed ex parte, the defendants have two remedies, namely to file an appeal under Section 96 of CPC or file a petition under Order 9 Rule 13 to set aside the order placing them ex parte. Full stop. If a defendant files an appeal under Section 96 of CPC, he would not be entitled to, and if the appeal is decided on merits, he would not be entitled to file an application under Order 9 Rule 13 of CPC. Full stop. The explanation to Section Order 9 Rule 13 of CPC is relevant and the same is extracted below. Full stop. Therefore, the defendant number 1, having lost the proceedings under Order 9 Rule 13, cannot now contend that the order placing him ex parte was without any basis. However, he is not deprived of the right to challenge the judgment and decree passed by the trial court under 96 of CPC based on the oral and documentary evidence produced by the plaintiff/respondent herein. Full stop. Since the appellant was pursuing the remedy under Order 9 Rule 13 from 27 to 2009 till 3/1/2025, the appellants could not have filed an appeal under Section 96 of CPC. Full stop. It also appears that a suit in OS number 811/2024 was filed for partition, and that the said suit was dismissed on
2/12/2025.
2/12/2025. Full stop. This appeal is filed on
16/12/2025.
Therefore, the contention of the appellants that they could not file the appeal in time, as they were under the bona fide impression that the suit filed for partition would be favorably considered, cannot be disbelieved. In that way of the matter, this court is of the opinion that the delay caused in filing the appeal deserves to be condoned and an opportunity deserves to be granted to the appellants to contest this appeal based on the oral and documentary evidence adduced by the respondent before the trial court. List for admission on?
Immediate. Next week.
Take whatever date you want.
Second April.
Third, fourth.
Hence, IA 125 is allowed.
2nd
25 is allowed.
Third, fourth.
Take whatever date you want.
3/4 Raja.
Second week of April.
2nd April.
Second,
12, Sachin BS.
Take whatever date you want.
Interim order.
Any Thursday, Friday, any
interim order.
Thursday, Friday.
Interim order may be extended.
Please don't execute the order. Execution ಹಾಕಿದಿರಲ್ಲ.
Correct. Delay ಇವತ್ತು ಕಂಡೋನ್ ಆಗಿದೆ.
Till the next date of hearing, the respondent is directed not to precipitate the matter before the executing court.
8th or 9th April. 8th or 9th April.
List on so and so. Yes, next.
Much of.
Sachin BS, list after service of notice to respondents 1 to 13.
Service has been issued to respondent number 10 to 13, my lords.
What about 1 to 10, 1 to 9?
They have not been served yet.
Let
But,
notice be
the-
served.
The contesting parties
Yes,
are 10 to
madam,
13.
whom do you represent?
10 to 13.
What's your name?
My lords, I appear on behalf of H. Pavan Chandra Shetty.
Mr. H. Pawan Chandra Shetty undertakes, has appeared for
10 to
respondents
13.
10 to 13. Officers directed to show his name in the cause list. List after service of
Well,
notice to respondent 1 to 9.
Contesting parties are 10 to 13. The
Notice.
date may be fixed. In
Learned
first
counsel for the appellant submits that the contesting parties are 10 to 13 and therefore the appeal may be taken up for consideration of interim prayer.
Please, my lords.
Hence list on?
For TIA. On
List on date could.
April 1st week.
Yes.
10th April. For hearing in I, serial number 30. Yes, Kalyan Basuraj.
200 days delay, my lords. This was a decree passed immediately around the time of pandemic. One of the cross of PW1 was closed on 16.
IA 1 of 23 is filed for continuation of delay of 200 days in filing the appeal. It is stated in the affidavit.
I'll furnish it, my lords.
It is stated in the affidavit accompanying the application that due to COVID-19 pandemic, the appellant could not come over to Bangalore to subject himself for cross-examination. Full stop. He filed an application to recall him for cross-examination and also to produce a cross-examination in chief andre enridu.
I think that's a type of cross-examination and further chief also to mark documents.
Cross-examination in chief andre.
I think that's a type of, apologies, my lords.
For cross-examination and also to produce several documents. However, since he was stationed in Kerala, he could not come over to Bangalore and appear for cross-examination. As a result, the court closed his side and posted the matter for arguments and then passed a judgment on 16/4/2022. Full stop. It is therefore claimed that the reason for not appearing before the court is beyond the control of the appellant, and hence the appellant prays for an opportunity to contest the suit on merits. The learned counsel for the respondent does not seriously oppose his application for continuation of delay. In that view of the matter, this application is allowed and the delay of 200 days in filing the appeal is condoned. Can we allow this appeal?
I may not have any objection, but let me
list down so-and-so for objection.
The first week of April, my lords, I will furnish the copy on my learned
down so-and-so for admission. Yes.
Remand ಆಗ್ಬೇಕು ಅದಕ್ಕೆ.
2nd April.
Nanda Kishore.
Nanda Kishore.
Additional documents.
For the appellants, my lords.
IA 1 of 25 shall be
In this matter,
considered
the
along with
appellant
main
has
appeal.
passed away, my lords.
IA 1 of 25 will be considered along with the main appeal. What is Commissioner?
It may be considered along with the main.
They have not served the copy.
We'll serve the copy, my lords. Appellant has passed away. We'll file LR's application.
Why don't you serve a copy? Why
We'll
do
serve the
you
copy.
file it without service?
I will verify and I will serve the copy.
A 2 of 25 shall also be considered along with the main appeal. Yes.
But interim order may be extended.
Interim order
Last
granted
time
is extended to the next date.
Last time expire ಆಗಿತ್ತು.
I think admit ಆಗಿದೆಯಲ್ಲ.
Serial number 15.
Grateful,
Manjunath H.
Manjunath H.
Lords, I appear for the respondent number
Appellant's
7. My lords,
4 to 4-5 days.
Please.
My lords, I appear for respondent number 7. My name was not reflected in the cause list. Short accommodation may be given, my lords.
What is your name?
Angad Kamath.
Angad Kamath.
I filed NOC Wakalat, my lords.
Barkul. Office is directed to show the name of Mr. Angad Kamath as the counsel for respondent number 7 after deleting the name of Mr. Bipin Hegde.
Mr. KBS Manian, my lords. Mr. KBS Manian.
After deleting the name of Mr. Bipin Hegde, Girish R and Mr. KBS Manian. List on so for objections to IA.
They've already filed.
They already filed.
They've already filed.
List on so Tamari.
Sometime next week.
Take whatever it is. Any Thursday, Friday, you can take.
Next Thursday, if it's
Next Thursday.
Very well.
Next Thursday.
Obliged.
Jairaj DS.
Serial number 16.
My apologies, my lord.
Jairaj DS.
ಇದರಲ್ಲಿ ನಾನು ರೆಸ್ಪಾಂಡ್ ನಂಬರ್ 1 to 3 ಮಾತ್ರ ಅಪಿಯರ್ ಆಗ್ತೀನಿ ಯಾಕಂದ್ರೆ
it's a collusive decree, though, suit between plaintiff and the defendant number 4. Adike notice may have to go to respondent number 4. Madam.
Issue notice, the learned counsel for the respondent number, learned counsel, Mr. N. Dinesh Rao submits that yes, he would appear for only respondents 1 to 3 and not for respondent number 4. Hence, issue notice on IA 1/24 as well as on the main appeal to the respondent number 4.
Copy innu kottilla tavu direction kotru.
I'll serve a copy. Notice was issued, my lord, but I'll serve a copy.
Serial number 17, Kumar M, Gopi GA.
Appeal for the appellant. There's a delay of about 265 days in filing this.
Ganapati, but yes, have you?
Application has been filed, my lords.
Statement is filed.
Pardon,
Have you
my
filed the statement? Written statement hakidira.
Written statement to hakidare. 2 documents were also marked, Exhibit D1 and D2. Exhibit D1 being the final notification and D2 being the order passed. The writ petition where, my lords, the proceedings for eviction or removal of encroachment, that filed writ petition, my lords, that came to be allowed, directing them to participate.
Did not
in the
lead any evidence.
My lords, the evidence that was led, my lords, has been struck off, holding that, my lords, the defendant's witness, my lords, did not subject herself for cross-examination. But the documents that were produced, my lords, was considered by the trial court. In
But
fact, my
why
lords,
did you
para
not-
number
Why
14.
did you not make yourself available for cross-examination?
I'm unable to make that submission, my lords. But what the trial court notes, my lords, at para 14 page, internal page 11, my lords, the court considers Exhibit D1. My lords, court says.
What is the ground for delay?
My lords, delay has been mainly, my lords.
Therefore, respondent number 1, file objection to delay application.
In 2023 appeal idu.
2 days time may be granted.
2 days alla kododilla. ಬಂದಿತ್ತಾ ಹಿಂದೆ?
ಹೌದು. I also.
6-3 ಬಂದಿತ್ತು. Learned counsel for the respondent seeks time as a last chance list on so and so. ನೀವು ಯಾರಿಗೆ respondent number 1 ga?
Respondent number 1.
List on so and so.
9th April.
Seeks time to file objections to IA 1/23 list on so and so.
Serial number 18, Ajit PB.
PB Ajit.
For the appellant.
You have no objection. Obviously, you're sailing with him.
I'm not saying I'm only a formal party.
Yes, Ajit.
My lord, so the respondents have filed application for early hearing. I have no objection.
IA 1/26 is filed for early hearing since the appeal is filed in the year 2024.
If I may make a
Comma,
submission, my lord.
and older matters are awaiting consideration. IA 1/26 is rejected.
Just one proposal, my lord. They filed a suit for bare injunction. The trial court has held that it's not maintainable. They ought to have filed a suit for declaration. Now this appeal will stay pending for quite a considerable amount of time, and then thereafter they'll anyway have to.
Madam, we have to decide the matter on merits. We'll have to hear it. This is a 2024 appeal. There are older appeals. We should stand in the queue. Who has filed this IA?
They have
The IA
respondent.
has not been allowed.
We are rejecting it.
The
Yes, next.
early hearing has been filed by.
Number 19.
IA is rejected, madam. Let it come in seniority. Ramesh KR.
I appeal for the appellant in this
Same
matter.
order, same order.
Manoj, one submission, Manoj. Manoj, this appeal is arising out of a suit filed by us, Manoj, seeking declaration of title.
Early hearing again early, first two.
Manoj, they have filed one more suit. Before the trial court, it is set down for cross-examination of PW1. Manoj, since they may take advantage of this dismissal of the suit filed by us, Manoj. In fact, Manoj, in this suit, the society had executed.
Can you file an application for stay of proceedings in that suit? I'll suit ಕೇಳ್ಕೊಳ್ಳಿ, stay ಕೇಳಿ ಇಲ್ಲಿ.
With that liberty, I am.
ಅರೆ ನಾನು ಯಾಕೆ liberty ಕೊಡು? CPC gives you liberty.
I have, in lieu of that, Manoj, they have.
IA, same order. Yes, next.
At least liberty may be granted, Manoj. Otherwise, by virtue of this order, Manoj, they will dismiss this application to be filed.
You know the contours of section 10. 10 application haki. Rejected.
Since we have taken that contention, Manoj, your lordship may kindly observe that liberty.
No. Yes, next.
Number 20.
Well, appealing for the petitioners, implementing applicants counsel. Well, we are the principal employer, the suit for injunction for on transfer we have not been implemented. And in the MFA, we were implemented as a party. Then matter went to Supreme Court. Supreme Court now says the matter is disposed of. The decree is passed. Therefore, you implicate yourself in the RFA. Therefore, I filed an application for implicating myself. I am the principal employer. I am required to be heard in the matter.
Yes, any objection?
My lord, this appeal itself is actually infructuous. What has happened after this? The crux of the matter is this, my lords. There was the respondent is a plaintiff. They were employed by Bosch, which is the impleading applicant.
This application, IA 2 of 24 is filed by Bosch, is it?
Yes,
Yes,
we are employed by Bosch.
We are the
A dispute had been raised. A dispute had been raised by the workmen in regard to their regularization and their permanent status. The Labour Court found, my lords, that they are the permanent workmen of Bosch, and the contract is a sham. Then it was challenged before the Honourable High Court. In writ petition also, the petition filed by Bosch was rejected. In the meanwhile, the appellant, who is a defendant in the trial court, who is said to be a contractor, he issued an order of transfer to the workmen. That was challenged before the civil court, saying that there is no relationship between the appellant and between the plaintiff and the defendant, and that suit has been decreed. Now, my lord, the writ appeal against the order of the writ petition was pending. Now, even the writ appeal filed by Bosch has been dismissed, and it has been held that the workers are the employees of Bosch.
Yes, sir. Is that a fact?
That's a fact. The Supreme Court has
Then
now
how
made
you-
an order in that MFAs against which SLPs were filed that I can seek for impeachment in the regular suit.
Right, whether in the SLP, whether it was brought to the notice of the Supreme Court that in the writ petition, there's a finding that they are
Yes,
employees
yes,
of.
yes. Yes, their lordships have been told. I
Only
appeared
the-
myself.
So where do we get that?
Their lordships have said, now your lordship let consider this application for impleadment on merits. My submission is that we are the
No, if
principal
there's
employer.
if there's already a finding that you are not the principal employer and this.
No, I am the principal
respondent-
employer.
No, they are the employer.
They are the employees of the
The finding is
contractor.
Bosch is the employer.
Now,
The finding
I
is
become the
Bosch is my
employer.
employer.
I am interested in the suit for injunction, which is without jurisdiction in the civil court.
The
Yes,
finding
please wait. Please wait. Mr. Kasturi, please wait. Yes.
The finding is that Bosch is the employer. The appellant, who is a defendant in the suit, is not my employer.
Yes.
This suit is limited to the extent that the appellant issued a notice transferring me to another place. Our contention was when Bosch is the employer, some third person cannot issue this notice to us
No, but
transferring
just
us.
now you said there's a finding that Bosch is not the
No,
employer.
my lord. Bosch is the employer. Bosch is the employer. The suit itself, the appeal itself becomes infructuous.
Yes.
Because now the writ appeal filed by Bosch, where they had challenged the finding that they are the employer, that has been dismissed. Bosch is the employer is the finding. They have
So
filed an
therefore,
SLP
they-
before.
so therefore Bosch cannot come in this appeal.
My only submission is this appeal itself becomes infructuous.
Yes.
In fact, my lord, 3 other appeals in respect of 3 other workmen had
But
been
the
filed.
Supreme Court order
They have
will
withdrawn
not
those
be-
appeals.
Please wait, Mr. Kasturi. Don't.
In similar circumstances, 3 other appeals, RFAs had been filed against 3 other workmen
In
similarly
that writ
situated.
appeal, this unique detectives and the
Not a
security,
party.
they're not parties.
They are not a party.
Then
Only Bosch is the party. That's the reason, my lord.
how do you say that the appeal is not maintainable?
Appeal is becomes infructuous because the unique
Unique
detective.
is not a party to that.
They're not, my lord, but what was challenged before the trial court was a notice of transfer issued by Unique to us. When there is a specific finding that Bosch is my employer, the only person who can transfer me is Bosch. No other person can
Yes.
transfer me.
Yes.
In 3 other similar appeals where similar transfer orders had been issued, the suit had been decreed. Unique had filed an appeal in those matters. Those matters have also been withdrawn by them actually, stating that
Is that
those
a
matters
fact?
are
You will
infructuous.
seek instruction, my lord, 2 weeks time may be granted.
2 weeks alla kodadilla.
Week time may be granted. 1 week.
Lord, I will submit one thing, Lord.
Yes, sir.
Lord, it is true, whatever my learned friend says that my writ appeal has been dismissed, matter is pending in Supreme Court in SLP. They have ordered for mediation. Mediation also failed. Yesterday, the matter came up before Supreme Court. There was some problem with the video, therefore they adjourned by 2 weeks. then the matter has been, we have said we are willing to discuss and settle these matters. My submission to your lordship is, even assuming that I am the employer, when the order of transfer has been signed by the contractor and the principal employer to my own establishment as a principal employer, I am concerned in the dispute with regard to transfer. They don't
But then
impede me.
you have not, no, but then you have not issued the order of transfer.
Well, I have also signed it. I have also signed it. He has obeyed the order of transfer. We gave an undertaking.
Transfer
to
order,
Supreme Court
Bosch
before
and
Justice
the
Paul.
appellant and the
No.
He
the
gave an
suit is
undertaking before
decreed-
Justice Paul that he will go and report. He reported.
Correct. Suit is decreed on the premise that the unique is not the employer.
Correct. Correct.
If that is the case, unless Bosch has issued an order of transfer, how can
We
Bosch
have
challenge
also
the
signed
decree?
it. Milord, we are also concerned because he is being posted to my own establishment as a principal employer.
Correct.
I need him there. I am also concerned in the dispute.
Yes. No, if you
Between
have
the-
issued an order of transfer, you are justified in challenging it.
The Bosch also signed in the transfer order, my lord.
That is not
Both
the
have
issue.
signed.
Issue ಮಾಡಿದ್ಯಾರು?
Issue ಮಾಡಿದ್ದು
Both of them have,
unique issue ಮಾಡಿದ್ದು.
both of them have signed.
Yes.
Issued,
Yes, my lord.
it is issued by unique. The order is issued
In
by
fact,
unique.
the latest order of the Supreme Court says,
Signed by what they
your
say is the
lordship may
boss.
consider
But
my
in any
implementing
event, my lord, when
application.
the appeal itself is infructuous. In 3 other similar matters, they withdrew the appeal saying that it is infructuous.
ಆಯ್ತು. In the order of transfer, was there any reference about this principal employer?
My lord, what
Yes.
the order of
Signed.
transfer is, I'll just submit. It is issued by unique. It is signed by unique, and it is also signed by by a Bosch, by somebody from Bosch. There is a signature of them.
So therefore, they are not. Are they not intended?
No, they didn't come before the trial court.
Yes.
This is an
No, no.
ultimately we are in appeal.
We are not parties.
They didn't come to the
Make
trial court.
parties.
I think get instructions whether you want to pursue this appeal or not.
Please.
To learn counsel for the appellant seeks time. I learn counsel for the respondent submits that similar appeals filed by the appellant were withdrawn. Also, learn counsel for the appellant seeks time to secure instructions. List
Serial
down
number
counsel.
21 also
Well,
same
22.
matter. 22,
Well,
22, my lord.
22 is similar.
22 also says.
The MFA, they are implemented as a party, or respondent to implemented as a party. So we can see the MFA.
ಆಯ್ತು ಆಯ್ತು ನೋಡೋಣ ಅವತ್ತು ಬನ್ನಿ ಅವತ್ತು. Yes, list.
22 is also similar.
20, 21, 22 same.
21, 22. Only 20 and
20 and 22 also.
20 and 20, 21?
21 not.
That's another.
Yes, 21.
22 is also same.
Number 21.
Only 2 weeks time may be granted to
For
file
what?
paper book. To file paper book.
2 weeks time is granted to file paper books. ಎಷ್ಟಿದೆ exhibits?
56 ಇದೆ sir.
56.
ಹೌದು.
2 weeks time is granted to file the paper books.
Trust.
Number 22, urgent serial number 3.
Appear for the appellant in this case, my lord. Appellant. So me 2 days.
Appellant
delay.
should stand this side.
2 days delay ಇದೆ ಸ್ವಾಮಿ ಇದರಲ್ಲಿ.
Notice ಹೋಗಿದ್ಯಾ?
ಇಲ್ಲ ಸ್ನೇಲ್.
Issue notice on IA 1 of 26 as well as in the main appeal. Issue emergent notice on IA as well as the main appeal. Sriram Babu.
24.
Yes, my lord.
Sriram Babu.
I'm appellant in this case, my lord.
Shiv
For
Shankar.
the respondent. There is objections with regard to delay is concerned. That's 441 days, there is a delay. That's,
Objection ಹಾಕಿದಿರಾ?
we'll file objections. ಆಗ್ತೀನಿ objections.
ಎಷ್ಟು ವರ್ಷ ಟೈಮ್ ಬೇಕು ನಿಮಗೆ?
411 days delay ಇದೆ. ಮೆಡಿಕಲ್ ಸರ್ಟಿಫಿಕೇಟ್ ಕೊಟ್ಟಿದ್ದೀನಿ ಸ್ವಾಮಿ. ಸ್ಟ್ರೋಕ್ ಆಗಿದೆ ಮತ್ತೆ ಕೋವಿಡ್ ಇತ್ತು ಅಂತ.
Then is COVID floods. The decree came to be passed in the month of floods, March 2023. That's there is no COVID even after.
ಸ್ಟ್ರೋಕ್ ಆಗಿತ್ತು ಆಮೇಲೆ
Date of the
ಸ್ಟ್ರೋಕ್
decree and subsequent.
ಕರೆಕ್ಟ್ ಅವ್ರೇನು ಪ್ಯಾರಾಲಿಸಿಸ್ ಏನೋ ಆಗಿತ್ತು?
44 ಪೇಜ್ ನಂಬರ್ 44 ಮೆಡಿಕಲ್ ಸರ್ಟಿಫಿಕೇಟ್ ಕೊಟ್ಟಿದ್ದೀನಿ ಸರ್. ಸೂಪರ್ ಸ್ಪೆಷಲಿಸ್ಟ್ ಡಾಕ್ಟರ್
Suit
ಕೊಟ್ಟಿದ್ದಾರೆ.
was pending. I can understand the parties not keeping.
ಕರೆಕ್ಟ್ ರೀ, ಸ್ಟ್ರೋಕ್ ಆಯ್ತು ಅಂತ ಹೇಳ್ತಿದ್ದಾರೆ. He couldn't come because of COVID, stroke and all
ಅನ್ಎಜುಕೇಟೆಡ್ ಅಂದ್ರೆ ಇಲಿಟ್ರೇಟ್ ಇದೆಲ್ಲ ಪ್ರಾಬ್ಲಮ್ ಇದೆ. ಅದಕ್ಕೆ ಡಿಲೇ ಆಯ್ತು. ಮೆರಿಟ್ ಮೇಲೆ ಹೋಗ್ತೀನಿ ಸ್ವಾಮಿ. ಡಿಲೇ ಕಂಡೋನ್ ಆಗಲಿ.
medical certificate 44
COVID
page number.
pneumonia in August 2022. She has been diagnosed as stroke with CVT superior sagittal
Manipal
sinus,
hospital Kottayam
right
also.
percentile.
Genuine reason, some
Acute
medical
central
reason.
seizures, recent COVID, LRT, diabetes.
She is uneducated and also. ದಯವಿಟ್ಟು ಕಂಡೋಲ್ ಮಾಡಿ ಸ್ವಾಮಿ ಮೆರಿಟ್ ಮೇಲೆ ಹೋಗ್ತೀವಿ
5824. ಕಂಡೋಲ್ ಮಾಡ್ಬೋದಾ?
ಇಲ್ಲ ಸ್ವಾಮಿ ಟೈಮ್
ಶಿವಶಂಕರ್ ಬಿಡ್ರಿ.
ಅಲ್ಲ ಮೆರಿಟ್ ಮೇಲೆ ಹೋಗ್ಬಿಡಲ್ಲ ಮೆರಿಟ್ ಅಲ್ಲ ಡಿಲೇ ಕಂಟ್ರೋಲ್ ಮೆರಿಟ್ ಮೇಲೆ ಫೈಟ್ ಮಾಡೋಣ ಸರ್.
41 days delay. I can understand when 30 days, 40 days or 50 days.
ಕಂಡೋಲ್ ಮಾಡ್ಬೋದಾ ಅಂತ ಕೇಳ್ತೀನಿ, ನೀವು ಕೇಳ್ತಿದ್ದೀರಾ ಅವ್ರನ್ನ.
ಮಾಡ್ಬೋದಾ? ಆಯ್ತು ಓಕೆ ಸರ್.
If you want to plead, you can plead with him. ಇನ್ ಸ್ವಲ್ಪ ಕೇಳಿ. Please request him.
ನಾನು ನಿಮಗೆ ರಿಕ್ವೆಸ್ಟ್ ಮಾಡ್ಕೊಂತ ಇದ್ದೆ.
ರಿಕ್ವೆಸ್ಟ್ ಮಾಡಿ ಸರ್. Please request him. A lawyer should know when to stop. I am saying we'll condone it and ತಿರ್ಗಾ ನೀವು ಮಾಡಿ. ಬರ್ಕೊಳ್ಳಿ ಏನಪ್ಪ IA 1 of 24 is filed by the appellant for continuation of delay of 441 days in filing the appeal. It is stated that the appellant is illiterate, and belongs to socially, economically backward community. ಎಲ್ಲಿ ಹೇಳಿದ್ರ ನೀವು ಹುಷಾರಿಲ್ಲ ಆಸ್ಪತ್ರೆ ಅಂತೆಲ್ಲ?
Due to COVID stroke, I am in bedridden.
She contends that she has contended that due to COVID-19, due to COVID pneumonia during August 2022, she was bedridden and she suffered a stroke. As a result, she could not defendant iವರು
also
he could not contest the suit. Full stop. Contest a suit and also file an appeal in time. So this application is not opposed by the respondents. A perusal of the medical certificate enclosed along with the application would disclose that the appellant was treated at Manipal hospitals for COVID pneumonia with LRTI in August 2022, and she was diagnosed with stroke with CVT superior sagittal sinus, right transverse and sigmoid sinus with right temporal non-hemorrhagic venous infract. Full stop. It is also stated that the appellant was under treatment with supportive measures till 5th of August 2024. This appeal is filed on 12/8/2024 and therefore this court is of the opinion that the appellant could not file the appeal due to reason beyond her control. Consequently, the delay of 441 days in filing the appeal deserves to be condoned and accordingly IA 1 of 24 is allowed and the delay of 441 days in filing the appeal is condoned. List for admission on date for
stay may be extended, my lord. Stay. They are filed the execution petition there. Stay may be extended.
In injunction suit idu?
Yes, it's injunction suit.
Interim stay of the interim order granted on so and so is extended till the next date. List for admission on so and so. Yes, Nayak Venkatraman Nagappa. To notice on IA 1 of 25 as well as in the main appeal. Chaitanya.
26, Chaitanya SG.
My lord, I am appealing to the appellant.
Yes, issue notice on IA 1 of 25 as well as in the main appeal to the other respondents.
I'll serve a copy, my lord.
Number 27,
Chaitanya, same order.
Yes.
Operate defendant note either. How many respondents are there?
Yes. Obre, sir. Only one, sir.
Chaitanya.
Only one. Yes, my lord.
ಇದರಲ್ಲಿ 26 ಅಲ್ಲೂ ಒಬ್ರೇನಾ?
ಹೌದು ಸರ್, ಎಲ್ಲದರಲ್ಲೂ ಒಂದೇ. ಒಬ್ರೇ ಇದೆ ಸರ್.
26 ಅಲ್ಲಿ ನೋಡ್ರಿ ಎಷ್ಟು ಜನ ಇದ್ದಾರೆ?
ಒಬ್ರೇ ಸರ್. only one respondent.
ಹಂಗಿದ್ರೆ RFA ನಲ್ಲಿ 26 ಅಲ್ಲಿ IA 125 is filed for contention delay of 4 days in filing the appeal. The cause shown for the appeal, full stop. The respondent has not objected this application. The cause shown for the for condoning the delay is produced, and this court is satisfied that the appellant could not file the appeal within time due to a reason beyond its control. Consequently, IA 125 is allowed, and the delay of 4 days in filing the appeal is condoned. Same order in serial number 2728. Great for admission on so on so. Janardhan G.
Great. 10th April.
I want to implead that, but BDA.
29.
I'm for respondent, my lord.
They are impleading.
Implead to BDA also, my lord, because BDA, I sought for impleadment of BDA. And reason is that like injunction.
My lords, I am opposing for implement of BDA, my lords.
That I am noticing first time it has come before the court. That I am submitting to the court and.
File a fresh suit if that is the case.
That suit for injunction. But what happened is I purchased the property from the owner's share, 60-40 ratio, the BDA has acquired the land of the owner, my owner of the land, and agreed to.
Why do you want BDA to be brought?
Because what happened is it has been acquired ಅಂತ ಹೇಳಿದ್ದಾರೆ. D5 we have produced before the court.
And file an application for additional evidence.
That we have produced that document. Anyhow,
ಈಗ ನೀವು ಇಂಪ್ಲೀಡ್ ಮಾಡಿದ್ರೆ ಅವ್ರ ಸ್ಟೇಟ್ಮೆಂಟ್ ಇಶ್ಯೂಸ್
ಏನಿಲ್ಲ ಅವ್ರ ಸ್ಟೇಟ್ಮೆಂಟ್ ಏನು ಅಂದ್ರೆ ಅವರು ನೋಟಿಫೈ ಮಾಡಿದಾರೆ, ನಮ್ಗೆ ಬಿಟ್ಟಿದಾರ ಇಲ್ಲ ಓನರ್ಗೆ ಅಷ್ಟೇ.
ನೀವು ಇದು ಮಾಡಿ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿ.
ಅಪ್ಲಿಕೇಶನ್ ಹಾಕ್ತೀನಿ, ಜೊತೆಗೆ ಅವ್ರು ಬಂದ್ರೆ ಕ್ಲಾರಿಫೈ ಆಗುತ್ತೆ. ಬಿಕಾಸ್ ದ ಲಂಡ್ ಜಡ್ಜ್ ಹಸ್ ನಾಟ್ ಲುಕ್ಡ್
ದಿಸ್ ಅಪ್ಲಿಕೇಶನ್ ಇಸ್ ನಾಟ್ ಮೇಂಟೈನಬಲ್ unless you seek for reliefs against the BDA. How is your application?
Only thing is BDA has notified the land ಅನ್ನೋದಕ್ಕೋಸ್ಕರ what happened is BDA has notified the land.
Yeah, 126 is filed for impleading the proposed respondent.
Only reason is this, exhibit D5, I have produced before the court. BDA has agreed.
Sir, how can you implead, sir? You file an application for additional documentary evidence, file an application for summoning BDA. That will consider.
All right.
ಅದು ಬಿಟ್ಬಿಟ್ಟು ನೀವು ಇಂಪ್ಲೀಡಿಂಗ್ ಹಾಕಿದ್ರೆ
ಇಂಪ್ಲೀಡಿಂಗ್ ಏನಿಲ್ಲ, ಅವ್ರದ್ದು ಓನ್ಲಿ ಎ ಫಾರ್ಮಲ್ ಪಾರ್ಟಿ BDA because BDA makes a statement that will clear ಅಂತ ಅಷ್ಟೇ. Because the land has been notified.
Filed by the appellant to implead the Bangalore Development Authority as a
acquisition authority,
as a respondent,
since they stated to have acquired the land.
In this appeal, it is stated in the affidavit accompanying the application that
at least he posted for admission, but we could be able to, at that point of time, it could be
submitted that. Submitted that the trial court rejected the suit, dismissed the suit on the ground that survey number 27 on which the suit shall property survey number 20 on the ground that survey number 27 from which the suit shall property was carved out was notified for acquisition. The appellant contends that in order to avoid contends that the BDA has released 40% of developed land.
See, 40, yes.
40% of developed land to the owner's share.
Yes.
And accordingly, the right of the appellant
is protected.
Is regularized and protected. Full stop. He contends that in order to avoid technicalities, he has filed this application to implead the Bangalore Development Authority as a party respondent in this appeal. Next para. The dispute in this appeal arises out of OS number 30320 of 2023, filed for perpetual injunction. Full stop. The suit property lay within survey number 27.
Yes.
The defendant had claimed that survey number 27 was acquired by the Bangalore Development Authority. and therefore a suit for perpetual injunction was not maintainable. Full stop. The plaintiff, the appellant now claims that the Bangalore Development Authority
Issued D5, my lord.
had
Exhibit
released
D5.
40% of
Yes, D5.
the
Yeah, yes.
40% of the land in survey number 27
To the owner
to
share.
the owner's share, and that the right of the appellant is regularized, and therefore a suit for injunction is maintainable. He, however, wants to implead the Bangalore Development Authority to clarify whether the site claimed by the appellant lies within 40% of the
Yes. Owner share.
40% of the land in survey number 27, which was released to the share of the owner. Full stop. If the appellant desires to get information from the Bangalore Development Authority, comma, he is bound to file appropriate application, either under Order 41 Rule 27 or under Section 151 of CPC to summon information from the Bangalore Development Authority. He can implead the Bangalore Development Authority only when he has any, when he needs any relief from against the said respondent. Apparently, the appellant is not seeking for any relief against the Bangalore Development Authority, and therefore he cannot be impleaded as a respondent in this appeal. Consequently, IA 126 is rejected.
But that
List
D5.
for
not
admission
made-
on date code.
One reference D5, I have to obtain such information produced. my lord.
Right? Admission ಬರ್ಲಿ ನೋಡು. List for admission on so and so. ಯಾವತ್ತು ಬೇಕು ಹೇಳಿ.
Next
Any
week.
Thursday, Friday you can take.
Next week.
Baswanna KM.
2nd April. Serial number 30, Baswana came.
The delay of 141.
141 days in filing the appeal. Suit is for injunction.
Please, my lord.
Vacant land or
No, my lord, this is,
suit? Is it vacant land?
no, my lord.
Oh,
It's a
Shed don't they?
shed along with the carpenter work.
Trial court Minutes has rejected the suit on many counts, including the fact that
suit is decreed.
No, my lord. Suit is dismissed. my lord.
it's a plaintiff's appeal.
Plaintiff's
The vendor of the
Filing
Plaintiff is claiming on based on title.
title.
Based on
registered
title.
sale deed, my lord. Based on registered sale deed.
Hmm.
Thereafter, the Kata also affected. And he started renovating the property while the defendant
I
obstructing.
think matter requires consideration. You are claiming title to the property in terms of some agreement, GPA and all those stuff.
Yes, ma'am.
That has happened way back in 1986. The principal owner of the land in the year
Requires consideration,
1986.
matter requires consideration. Barcode. IA 1 of 26 is filed for condition of delay of 141 days in filing the appeal. It is stated in the affidavit accompanying the application that after the appeal
Para 6th, my lord.
was disposed of, the son of the appellant met with an accident.
Son and
Son
is met with an accident. Husband is suffering from heart problem. Thereafter, he is undergone the surgery. ma'am.
son met with an accident and her husband is suffering from coronary diseases. And therefore, she could not file the appeal within time. Full stop. Along with the application, the appellant has placed on record documents to show that her husband was treated at Glen Eagles BGS Hospital on 26/11/2025. Which shows that the CAG was done on 24/11/2025 and stenting CAG and stenting was done on 24/11/2025. Full stop. Will Magan Delide?
Next page.
Next page.
She is also placed on record, a discharge summary
57.
issued by Narayana Hospital, which indicates that the son of the appellant suffered injuries in an accident and was admitted on 26/6/25. Full stop. Therefore, this court is of the opinion that the appellant could not file the appeal within time due to a reason beyond our control. Hence, IA 1 of 26 is allowed and the delay of 141 days in filing the appeal is condoned. IA 2 of 26 would be considered along with the main appeal. List on so and so for admission.
And meanwhile, maintain status quo.
Kasavanna,
Same.
same order.
My lord,
Adullo ಇದೆನಾ?
I number 2, my lord, status quo.
No, ಇದೆಲ್ಲ ರೂಪ ಅಂತಿದ್ದಾರೆ, ಅದ್ರಲ್ಲಿ ನರಸಿಂಹಮೂರ್ತಿ ಅಂತಿದ್ದಾರೆ.
Yes, my lord, this is a GPA holder in the earlier.
Narasimurthy is GPA holder.
Rupa is the GPA holder on behalf of the Narasimurthy in 605, my lord, 30. In the second one is Rupa is personal appear.
ಅಲ್ಲ, in C number 13 ಅಲ್ಲಿ ರೂಪ pursued the suit.
Please.
She
No,
pursued the.
Yes, so we pursued the appeal only. Suit is participated in Narasimurthy. Narasimurthy is participated, my lord. Thereafter, he is handed over the property in favor of the Rupa.
ಏನ್ ಮೇಡಮ್ ಆಯ್ತು ಅದು?
He is executed the GPA
The
based on
appellant, in the affidavit accompanying the application, it is stated that the deponent had obtained a power of GPA, na?
Please, my lord.
Had obtained a power of attorney from the appellant. She contends that appellant and that she was instructed to file an appeal challenging the judgment and decree passed by the trial court. She contends adadmele accident adala bariri. See number 31, same order.
Same. And in meanwhile, my lord, status quo.
Yes.
We are in possession of the property.
Absolutely, my lords, if your lordship looks at the findings of the trial court.
Whatever it is, Mr.
Position is, my lord.
Till the
Position,
next
my
state
lords,
of
they did
hearing.
not have the benefit of an injunction even
Till the
during
next
course
state
the
of
suit.
hearing, please wait till the next state of hearing, comma, both the
If your
appellant and
lordship
the
could just
respondent.
hold it for admission with the records, not.
Please
Then,
wait.
my lords, then
Till the
possibly
next
even
state of
that order
hearing,
may not
please
come up.
wait, Mr. Till the next, please listen to what is. Till the next state of hearing, comma, the appellant and the respondent shall maintain status quo of the property as it stands today. Neither the appellant nor the respondent shall change or alter the nature of the suit property, and they shall not encumber, alienate, transfer, or part with possession of the suitable property. Till the next state of
Limited to
hearing.
next state, limited.
Till the next state of hearing. List on so and so.
Serial number 32,
9th.
Onion KBS.
Or your lordship with this, I don't know, if your lordship can not direct us, the paper book in Jasti live. It's a very small issue.
ಆಯ್ತು, admission ಬರ್ಲಿ.
What's ಆಗ್ಬೋದ?
Yes, next.
I appear for the review petition in 32.1.
32, I appear for the petitioner, my lord.
Huh?
32, I appear for the petitioner.
Both appellant and respondent have filed review petition respectively.
Then we'll allow this review.
My lord,
Even you have filed.
Mine is a prior review petition. There is a delay of 700 odd days. 4,000 days.
If both of you wants a review, we'll allow the review petitions and list for hearing. Here, what is this regarding?
The issue is this. Suit for bail injunction came to the fight.
Hmm.
2025 itself admits about several sale transactions executed in the sale to the defendant.
Right, you have any objection for condemnation of delay?
Lord, my condonation delay is only for 84 days.
What about 769 days? You have any objection?
The copy of the review petition itself is not served. I have not filed an objection.
ಏನೋ ಸರ್ವ್ ಮಾಡಿಲ್ಲ ಅಂತ ಮಾಡ್ರಪ್ಪ. The learned counsel for the petitioner in serial number 32.1 is directed to serve copies of the review petition along with all applications to the learned counsel for the respondent. List on so and so. Yes, Vijeta Naik.
16th April. 16th April.
Take whatever date you want.
For admission.
ಯಾವತ್ತು ಬೇಕೋ ತಗೊಳ್ಳಿ.
Number 33.
For the petition.
Any Thursday and Friday, you pick up any date. What happened?
Lord, locker is not in my name or joint name. The locker is which is operating, it's we belong to.
Alright, let them go. If you want, we'll ask somebody to go and find out what exactly is there in the locker. How many times the locker was, Really, yaru?
She herself admitted in the statement of objection filed to oppose the stay application. Para number 4 of.
There's so many lawyers, you pick up any person whom you want. ಯಾರು ಬೇಕು ಹೇಳಿ? ಹಾ. ಯಾರಿದ್ದಾರೆ? ಹಾ. ಹಾ?
ಯಾರೋ ಕೂತಿದ್ದಾರೆ ಇಲ್ಲಿ.
ಅವರೆಲ್ಲ ಸೀನಿಯರ್ಸ್, ಅವರೆಲ್ಲ ಬೇಡ. ಯಾರ ಯಂಗ್ಸ್ಟರ್ಸ್ ಇದ್ರೆ ಹೇಳಿ. Some youngster. Yes, madam, this one standing there. Come, yeah, come. ಹೇಳಿ sir. Let lawyers benefit from the
litigation.
From the litigation. Can't help it. When I try to convince you for a settlement, you people are not willing. So let somebody benefit.
ಇದರಲ್ಲಿ ಏನಾಗಿದೆ ಅಂತಂದ್ರೆ, not only these two litigations, there are about 9 litigations pending between the parties. SC/ST cases are also filed against the father and the mother, 3, and those persons come and sit here in the court to watch the proceedings. ನೆನ್ನೆ ಸುಮ್ಮನೆ ಕ್ಯಾಶುಯಲಿ ಮಾತಾಡಿಸಿದ್ರೆ
ಏನಾದ್ರು ನೀವೆಲ್ಲ
ತುಂಬಾ ಇದೆ, ಸೆಟ್ಲ್ ಆಗುವಂಗ್ ಕಾಣೋದಿಲ್ಲ ಇದು.
You are seasoned, seasoned senior advocate. You should counsel the parties.
ಹೇಳ್ ನೋಡಿದೆ ನಾನು.
ಫ್ಯಾಮಿಲಿ ಒಳಗೆ ಅಮ್ಮ ಮಗಳು, ಅಮ್ಮ ಗಂಡ, ಅಮ್ಮ ಮಗ,
ಅಲ್ಲ ಹೇಳ್ ನೋಡಿದೆ.
ಮದರ್ ಸನ್, ಮದರ್ ಡಾಟರ್, ಮದರ್ ಹಸ್ಬೆಂಡ್.
ಬಟ್ ಕ್ಲೇಮ್ ತುಂಬಾ ಎಕ್ಸಾರ್ಬಿಟೆಂಟ್ ಇದೆ, ಅದರ ಸಲುವಾಗಿ ಅದು.
Come to some reasonable terms.
ಆಮೇಲೆ ಪ್ರಾಪರ್ಟೀಸ್ ದೇವರ್
ಅವ್ರು ಹೇಳ್ತಿದಲ್ಲ ಏನೋ ಜಿವೆಲ್ಸ್ ಕೊಟ್ಬಿಟ್ರೆ ಎಲ್ಲ ಸೆಟ್ಲ್ ಆಗುತ್ತೆ ಅಂತ ಹೇಳ್ತಿದ್ದಾರೆ.
Jewels are still that list itself appears to be manipulated. I got one document to establish.
Okay, now please anyway tell us how much can we pay her?
Malas may kindly see one particular document which goes to establish. She got about 51 lakhs of 51 lakhs.
Fair enough. Let somebody go there, find out from the locker.
Let them go. Joint locker is there.
You know how a locker in a bank operates? No? I'll tell you. There's something called a bank locker. In all banks, there'll be a locker maintained by the bank. Anybody can go register in the bank and get the facility of a locker. There'll be 2 keys. One key will be with the bank, which is known as the master key, and other key will be with the customer. The issue in this case is very simple. Senior says that his client has kept some jewels in a locker. He says it is only 100 grams. The other side says it is 7.5 kilos of gold. 7.5 kilos of gold. So what you have to do is you have to go to the bank. She will accompany you. In the bank, the locker will be opened in your presence. You should take photographs and also make an inventory as to what are the jewels there in the locker, what are its respective weight. Can you do that?
Yes, sir.
And you should also go back to the bank official and find out when she operated the locker last and how many times she has operated it. Yes, tell us.
Way back in 2022, it was operated. Let's say find it out. There will be registers maintained. A register tagad ನೋಡಿ.
ಎಷ್ಟು ದುಡ್ಡು commission fee? Last time we asked 1 lakh for that.
This time it is at the instance of the respondent.
ಇಬ್ರು ಕೊಡಿ ಅಷ್ಟೇ. Both of you pay.
We'll share.
1 lakh.
We'll share.
Then why should the court pass an order?
Their own admission says that she has taken the jewelry. On record is on record.
Sir, we are trying to sort it out. If you want to pay, if both of you are willing to pay, ಮತ್ತೆ ಕೊಡಿ ಬರ್ಕೊಳ್ಳಿ. The dispute in this criminal petition revolves around certain jewelry allegedly handed over by the mother to the daughter for safekeeping. Full stop. The daughter has claimed that whatever jewels that were given to her by her mother is kept in a locker at
joint locker
at which bank?
I'll get the information.
at so-and-so branch. Bearing locker number so-and-so. The learned senior counsel for the petitioner slash daughter submits that the petitioner has no objection for the locker to be inspected by an advocate commissioner who may be appointed by the court. Full stop. The learned counsel for the respondent has no objection for an advocate commissioner to visit the bank and to open the locker in her presence and to draw an inventory about the jewelries in the locker, their respective weight, and also find out from the bank officials as to when exactly the locker was operated and how many times it was operated. Full stop. In view of the aforesaid, comma, as an interim measure which will not have any bearing on the outcome of the proceedings, comma, the Miss Ranjana Salanke Ji, who was present in the court, was requested to visit the bank and inspect the locker and draw an inventory and also find out from the bank when and how many times the locker was operated by the petitioner. Full stop. She accepted the request of the petitioner and agreed to visit the bank and also draw an inventory as stated above. Hence, she is appointed as a court commissioner. Full stop. Office is directed to issue appropriate commission warrant authorizing her to execute the commissioner work, authorizing her to perform the above duties. Full stop. The commissioner's fee is fixed at a sum of rupees 1 lakh payable by both the appellant and respondent number 2 in equal shares. At the spot. Full stop. The commissioner shall visit the bank on
Any day.
what date is convenient?
Next week.
Pick up a date, madam. Date.
Second.
Huh?
April 2nd. Or
April 2nd. Thursday. On 2nd April 2026 at 11 a.m. Full stop. The daughter slash petitioner shall be present at the bank, at the branch of the bank along with the keys of the locker. Full stop. The commissioner shall also drop an inventory of the jewelries found in the locker and their respective weight and take photographs of each jewel individually. Full stop. She shall also ascertain from the bank officials as to when the locker was operated last and on how many occasions, the petitioner had visited the bank for operating the locker. Full stop. List on. If need be, the commissioner may request the local police for assistance, and if a request is made, the local police shall provide necessary assistance.
Unless it is Karnataka Bank, Baswanagudi branch.
Karnataka Bank?
Karnataka Bank, Baswanagudi branch.
Baswanagudi branch.
And locker number is 213.
So and so. Yes. If you want, you can have this number of the commissioner.
I'll
Contact number. Serial number 34.
34, government advocate.
Yes.
Get the respondent.
This order is challenging the LIC award.
Your Lordship.
But
Maybe taken up next week.
RFA is not maintainable.
Concerned government advocate is not on leave, Your Lordship. Kindly it may be taken up next
So what
week.
is the suit for?
Suit the LIC respondent is
This
filed
order
the
has been challenged.
seeking for
LAC RFA ಹೆಂಗ್ ಆಗ್ತೀರಿ LAC?
RFA ಬರಲ್ಲ, MFA ಬರುತ್ತೆ.
Yes, your lordship, that is what concerned government advocate is not keeping.
ಮೇಡಮ್ ಕನ್ಸರ್ನ್ ಗವರ್ಮೆಂಟ್ ಅಡ್ವೊಕೇಟ್ ಬಂದ್ರೆ LAC RFA ಆಗಲ್ಲ.
Understood, your lordship. Kindly.
MFA ನೇ ಆಗ್ಬೇಕು.
It may be taken up for tomorrow. Your lordship.
No, madam. ಬರ್ಕೊಳ್ಳಿ. The appellant has challenged.
May be permitted to convert to MFA. Your lordship.
ಆಯ್ತು. Appellant has challenged the judgment and award dated 16/2/2019 passed in LAC number 169 of 2016 by the first additional senior civil judge and CJM Mandya. Full stop. In view of section 54(2) of the Land Acquisition Act
18 ಕೆಳಗಡೆ ಅನೌನ್ಸ್ಮೆಂಟ್ ಹಾಕಿದ್ರು.
ರೀ ನಾನು ಕೇಳ್ತಿರೋದು ಏನ್ರಿ ರಾಜಾ? ಅಪೀಲ್ ಎದ್ರಲ್ಲಿ ಹಾಕೋದು? ಯಾವ ಪ್ರೊವಿಷನ್ ಹಾಕೋದು ಅಪೀಲ್? MFA ಯಾವ ಪ್ರೊವಿಷನ್?
54
54 ಇನ್ನೇನು ನೆಕ್ಸ್ಟ್ ಏನೋ ಇದೆಯಲ್ಲ? In view of section 54 bracket small Roman 2 of the Land Acquisition Act 1894, the appellant is bound to file an appeal. We are bound to file a miscellaneous first appeal and not a regular first appeal under section 96 of the Code of Civil Procedure. Hence, his appeal is disposed of, reserving liberty to the appellant to file necessary appeal before the appropriate court. Full stop. Office is disposed of, madam.
May be directed.
Is not maintainable. Full stop. Consequently, office is directed to renumber this regular first appeal. ಇದು ಮುಂಚೆನ MFA ಅಂತಾನೆ ಹಾಕಿದಿರಾ? Earlier it was filed as MFA.
5117.
5117.
I'll get the clarification. Kindly, it may be taken up next week.
ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಎಲ್ಲ ತಗೊಳ್ಳಲ್ಲ ಮೇಡಮ್, ಇವತ್ತು ಹೇಳ್ಬೇಕು. Reference order is
They
under.
also condoned, your lordship, as IA for condemnation of delay also condoned.
Correct, but
ಅಲ್ಲ
how is an RFA maintainable?
ಅದೇ 41 ರೂಲ್ 5 ಕೆಳಗಡೆ ಹಾಕಿದ್ದಾರೆ MFA, that is not maintainable.
ಕರೆಕ್ಟ್, ಮುಂಚೆ MFA ಅಂತ ಹಾಕಿದ್ರಲ್ರಿ.
ಅದು 41 ರೂಲ್ 5 ಕೆಳಗಡೆ ಹಾಕಿದ್ದಾರೆ. ಇಂಜೆಕ್ಷನ್ ಆರ್ಡರ್.
ಏನ್ ಮೇಡಮ್ ಆಯ್ತು? Hence this appeal is ordered to be renumbered as MFA and list before the appropriate court. For statistical purposes, this RFA is treated as closed. Yes.
Much obliged.
Serial 35, Shivakumar D. Shivakumar.
DA Shivakumar.
DA Shivakumar, serial number 35.
Declaration. Issue emergent ಆಗಿದೆಯಾ?
Appear ಆಗಿದೆ sir.
Notice ಆಗಿದೆಯಾ?
Yes sir.
Cause shown is allowed a delay of 41 days in filing the appeal. Admit call for records, paper books to be filed within 8 weeks.
Serial number 36, Ravi Shankar R.
Ravi Shankar R.
Appear for the appellant's matter.
Declaration
Short
suit.
adjournment.
No adjournment. What is the suit for?
Declaration and injunction.
What has happened to the suit?
Limited and.
Suit ಏನಾಗಿದೆ? You can't.
It is decreed.
Suit is decreed.
Yes, madam.
Mandatory injunction possession. Yes, Barcode, admit, call for records. Paper book to be filed within 8 weeks. Interim stay of the impugned judgment and decree. Yes. For this you need 2 weeks, is it? For such a simple thing you need 2 weeks. Suit is for declaration, recovery of possession. Yes. Vijay Bosle.
Yes, madam.
Appearing for the appellant's fresh
Stay ilva. Hey, Ravi Shankar, have you filed an application for stay?
No, man, you require time for that.
On the reliability. Admit call for records. Paper books to be filed within 8 weeks.
It's maybe taken on 9.
You file an application, we'll consider. Yes, Vijay Bosle.
Serial number 37. Vijay Bosle.
Suit is, what has happened to the suit? Who is Vijay Bosle? Senior. Barkoli. Interim, admit issue note. Yeah, only one respondent or how many respondents are there?
2, sir. 1 and 2.
Sukanya. BL Sanjeev. No. Admit call for records till the next date of hearing, comma, the operation and execution of the impugned judgment and decree state. Sanjay Sanchan. Emergent notice regarding admission. Corona.
The matter should be heard on the merits itself. So formally, that is not admitted. But I represent third respondent. Lord, appeal will be executed at the date will be for final hearing, my lord.
Admit paper books to be filed within 8 weeks. Response month.
Lord, at least 3 months will be fixed for that. 3 months, Lord,
After 8 weeks, June allo July. July the roster change ಆಗುತ್ತೆ. So therefore, I cannot fix a date for the appeal date. After 8 weeks, May after. Finish current.
40 minutes, I appeal for the respondent, serial number 40. But there is a delay, my lord, huge delay of more than 300 days. I will not file.
Narayan, I think you are appearing in the wrong map. This is serial number 40, Dharanishwaran and Anand Solapur.
Please, my lord, please, my lords. My lords, I appear for the appellant. This is
I'm sorry.
appeal. This is defendant's appeal against the judgment and decree in a suit for recovery of money filed by the plaintiff. The specific contention of the plaintiff is that he was terminated summarily by a notice exhibit P6 dated 25/2/2016. This is a specific contention that no prior notice was given. As per the contract of employment, he says that there was 2 months prior notice should be given. There is also a clause which says that I can summarily terminate. The trial court finds that I have the right to terminate him summarily. And in spite of it, it says that I did not give separation notice or termination notice, on which basis the plaintiff has filed the suit. There is a self-contradiction by the trial court. Your lordship may kindly turn to paragraph number 16.
Now, where are the clauses?
Please, the trial court has traversed it.
Both 13.1.
Please, 13.2. Specifically, 13.2. Your lordship may kindly turn to page number, ink page 32. The trial court traverses the same. Please, please. 13.2. If you have committed any serious breach or repeated or continuous after warning and writing, breach of obligation under this contract, or have been guilty of conduct which brings or may bring the company or yourselves to disrepute, or have non-performing even after giving repeated opportunity. Under this class, I have terminated. That is this contention. The plaintiff's contention also is that, like I have summarily terminated him.
Summarily ಹೆಂಗಾಗುತ್ತೆ? Have you produced material to show?
Yes, my lords. Yes.
That he had
Exhibit P6 filed by the plaintiff is the summary termination notice.
No, please hear what the court is saying.
My lords,
Exercising power under clause 13.2, there must have been serious breach or repeated or continuous breach of obligations.
Please, my lords.
What is the material produced by you to show that there was serious breach or repeated or continuous breach of obligations under the contract?
Exhibit D1 is the document.
What
Warning
is that?
notice, which clearly says, you know, like what are the serious, you know, like, rather deviations or non-performance, you know, like he was doing. And thereafter, by letter dated 25/2/2016, he was summarily dismissed or terminated. The trial court goes on to say, your lordship may kindly turn to page number, ink page 35, internal page 20. Your lordship would get about, you know, like seven lines above. Though a warning notice, your lordship gets it?
Yes.
Though a warning notice is issued by the company has not complied with class 13.2 of exhibit P2 by issuing termination notice.
No,
This termination notice is exhibit P6.
Right, but should you not tell him?
Milords, you know, like P6 clearly says that. I will just, you know, like say pass on, you know, like exhibit P6, which clearly says that on which basis he said that he has been terminated.
Should you not tell him what are the breaches or the repeated or the continuous breach of obligation? Should you
Milords,
not tell
two
him?
things. One, warning notice was given as per exhibit D1.
Correct.
In exhibit P6 also, no, like say I have charted out, no, like what are the deviations.
P6 is the termination.
Milords, it also, no, like say says, no, like what are the reasons.
No, then you should you not inform him?
Milords, you know, like I have informed.
No, should you not tell him on so and so we had notified you about these lapses or the breaches. You did not, or you continued, or you repeated. So therefore, we are terminating your services on the L.
Milords, you know, like see the document, you know, like see itself, you know, like speaks for it. I'll just, you know, like pass on. Sorry. It's a big document. I'm sorry.
Records bandilva?
Illa, sir.
Then we'll get the records.
Please.
No, please, no. My lord, one submission, my lord. In that only court says, my lord, there is no dispensation in for summary notice. If they want to continue as a summary proceedings, they ought to have issued notice to me calling upon the explanation. My lord, their notice has not been dispensed with in the clause. The court says that there is no summary notice is available. My lord, then it's hold that, my lord, termination note hold good. I'm entitled for a 2 months salary.
Yes. Why 2 months not? Why not 3 months?
No, my lord, it's as per the order proposed, my lord, appointment order. My lord, I'm entitled for 2 months salary.
Correct. That is before you are sought to be terminated without
Please,
any
my lord, says
without
that,
any cause.
Page 15,
please.
See, without cause are there 2 months. Suppose if they have cause.
Ad summary proceeding initiate madbekadaga. That's a moment, my lord, they have to issue a notice to us calling upon explanation. My lord, that notice is not dispensed in the clauses.
That is right. Why 2 months? Why not 3 months? Why not 6 months? Why not 9 months?
Lord, yes, my lord, kindly see, my lord.
Does the clause contemplate paying 2 months salary?
Please, my lord, please, my lord. Idedrolagide. My lord, para 12, page 28.
Para?
My lord, page 28, my lord, para 12 of the judgment, my lord, last. My lord, after the successful completion of prohibition, the agreement may termination of a 2 months notice in writing or either side. Notice may be given. It's a part of the.
In lieu of termination notice without cause.
Please, my lord.
Without cause, it is 2 months.
Please, my lord.
Suppose if there is cause.
Well, cause means they have to issue notice calling upon me. There's no dispensation of
So how
notice.
can the court say, court can set aside the termination? How can the court say pay 2 months salary?
No, well, as per this amendment.
If there is cause to terminate, the court should only say.
Let call for records. I'll also go through the records. I don't
admit call for records.
No, admit, madam. If it's a call for record.
These are all fanciful litigation, Mr.
Have a call for record.
There was no challenge to the.
At the most, the court can say that this termination is bad in the eyes of law. Can the court say, you're terminated, fair enough, pay 2 months salary?
Now, court says, my lord, if want to terminate, they have to give a 2 months notice to it, my lord.
Where is the clause?
Lord, that clause, my lord, offer clause. That's what I will call for the records. I will submit exhibit
Call for
P1, P2. Only one, no admission is required. My lord, if it's there, I will succeed. Otherwise, my lord, it will already, my lord, once it is
Call
remanded.
for records, yes.
Please only.
List on so and so for admission.
Please.
I'll not adjourn it next time, mister. Come
Please,
ready.
please, please,
Oh.
please.
Go.
Number 41.
Good.
They may be.
Stay is already there.
Interim stay, interim order granted on so and so, serial number 14 only. Interim order granted is extended to the next date. Gautam Chand.
Serial number 41.
Your Lordships, seeking for a
Good
short
Madhya.
adjournment, Your Lordships.
Yes, Shankar.
There's a severe throat infection.
Suit is decreed.
Suit is decreed. Suit my lord is of the year 1985.
Call for records. Admit call for records.
Not
The
before.
drawing of a final decree is stated. However, all further proceedings leading up to
Your
final
Lordships, it
decree
may
shall
be
continue.
short.
Before your lordship admits, not could it be taken up at this stage? 1985 suit.
Your Lordships, a short adjournment may be granted, Your Lordships, within next
But
Thursday.
mother-
The arguing counsel has a
Suit is
severe
filed
throat
by whom?
infection.
Mother against the daughter-in-law for partition. It is a grant. Grant is made in favor of the mother and the son jointly. Son dies. Daughter-in-law does not give a share. So she files a suit for partition.
Half
share.
Uh,
And during the pendency of the suit, she dies executing a will. Court says that the will has been proved.
Chetan and the
Ashton.
man, the lady has died.
Lady has lied.
Beneficiaries are fighting. Beneficiaries are fighting.
Not the daughter-in-law and the beneficiary under the will are
Right,
fighting.
but the lady is gone.
And our last wishes not that I should get because
You will get it.
what
You will get it.
Yavaton-
Final decree is
Next Thursday, Your Lordships.
Madam, did you understand what the court said? What did the court say? Court has admitted your case. Court has granted you interim order.
Yes, Your Lordships.
You don't want that.
We do.
You want it. Yes. Next.
Number 42.
Notice on IA 125 as well as in the main appeal.
Ex parte judgment and decree.
Notice,
Order
let
nine.
notice go. Notice should be issued. Rakshita.
Serial number 43. Rakshita.
In fact, it's already order of status quo. It will be continued, but it may be posted for B group or final hearing.
The appeal may be kindly be admitted.
Admit, call for records. Sandi the records. no?
It's already been admitted, my lord.
Filing, paper book shall be filed within 8 weeks. Parties are directed to.
The paper book was
Interim
submitted.
order granted is extended till the disposal of this appeal.
The paper book is filed.
ಮಾಡಿದ್ದೀರಾ?
Obligement, ಹೌದು.
ಆಯ್ತು. Admit list of final hearing. Until then, comma, the interim order granted is extended. Yes.
Obligement.
Grateful, my lord.
Serial number 44. Ravi Shankar S.
Until then, until disposal of the appeal.
Suit for declaration and possession
Shankar.
of these shared with property. Suit was dismissed. I relied upon a will.
Suit is decreed.
Dismissed, my lord.
Dismissed.
Suit for possession.
Based on title.
Based on, I had a gift deed. And I had a gift deed, registered gift deed. My donor has got the property under a will.
Who are the defendants?
Defendants are the third person who are sitting over the property of a B schedule property.
Admit ಮಾಡ್ಬೇಕಾ? Admit, call for records, admit issue emergent notice.
Your Lordship may kindly see one observation is there that the will is concocted and the criminal case pending. The observation may come in the way of like ಅದಕ್ಕೋಸ್ಕರ I have sought only the observation as
ಒಂದು ಕೆಲಸ ಮಾಡಿ, issue notice, issue emergent notice to the respondent. Call for records, list on so and so and date ಕೊಡಿ. Yes, VB Sidramaya.
10th April. Serial number 45. Sidramaya VB. Serial number 45.
Client is rejected. Lakshmish G Lakshmish or R8. Hmm. Suit is filed after 25 years.
Yes, ma'am. But the appeal is as against dismissal of the suit based on an application.
Compromise decree. The suit, the compromise decree passed in 28 of 91 is challenged. By whom?
By the son.
Now, was he a party in OS number 28?
No, he was not. His father was a party.
His father was a party.
That attained finality. Thereafter, the father expired in 2008. There is an inter-party suit between the children, claiming that the property, subject property is an
Let
ancestor.
him come. Let us with Sidramaya come. Pass over.
Serial number 46.
G. Suhas.
Bus.
R.V. Naik.
A plaintiff suit for a bare injunction has been dismissed on the ground not the schedule of the plaintiff's property is different than the schedule of the defendant's property. Therefore, the suit is not
The
maintainable.
suit must have been decreed, Alva.
No, suit has been dismissed.
Suit must have been decreed.
No, because the schedule of the defendant's property is different.
No, you said schedule of the defense property is different.
Yes.
Schedule of the plaintiff's property is different.
No, and the plaintiff claims that the defendant's property. That is the reason. So plaintiff is claiming defendant's property with a different identity.
Yes.
A title suit should have been filed, suit for declaration of title.
Yes.
My lord, I appear for the appellants, my lord.
Lord, you may kindly see, my lord, the judgment.
Records ಬಂದಿದೆ
For
ಸ್ವಾಮಿ.
records.
ಬಂದಿದೆ.
Records ಇದೆಯಾ?
Call for ಮಾಡಿದ್ದಾರೆ ಸ್ವಾಮಿ. On the previous day.
ಬಂದಿಲ್ಲ.
ಬಂದಿದೆ.
ಬಂದಿದೆಯಾ? Call for records.
Lord, we have served
Of
the
the trial
copies.
court. No?
We have served the copies on the to the other side, my lord. There is
You have received the copies.
Copies of the
Plaint, ಹೌದು. ಅಷ್ಟೇ ಏನು ಹಾಕಿಲ್ಲ.
Evidence ಎಲ್ಲ paper book ಹಾಕಿದಾಗ ಬರುತ್ತೆ.
document.
It may kindly be overruled.
Next. Call for records, list for admission on so and so. Rajeshwari M.
But I appeal for the respondent, Lord, in this matter. But there is a huge delay of more than 300 days in filing, Lord. I will formally file the objections, my Lord. 1 week's time may be granted. It's a money suit.
Counsel for the response to file
Meantime, they have
objections
filed
to IA
execution
126. List on so and so.
They have filed the execution petition. It is
Don't
listed
proceed with the execution.
No, not yet, my Lord. I am not yet.
Counsel for the respondent undertakes not to precipitate the execution of the impugned judgment and decree in EP number
EP number
25042.
250.
42 of
So and so.
25.
Yes, next.
Till next date of hearing. In the meantime, I'll file my objections.
Anuradha arrest.
16th
Much.
Serial number 48.
Appeal to the appellant in this matter. It is a defendant's appeal. The suit was filed for declaration and possession, please, Your Lordship. The suit is partially decreed. Against two people, it is dismissed. Rest of the persons, it is allowed, please, Your Lordship. This is a case wherein there was a suit for, there was a partition between two brothers in the year 1988. Later on in the year 1990, a registered GPA is executed. And based on the registered DPA, there are many sale deeds executed. In the year 2004, wife files a suit against the husband for partition. And within 3 months, it is decreed. Based on that, the wife files a suit saying that she is the owner of the property and for possession, please, Your Lordship.
Emergent notice regarding admission.
Your Lordship,
Call for records. Till the next date of hearing, the operation and execution of the impugned judgment and decree is stayed. The 2011 suit. Yes, next. Mr. Devanand.
49, R.A. Devanand. 49.
R.A. Devanand.
Lord, appearing for the respondent 1 and 2, my lord.
This is an appeal by the tenant who suffered a decree for eviction. It has already gone on record that I do not press this appeal on merits. And in the meanwhile, they bring it 4 pages of memo of calculation of arrears of rent amounting to 6 lakhs. And I have each answered the monthly rent what they claim to be not paid by filing a memo. I have served a copy on the other side. I am filing a reply to that memo of calculation.
Now you please tell us what are the payments that you have made.
payments except, my lord, can I request, my lord, before looking into that memo of calculation and the replay of mine, it would be better if my lords were to make a note, mental note of the fact that from day one of the inception of the tenancy till the day of the decree passed, every entire payment of rent is through the banking transaction. Not a single month that a rent was handed over.
Thank you. Please give the details unnecessary.
Please. No.
This memo is only verbose. Aste.
Yes, I have made a note. I have made a note. Can I request my lords to kindly be at page 2 of my objection to the memo?
We will not do this calculation. We'll direct the register to
Please,
do
please.
the calculation. Barkul, the memo is filed by the.
Lord, it would be advantage to the landlord itself, though I appear for the tenant, that
Correct.
he claimed 6 lakhs rupees, but I have said I am in arrears of 4 lakhs. And the trial court passed a decree that I am in arrears of 1,10,000. There was an error in the part of
When
the
will
trial.
you pay that 4 lakhs?
Some non-payment of rents on some days and some payment.
When will you pay that 4 lakhs?
I am ready.
No.
If my lords were to give me a week's
So
time,
he
out of
says-
that 2 lakhs is the security deposit.
The appellant says that you are bound to pay only 3,16,000.
No. As per the memo of calculation, what he has filed later, after his appearance before the court, the trial court holds me a decree against me a decree for 1,10,000 that I am in arrears of rent.
Yes.
I have walked an extra mile to say, no, trial court error is wrong, computation is wrong. I am at 4 lakh and odd is the
Yes,
due.
Mr. Are you willing to accept 4 lakhs and close the dispute regarding arrears of rent?
My lords, I'll seek instructions from my client, my lords, with regard to that.
Mr. Trial court has only decreed for 1,10,402 up to 21. From 21 till date, what is the arrears?
They claim additional increase of rent of 5 months, 5%, but there is no contract between myself and the landlord
Yes.
with regard to the hike rent.
Yes.
And it is better, I am on their side to say, because I do not want to rather deceive any person of this type.
My lords,
I have called out in my objection.
From 2021, what will be the arrears? Are you willing to accept 4 lakhs towards the arrears and close the issue?
my lords, I'm the proxy counsel in this matter, my lords. I'm appearing for Advocate Bhargav. I have to seek instructions.
For the reply is filed by the reply to the memo filed by the Learned Counsel for the respondent is filed. The Learned Counsel for the appellant submits that a sum of rupees 4 lakhs.
4 lakhs, I have called out 4 lakhs.
A sum of rupees 4 lakhs.
20,000.
20,000 is due to the respondent.
Yes.
The Learned Counsel for the response seeks time to secure instructions. Hence list tomorrow.
Not tomorrow, my lords.
Tomorrow, ne, sir.
Not tomorrow.
Not tomorrow, ne.
Allah, I had some medical examination to undergo. Can it be on Tuesday or Wednesday? Allah, my client is ready. If the court says yes, they are agreeable, he is there to present a check.
That is why I wanted to list tomorrow.
No, not tomorrow is my day of my medical examination.
2nd April.
Yes.
2nd April.
Number 50,
Oblak.
S. Kumar.
Much
50,
obliged.
yes.
Your Honor, respondent has filed an money recovery suit in the trial court, which is in favor of the respondent. Suit favor agide Swami, decree agide respondent paragide Swami.
STK
2,37,000 Swami. They have claiming based on the tax invoices. They have delivered goods to the appellant until
deposit 50%. Barcode issue emergent notice.
My lord, we are ready to make a deposit of 10 to 20% to stay the judgment and the decree.
No stay. Emergent notice. Stay bekere 50%. Badwa?
Yes, Lord.
Interim stay of the impugned judgment, operation and execution of the impugned judgment and decree subject to the appellant depositing 50% of the suit claim before the trial court within 4 weeks from today. Yes.
Serial number 51.
Sorry for the interruption. Second is declared to be a holiday.
Yes, sir. Second is working. Third, fourth are declared holidays. Serial number 51, Vasant Madhav, yes.
It's okay. If it is
For the
holiday,
appellant.
It's okay. Baswa Jayanti, it's a holiday, state government holiday.
2nd April is not a holiday.
Oh, it's okay. I'm sorry for the interruption.
3rd is a holiday.
Oh, bless you.
Baswa Jayanti.
Serial number 51, Vasant Madhav, yes.
For the appellant, please.
Third is Good Friday. Baswa Jayanti is 20th. Yes.
For the appellant, please, my lords.
Vasant Madhav. Suit is for?
Suit is for declaration and possession. Suit is decreed. It's a defendant appeal, please.
Okay. Admit emergent notice. Call for records. Interim stay of the impugned operation execution of the impugned judgment and decree till the next date.
One submission. The name of
Admit emergent notice. Emergent notice, call for records. Interim stay of the operation and execution of the impugned judgment and decree till the next date. List on date.
Yes, 9th April.
9th April.
my lords, name of Ankit S. Reddy may be shown for the appellant, please, my lords. Instead of Vasant Madhav, I filed the NOC Wakalat in the counter today.
Mr. Ankit.
S. Reddy.
Office is directed to show the name of Mr. Ankit S.A.
S. Reddy.
As?
S. Reddy. Ankit S.
S.
Reddy.
Reddy. As the counsel for the appellant if he has entered appearance. After deleting the name of Mr. Vasant Madhav, yes. Yes.
Serial number 52, Gutkal Sivappa Shankarappa.
After Bada and delete the name of Mr. Vasant Madhav.
The defendant's appeal, my lord. The
Suit
suit is decreed, my lord.
Suit is
Suit for
decreed.
specific performance of the agreement. The plaintiff, even though he has failed to show that my ready and willingness to the execution of the sale deed.
Emergent notice regarding rule. Interim stay of the operation and execution of the impugned judgment and decree till the next date of hearing. List on date.
9th April. Serial number
Kartikeya
53,
Khanna.
Kartikeyan Khanna.
9th, madam.
Yes.
My lordship, I'm for the appellant and this suit is for bare injunction and decreed. My lord, I am representing the Apartment Owners Association and there is a piece of undeveloped land in front. My residential side is built up. OC is granted. The residential apartments have been built up. Occupancy certificate has been granted. And a portion of land is acquired by BIMRCL. And thereafter, the sanction plan, the commercial development has not happened. Now, the respondent side, they wanted to build a commercial complex without identity of the property. Property was not identified. Now, the clear problem, the issue in this the judgment of the trial court is that the suit scheduled property itself is not identifiable. And there are two things that I wanted to bring your attention to, my lords. One is on page number 32. My lords, on page number 32 of the judgment, which appears as page number 17 of the judgment actually.
Call for records. Vidyadhar,
I appeal for the respondent, madam. I am the owner of the.
you are the only respondent or?
I am the only respondent.
Call for records. Call for records.
My lords, I have also filed the application for stay. Stay of the application.
Not granting any stay to you.
My lord.
Call for records. Yes.
My lord.
Final hearing matter, serial number 54 urgent, serial number 55, Abdul Razak.
Abdul Razak.
Serial number 55.
KB Satish Chandra.
Your Lordship, for appellant, Your Lordship.
Yes.
This is a suit filed by the appeal preferred by the defendant. She is the second wife of one Narayanamurthy, Your Lordship. Plaintiff number one was the ex-wife of one Narayanamurthy, Your Lordship. The suit is for partition. This suit is decreed in favor of the respondent, Your Lordship. My specific contention is that, Your Lordship, this suit is not maintainable as they have denied the relationship and the defendant has denied the jointness and possession of the respondents, Your Lordship. And second, my specific contention is there is no cause of action.
First, you please tell us what is the relationship of the plaintiffs with the defendant? Who are the plaintiffs?
Defendant
Who are
is
the
the
defendant?
second wife.
Defendant is the second wife
Defendant is of one Narayanamurthy. The respondent number
Defendant is
one
the second
was the first wife, ex-wife of one Narayanamurthy who deserted and left the Narayanamurthy 15 years back of marriage of the defendant, Your Lordship.
Yes, where are you from, Mr. Abdul Razak? Where are you from? Bangalore.
Bangalore, Your Lordship.
You're practicing in Bangalore.
Yes, Your Lordship.
Yes. Yes, please argue. Then why don't you come to the court?
Personal inconvenience
Yes,
is there,
please
Your
go
Lordship.
on.
Kindly, it may be taken on after 2 weeks, Your
No, no,
Lordship.
we'll not.
I'll come to the court.
Adjourn it. Please go on, go on, go on. Please go on. You're arguing a
Your
civil
Lordship,
suit, a regular first appeal, so you should be thorough on who are the plaintiffs, what is the relationship with the defendant. Then here,
I have filed the
you're
family
straight
tree,
away
Your
jumping
Lordship.
to the case.
I filed the family tree of the parties.
And when you're
That's in
arguing a
court
first
file, Your
appeal, please listen to me. I'm giving you a tip free of cost. When you're
Please,
arguing a
please,
first
Your
appeal, either you adopt the array of parties before the trial court or before the appellate court. Don't say appellant
Please,
and
sir.
then go to plaintiff, then defendant, then respondent, Atharama. Plaintiff and defendant, appellant and respondent.
I see.
Really.
So,
Bharadam, plaintiff. Plaintiff number one is the
I
wife
refer
of
the
Narayanamurthy, son Shiva Shankari, daughter, Shivagami, daughter. Kastur is the second wife. Held.
Your Lordship, the plaintiff, they have not paid the sufficient court fee, Your Lordship. And another contention is that the non-gender of necessary party, because the defendant Narayanamurthy is having daughter. She has examined as a DW2. The plaintiff have not cross-examined the DW2, Your Lordship. So, kindly take up the plaintiff, Your Lordship.
Abdul Razak, there is something called a plaint filed in the trial court.
Please, Your
Plaint haktarala suit, plaint over the first two. Then you please read the written statement. Then go to the issues. Who are the witnesses? RFA hang argument ಮಾಡಬೇಕಾಗಿರೋದು. You can't argue like a writ petition.
Plaint also me.
Paper book. LCR ಇದೆಯಾ ಕೊಡಿ. You straight away jumping to argue the case. You're not even giving me the basic facts as to who are the plaintiffs, what is the property, how the family got the property, who is the owner. You're jumping to the points of law already. Give the facts first.
The property is, Your Lordship. It's a 300 square feet house, Your Lordship. It is purchased by the defendant. She is the second wife. Due to the love and affection, it was registered in the name of Narayanamurthy and the defendant, in the joint name of Narayanamurthy and defendant, Your Lordship. She is running vegetable shop in the suit schedule property, Your Lordship. The relationship of the defendant with the Narayanamurthy is admitting by the respondents, Your Lordship. That has been mentioned in para number 4 of the plaint, Your Lordship.
So who is the defendant? Defendant, her husband Narayan Murthy intide.
How's it?
Because the
Plaintiff themselves are
defendant,
admitting that she is the wife of the Narayan Murthy because they have deserted the Narayan Murthy 15 years.
Please read paragraph number 4 of the plaint.
Please, Your Lordship. The plaintiff number 1 submits that the defendant and her husband Narayan Murthy, whereas running provision shop and defendant was assisting him to carry out the work on day-to-day basis. And for the same plaintiff husband, herein purchased the property in joint with the defendant under registered sale deed, so and so, Your Lordship. So they are admitting the relationship with the defendant, Your Lordship. So kindly see the prayer column, Your Lordship. Prayer number 1. They are seeking declaratory relief, Your Lordship, to declare the plaintiff half share in the suit show property by demarket the same by meets and bounds and to grant such other relief. But they have not paid the court fee as per
Whether
the
the
declaratory relief, Your Lordship.
Whether the plaintiff number 1
Please.
and the husband of defendant is Narayan Murthy.
Yes, Your Lordship.
Plaintiff number 1 husband ಮತ್ತೆ defendant husband Narayan Murthy same person
Same person.
Then you read paragraph. Read paragraph number 4 of the plaint again.
The plaintiff number 1 submits that the defendant and her husband Narayan Murthy.
It is plaintiff number 2 submits.
ಅಲ್ಲ ಪ್ಯಾರಾ ನಂಬರ್ 4 ಅಲ್ಲಿ plaintiff number 1 submits ಅಂತಿದೆ plaint ಅಲ್ಲಿ.
ಅದು ಹಿಂದಿನ ಪ್ಯಾರಾ ಓದಿ. ಅದು ನೀವು ಓದ್ತಿರೋ ಪ್ಯಾರಾ 5 ಅದು. ಪ್ಯಾರಾ 4 ಓದಿ.
The plaintiff number 1 submit that there are 2 paras same number. 4 ಅಂತ ಎರಡು ಇದೆ ಅದರಲ್ಲಿ. 4 ಅಂತ ಪ್ಯಾರಾ 4 ಎರಡು ಇದೆ ಸ್ವಾಮಿ ಅದರಲ್ಲಿ plaint ಅಲ್ಲಿ. ಪ್ಯಾರಾ ನಂಬರ್ 4 No, I am for different.
One paragraph. There's only one paragraph.
The plaintiff number 1 submit that the plaintiff husband.
ಪ್ಯಾರಾ 4 ಓದ್ರಿ plaint ಇದು.
ಸ್ವಾಮಿ 3 ಆದ್ಮೇಲೆ 4 ಬರುತ್ತೆ ಎರಡಕ್ಕೂ ಕೊಟ್ಟಿದ್ದಾರೆ ಅವರು. ನಾನು 3 ಆದ್ಮೇಲೆ 4 ಬರುತ್ತೆ ಅದು
3 ಆದ್ಮೇಲೆ
ಅದೇ ಓದ್ತಿದ್ದೀನಿ ಸ್ವಾಮಿ. The plaintiff number 1 submit that 5 page number 3 ಅಲ್ಲಿ ಇದೆ ಸ್ವಾಮಿ. plaint page number 3 ಅಲ್ಲಿ ಪ್ಯಾರಾ ನಂಬರ್ 5 ಇದೆ. ಪೇಜ್ 2 ಅಲ್ಲಿ ಎರಡು ಪ್ಯಾರಾನು 4 ಅಂತ ಕೊಟ್ಟಿದ್ದಾರೆ. ಅದರಲ್ಲಿ ಫಸ್ಟ್ 4 ಓದ್ತಾ ಇದ್ದೀನಿ ಸ್ವಾಮಿ ನಾನು. 3 ಆದ್ಮೇಲೆ 4 ಬರುತ್ತೆ ಫಸ್ಟ್ 4. The plaintiff number 1 submits that the defendant and her husband Narayan Murthy were running provision shop and the defendant was assisting him carry out the work on day-to-day basis. So they are admitting the relationship.
The plaint is amended. There is an amended plaint which says plaintiff number 2 submits. This is paragraph number 4. I am reading it for your convenience. Plaintiff number 2 submits that the defendant and her husband Narayan Murthy were running provision shop and defendant was assisting him to carry out the work on day-to-day basis, and for the same plaintiff's husband herein purchased a property in joint with the defendant under registered sale deed dated so and so. So Narayan Murthy purchased this property in his name and also in the name of the defendant.
Oh, that is their claim. But my case is defendant has purchased. She was running because he was a cancer patient. He was bedridden and acute alcoholic, Your Lordship. So he was not in a position to earn outside, Your Lordship. So this property exclusively purchased by the defendant, but it has been registered in joint name of Narayan Murthy and the defendant, Your Lordship. Before executing sale deed, there was a agreement for sale, Your Lordship. That was executed in the name of sole defendant only, Your Lordship. Entire sale consideration also paid by the defendant to the seller, Your Lordship. That agreement is marked as Exhibit D7, Your Lordship.
Where is
so before that, there was. Exhibit D7 is this agreement of sale, Your Lordship. That is in the name of defendant only, Lordship. There is no Nandmurthy's name in that documents, Your Lordship.
What is there to show that you have paid the money?
That is by through cash only, Your Lordship. That is also endorsed in the Exhibit D7 agreement, Your Lordship.
So long as the property is in the name of Narayan Murthy, are the plaintiffs not entitled to a share? So long as the sale deed is the name of Narayan Murthy, are the plaintiffs not entitled for a share?
Yes, Your Lordship, because the case of the plaintiff that the name of the Nayamurthy is reflecting in the sale deed, but they never contended that the sale consideration amount has been paid by the Nayamurthy, Your Lordship. In their whole case, they have not contended.
No, what is the law? Kudrit, TP
Presumption is there, Your Lordship, but I have marked the agreement for sale that is executed in the name of defendant, Your Lordship.
Have you read section 45 of the TP Act? Yes. Please read
And
section
there-
45 of the TP Act. TP Act Odi.
Please.
Hmm.
What is of TP Act, Your Lordship? Rules that
45,
when multiple owners.
45 of 45. It is 45. Please read 45.
Where immovable property is transferred for consideration to two or more persons, and such consideration is paid out of a fund belonging to them in common, they are in the absence of a contract to the contrary, respectively entitled to interest in such property, identical as near as may be with the interest to which they were respectively entitled in the fund, and where such consideration is paid out of separate funds belonging to them respectively, they are in the absence of contract to the contrary, respectively entitled to interest in the such property in proportion to the shares of the consideration which they respectively advanced.
So what does it mean if you have mentioned in the sale deed that out of 2,84,000, the entire consideration is paid by this lady, Yaru?
Please.
Kasturi. Then the entire property
Yes,
will come to Kasturi. If it is not mentioned,
Please,
then it will be divided between two.
Yes,
it should be mentioned in the sale deed that the entire proper consideration is paid by Kasturi. Only then she is entitled to the full property. Otherwise, by default, it will be divided between two. That is the law.
Moreover, Lordship, they are seeking partition, but they are not in joint possession, and they have not admitting the relationship with the defendant, Your Lordship. So they should have.
Section 8 ಗೆ ಜಾಯಿಂಟ್ ಪೊಸಿಷನ್ ಏನಕ್ಕೆ ಬೇಕು? ಸೆಕ್ಷನ್ 8 ಗೆ ಜಾಯಿಂಟ್
ಅಲ್ಲ,
ಪೊಸಿಷನ್
ಡಿಕ್ಲೇರೇಷನ್
ಏನಕ್ಕೆ ಬೇಕು?
ಅವ್ರು ಡಿಕ್ಲೇರೇಷನ್ ಕೇಳ್ತಾ ಇದ್ದಾರೆ, ಅವರ ರಿಲೀಫ್ ಡಿಕ್ಲೇರ್ ಮಾಡಿ ಅಂತ ಹೇಳಿ, ಅವರ ಶೇರ್ನ ಡಿಕ್ಲೇರ್ ಮಾಡಿ ಅಂತ. So they have to pay the. ರೆಡಿ ಮಾತಾಡ್ಬೋದು, ಮಾತಾಡ್ತೀವಿ ಸ್ವಾಮಿ, ರೆಡಿ ಇದೀವಿ.
ಎಷ್ಟು ಕೊಡ್ತೀರಿ ಹೇಳಿ? ಇವತ್ತು ಫೈನಲ್ ಹಿಯರಿಂಗ್ ಬಂದಿದೆ ಅಪೀಲ್. ಮ್ಯಾಟರ್ ಇಸ್
ಅಲ್ಲ, ನಾ
ಲಿಸ್ಟೆಡ್ ಫಾರ್
instruction
ಫೈನಲ್
to-
ಹಿಯರಿಂಗ್.
I have to obtain
Should come up.
instruction, Your Lordship.
ಎಷ್ಟು are you willing for settlement?
Yes, Your Lordship. Yes, Your Lordship. We can have a
Joint
discussion.
borrowing. We are not admitting she is the wife.
Mister, there's a sale deed, she is entitled for half.
Yes, you are. Can I have last statement?
She is entitled for half.
I am entitled for.
And you please wait. She also says that she is the wife of G. Narayan Murthy.
There is no distribution for the first wife. Wife in the first wife, you ಯಾವುದೇ ಡಿಸ್ಟ್ರಿಬ್ಯೂಷನ್ ಆಗಿಲ್ಲ, ಯಾವುದೇ ತರದ್ದು ಇದಾಗಿಲ್ಲ. ಓನ್ಲಿ ಇವರು ಅಲ್ಲಿ ಹೋಗಿ ಕೆಲಸ ಮಾಡ್ತಾ ಅಲ್ಲಿ ತಮಿಳ್ನಾಡಿಂದ ಬಂದಾಗ ಇವ್ನ ಅಂಗಡಿನೆಲ್ಲ ಎಮ್ಮ ಬಂದ್ ಕೆಲ್ಸಕ್ಕೆ ಸೇರ್ತು, ಇಬ್ಬರಿಗೂ ಅಟ್ಯಾಚ್ಮೆಂಟ್ ಬೆಳೀತು, ಒಬ್ರು ದುಡಿದ್ರು, ಪ್ರಾಪರ್ಟಿ ತಗೊಂಡು. ದಿಸ್ ಇಸ್ ಅ ಫ್ಯಾಕ್ಟ್.
300 ಅಡಿ ಸ್ಕ್ವೇರ್ ಫೀಟ್ ಒಳಗೆ ಏನ್ ಡಿವೈಡ್ ಮಾಡ್ಕೊತಿರ್ತಿ? ಕಮ್ ಅಪ್ ವಿತ್ ಸಮ್ ಸೆಟಲ್ಮೆಂಟ್.
ಅಲ್ಲ, ಅದನ್ನ ಅವರು ಎಷ್ಟು ಅಮೌಂಟ್ ನನಗೆ ಐಡಿಯಾ ಇಲ್ಲ, ಏನ್ ಯಾವ ಏರಿಯಾ ಏನ್ ಕಥೆ ಆಗ್ತದಿಲ್ಲ.
ಅಲ್ಲ, 300 ಅಡಿ ಚೋಳನಾಯಕನಲ್ಲಿ ಏನು? ಚೋಳನಾಯಕನಲ್ಲಿ ಇರೋದು ಚೋಳನಾಯಕ್ must be about 7,000 to 8,000 rupees per square feet, or maybe 10,000 rupees per square feet. ಚೋಳನಾಯಕನಲ್ಲಿ.
Swamithalli, at the time of marriage of defendant, there was a family settlement, Your Lordship. He has given an entire house 30-40 measuring 2-storied building has been given to the plaintiff, Your Lordship. That is in exhibit P8, Your Lordship, D8, Your Lordship. ಸೆಟಲ್ಮೆಂಟ್ ಮಾಡ್ಕೊಂಡು ಅವರಿಗೆ ಒಂದು ಎಂಟೈರ್ ಬಿಲ್ಡಿಂಗ್ ಅನ್ನೇ ಬಿಟ್ಕೊಟ್ಟಿದ್ದಾರೆ. ಇದು ಮಾತ್ರ 300 ಸ್ಕ್ವೇರ್ ಫೀಟ್ ಬರ್ತಾ ಇದ್ದಾರೆ.
ಅಮ್ಮವ್ರನ್ನ ಕೇಳ್ತೇನೆ, ಅವ್ರ ಸೆಟಲ್ಮೆಂಟ್ ಗೆ ಏನಾದ್ರು ಒಪ್ಕೊಂಡ್ರೆ ಅವರಾದ್ರೂ ಕೊಡ್ಲಿ, ನಾವಾದ್ರೂ ಕೊಡ್ತೀವಿ.
Yes, are you willing to settle? 1 week ಟೈಮ್ ಕೊಡ್ತೀನಿ, ಸೆಟಲ್ಮೆಂಟ್ ಮಾಡ್ಕೊಳ್ಳಂಗಿದ್ರೆ ಮಾಡ್ಕೊಳ್ಳಿ. Otherwise the decree is correct. Within 1 week you should settle, otherwise we will close it.
2 weeks may be granted, Your Lordship. No, I have to obtain the
2 weeks
instruction.
ಬೇಡ, ಹಂಗೆ I'll decide the case. Argument ಮಾಡ್ಬಿಡಿ. I'll decide the case, you please argue. I'm giving you this offer of settlement because the property is very small. It's a 300 square feet property. It can't be divided into 2 shares. So better you settle it. Pay some 10 lakhs and close it.
No, I will ask you. Otherwise, I am ready to pay this back.
You are ready, and she is living there, mister. She is living there.
ನೋಡೋಣ, ನನಗೆ
ನೋಡಿ
ಎಷ್ಟು ಅನ್ನೋದು ಗೊತ್ತಿರೋದಿಲ್ಲ. Can I will ask you?
ಬರ್ಕೊಳ್ಳಿ.
She is leading her life by selling
and the vegetables for the respondent. Having regard to the fact that the suit property is only 300 square feet, this court felt it appropriate to counsel the parties for a settlement. Hence, the parties are directed to work out a settlement. List on yavattu vending on next week or next Thursday na
Second April. Friday holiday.
9th April.
Please, Your Lordship.
9th April. Settle it if you want. Otherwise, you can tell your client 50% will confirm the judgment of the trial court. V. Prabhakar.
Serial number 56, V. Prabhakar.
P.V. Raju.
It is a suit for mandatory, permanent and
On the last date, my lord, your lordship had
suit
directed
filed,
the appellant to furnish copies of the paper books. They have not given me till today. It has been noted also.
ನಿನ್ನೆ ನಾನು ಅವ್ರು ಕೊಡ್ತೀನಿ ಅಂತ
ಏನ್ ಮಾಡ್ತೀರಾ ಪ್ರಭಾಕರ್? ಐ ಕಾಂಟ್.
ಅಲ್ಲ, ಇದರಲ್ಲಿ ಹೌ ಸೂಟ್ ಈಸ್ ಮೈಂಟೈನಬಲ್ ಅಂತ ಕ್ವಶನ್. The trial court has granted some reliefs.
Learned counsel for the appellant has handed over the paper books.
R3 ಎಲ್ಲಾರು ಕೊಟ್ಟಿದ್ದೀನಿ. ಇವರು ಡಿಸ್ಮಿಸ್ ಆಗಿದೆ, ಅವರು ಇದಾಗಿದೆ.
Counsel for the respondent number 3 who seeks time to address arguments. List on so and so.
2nd April. 57.
And the blame comes on the court
ಅಲ್ಲ
always.
ನಾನು ಇಲ್ಲ ಅವರು ನಮ್ಮ ಕೊಲಿಗೆ ಏನ್ ಮಾಡಿದ್ದಾರೆ ಎಲ್ಲ ಕೊಟ್ಬಿಟ್ಟಿದ್ದಾರೆ ಅಂತ ನಾನು ಅನ್ಕೊಂಡ್ಬಿಟ್ಟೆ ಒಂದು ಕಾಪಿ.
ಕೊನೆಗೆ ಬ್ಲೇಮ್ ಬರೋದು ಕೋರ್ಟ್ಗೆ. ಕೋರ್ಟ್ ನವ್ರು ತೀರ್ಮಾನ ಮಾಡೋದಿಲ್ಲ. ಕೋರ್ಟ್ ಅವ್ರು ಸುಮ್ಮನೆ ಇರ್ತಾರೆ.
ಫೇರ್ ಆಗಿದೆ ಕೊಡ್ಬೇಕಾಗಿರೋದು ನಂದು.
ಫೇರ್ ಆಗೇ ಇದ್ದೀರಾ, ನೋಡಕ್ಕೂ ಫೇರ್ ಆಗೇ ಇದ್ದೀರಾ ನೀವು. But you are not fair.
ಅಲ್ಲ I am fair.
You are fair, I know it. I can see it.
Sometimes due to circumstances we can't avoid something.
Last time when the matter was listed, I told you to serve a copy.
ಅವತ್ತು ಇದು ನಾನು ಕೊಟ್ಟಿದ್ದಾರೆ ಇಲ್ಲ ಅಂತ
ಸಪ್ಪಣ್ಣನವರು ಬಸವರಾಜ್ ಶಿವಪ್ಪ
ಅವರು ಬೇರೆಯವ್ರಿಗೆಲ್ಲ ಕೊಟ್ಟಿದ್ದೀವಿ, ಯಾವಾಗಲೇ ಕೊಟ್ಬಿಡಿ.
Some inconvenience. Actually, I am ready, my lord.
Please go on.
The respondent number 1.
Next one, 15th or 22nd. I will argue the matter, my lord. I will get ready.
Everybody has a reason for an
No, I will get
adjournment.
ready, my lord.
Please start. Please let us, another 8 minutes at least you start.
Yeah, that I can do, my lord.
ಹೇಳಿ. ಏನ್ ಸೂಟ್ ಏನು?
My lord, this is food for declaration.
Suit is decreed or dismissed?
So, I am the defendant number 1 before the trial court, my lord. And the respondent number 1 is the plaintiff. Respondent number 2 is the defendant, my lord. My suit came to be, the suit came to be decreed by order dated 3/1/2023, my lord. This is suit for the relief of declaration to declare that the plaintiff is the absolute owner of the suit's property, which is a site property measuring east to west 41 feet and north to south 29 feet, and to declare that the judgment and decree dated 30/11/2002 passed in OS 353/1991 on the file of 8th additional city civil judge and Bangalore is collusive, fraudulent, void and not binding on the plaintiff, and permanent injunction to restrain the defendant number 1 from interfering with the peaceful position enjoyment, my lord. The case of the plaintiff is that, my lord, he has purchased the suitable property from the defendant number 2 under the register CLD dated 29/1/2001, and his vendor has purchased the same under the register CLD dated 25/3/1985 from Chamraj Pet Art Silk and Handloom Weavers and Exporters Association. It is his further case that later he came to know that the defendant number 2, who is none other than the vendor of the plaintiff, has filed the suit in OS 253/1991 against the husband of defendant number 1, and the same came to be dismissed on 30/11/2002. And in the said suit, both the husband and defendant number 1 and also the defendant number 2 colluded with each other. My lord, I have filed the written statement. My case is that I am the defendant number 1. My case is that the suit itself is barred by limitation for the reason that the CLD dated 4/4/1990
Sir,
executed.
please give me the facts. First of all, you please give me the facts.
These are the facts, my lord. The plaint I brought to your lordship's kind attention. A written statement, my contention, my.
The suit is filed to set aside some judgment passed in.
Judgment.
ಅದನ್ನ ಹೇಳ್ಬೇಕಲ್ವಾ?
ಅಲ್ಲ ಅದು ಹೇಳಿದೆ ಬಂದಿದೆ ಅದು OS number 353/1991. ಅದು ಹಿಂದೆ the vendor of the plaintiff has filed that suit, my lord. That has been dismissed in the year 2002. And my contention is that the suit itself is barred by limitation for the reason that my husband has purchased on 4/4/1990 under the shell deed, that is Exhibit D1. That has not been challenged within the time.
There are 2 sale deeds executed by the association.
Yes, my lord.
One is in favor of defendant number 2.
Oh, yes, my lord.
That is 25/3/85.
Yes, my lord.
And the sale deed in favor of husband of defendant number 1 was executed when?
4/4/90. But members are different, my lord.
4/4/1990.
My lord. President and secretary are different. My case is that those who have executed sale deed in favor of the second defendant were not the office bearers. It is my case. That is the crux of the case, my lord.
Yes.
And I have taken a condition that the suit is barred by law of limitation because my sale deed is dated 4/4/1990. That came to be that was not challenged on time. And my further contention is that the suit is hit by the principles of res judicata for the reason that issues involved in OS 353/1991, which has been filed by defendant number 2, and in the present suit are one and the same. And the defendant number 2, under whom the plaintiff is claiming his right, is the plaintiff in OS 353/1991. And the plaintiff has stepped into the shoes of the defendant number 2. And the issues in question have already been heard and decided on merits. It is my contention. My next contention is that when the suit filed by the defendant number 2 in OS 353/1991 to declare his title over the social property has been dismissed, the plaintiff does not derive any right over the same, as the title of the defendant number 2 was negatived by the judgment and decree passed in OS 353/1991, and the defendant number 2 has lost his alienable title. It is my case, my lord, and further my case is that the sale deed came to be executed in favor of the plaintiff on 29/1/2021 during pendency of the suit in OS 353/1991. That was not yet decided. It was decided in the year 2002. During the pendency of the suit filed by defendant number 2, the plaintiff has purchased the property from defendant number 2. And I have specifically denied in my written statement as to the allegation of collusion in between my husband and the defendant number 2 in filing the suit.
Who is this K. Varadaraj?
Varadaraj is my husband, husband of the defendant number 1.
So that suit was compromised.
No, my lord, it was dismissed. 353/1991 was dismissed on merits. That was filed by the defendant number 2 against my husband. It was contested and it was dismissed.
That suit was dismissed.
Dismissed. It was in the year 2002. During the pendency of the suit in the year 2001, he has sold the property in favor of the.
But your sale deed was set aside in 25/1997.
ಅದು 1997 1997 ಅಂದ್ರೆ that's cancellation of sale deed, my lord. ಅದು cancel of sale deed. My case is that those who have cancelled my sale deed are not at all the members. They are unconcerned persons and I am not a party to it.
Yes.
And next, my lord, my contention is that suit is barred by law of limitation, and I have taken a contention of res judicata. So these are the pleadings, my lord, and I will argue in detail, my lord. Short. I will come to the grounds of.
No, we can't adjourn it just like that, sir.
My humble request, my lord.
Yeah, the danda katbekashte. You have to pay some cost. That is listed for final hearing.
Yes,
all lawyers want adjournment.
I am ready, actually, but.
Correct. If you're ready, then you should argue.
Yeah, only this time.
The learned counsel for the appearance seeks
only
time.
This time.
Since the appeal is listed, my roster begins from 2023.
ನಾನು ready, ನಾನು ಮಾಡ್ಬಿಡ್ತೇನೆ, my lord. Next, ಮಾಡ್ಬಿಡ್ತೇನೆ.
ನಾವು ನಮ್ಮ ಕಷ್ಟ ನೀವು ಕೇಳ್ತಾ ಇಲ್ಲ. ನನ್ನ ರೋಸ್ಟರ್ 2023 ಇಂದನೇ ಶುರು ಆಗೋದು. So therefore you can't avoid.
ಇಲ್ಲ, ನಾನು ಮಾಡ್ಬಿಡ್ತೇನೆ next time.
Since the appeal is filed, since the appeal is listed for final hearing,
15.
Request for adjournment is not justified. Nonetheless, as a last chance list on
15/4. 15/4. ಅಥವಾ
8
or 9.
9th April, subject to payment of cost of rupees 2,000 payable to the Advocates Clerks Association.
Yes. Ablation.
58 urgent, 59, Prasanna Kumar CS.
ನಿಮ್ಗೆ ಇಂಟಿಮೇಟ್ ಮಾಡಿಲ್ವಾ?
ಇಂಟಿಮೇಟ್ ಮಾಡಿದ್ದಾರೆ, ಡೇಟ್ ಕೊಟ್ಟಿಲ್ಲ.
ಕೊಟ್ಟಿದ್ದಲ್ಲ, ಡೇಟ್ ಕೊಟ್ಟಿದ್ದೆ. ಪ್ರಸನ್ನ ಕುಮಾರ್ CS.
Kumar CS number 59, Prasanna Kumar CS.
Prasanna Kumar CS. CS Prasanna Kumar. Somsekhar Naidu.
Milords, appearing for the respondent number 1, Milords. Milords, we recently came on record through a paper publication. Milords, I kindly request a short date before this honorable court, Milords, for filing our objections to the main petition.
There's no concept of filing objections to the main petition. This is an appeal.
Yes, Milords.
In appeal, you don't file objections. You will argue based on the material before the trial court.
Milords, the suit was filed, there was a delay of around 1,182 days, Milords, and the court recently condoned the delay in the month of January.
Delay is condoned. Matter is appearing for final hearing, Mr.
Yes, Milords. Yes, Milords. Milords, we just need a few time, Milords. Recently the client came to us with the instructions.
Please keep it in mind. There's no concept of filing objections to the appeal.
Please, Milords, yes.
The first appeal, there's no question of filing objections.
Please,
objections allela file ಮಾಡಿದಿರಲ್ಲ trial court ಅಲ್ಲಿ.
Milords, the trial court decree ex parte ಆಗಿರೋದು, this the person who's claiming the property, the scheduled property, Milords, is actually the person who's saying that he got the property from the previous owner in the year 1967, my lords. That being the factual scenario, my lords, he was not a party to the suit filed in the OS before the trial court, my lords. He has come before this honorable High Court.
Should we allow this appeal?
No, my lords, senior instructions ಅದು ಮಾಡಿಲ್ಲ my lords. Kindly, my lords, ಒಂದು short date ಕೊಡಿ my lords. Senior ಬಂದು argue ಮಾಡ್ತಾರೆ ಇದನ್ನ.
When did you enter appearance?
My lords, on 31, my lord, 37 of 25, my lords. We filed our wakalat on that time.
The learned counsel for the respondent, the learned counsel for the appellant is absent. The learned counsel for the respondent number 1 seeks time. The last chance list on so and so, subject to the appellant and the respondent paying a sum of rupees 1,000 each to the Advocates Clerks Association.
Please, my lords.
CB Manjunath. Ready? Mutturaju. Why Mutturaju, you don't come to the court? A criminal petition ಯಾಕೆ ಬರಲ್ಲ? ನೀವು ಮುತ್ತುರಾಜನ್ ನೀವೇನಾ? ಮುತ್ತುರಾಜ್ ಹೆಚ್ಚೆ ಕ್ರಿಮಿನಲ್ ಪಿಟಿಷನ್ ಯಾವ್ದು ಹಾಕಿದಿರಲ್ಲ? ನೀವು ಹಾಕಿಲ್ಲ? ನೀವು ರೆಸ್ಪಾಂಡೆಂಟ್ಗೆ ಇಲ್ವಾ? ನೋಡ್ರಿ ಇದೆ ಮುತ್ತುರಾಜ್ ಅಲ್ವೇನ್ರಿ? ವೈ ಯು ಡೋಂಟ್ ಕಮ್ ಟು ದ ಕೋರ್ಟ್? ಯಾವ್ದು ಕ್ರಿಮಿನಲ್ ಪಿಟಿಷನ್ ಹಾಕಿದಾರ ನೋಡಿ. ಯಾವ್ದು 498A ಕೇಸಲ್ಲೆಲ್ಲ ಅಪಿಯರ್ ಆಗಿದ್ದೀರ. ಏನ್ ಬುಕ್ ಕೀಪಿಂಗ್ ಇಲ್ವಾ? ಬುಕ್ ಕೀಪಿಂಗ್ ಇಲ್ಲ ನಿಮ್ಮ ಆಫೀಸಲ್ಲಿ? ಚೆಕ್ ಮಾಡಿ ನೋಡ್ರಿ ಅದು. ಮುತ್ತುರಾಜ್ ಅಂತ ಬೇರೆ ಯಾವ ಲಾಯರ್ ಇಲ್ಲ ಇಲ್ಲಿ. ಹೌದಾ? ನೋಡಿ ಚೆಕ್ ಮಾಡ್ರಿ ಯಾವ ಮುತ್ತುರಾಜ್. ರೆಡಿಯಾ? ವಿಲ್ ಟೇಕ್ ಇಟ್ ಅಬೌಟ್ 2:30.
Lordship, one humble submission before this court, my lordship. Serial number 7, my lordship. I complained the office objection. Needful has been done, my lordship.
Copy to opposite.
Copy has been served to opposite advocate also.
When counsel for the appellant submits a needful is done. Office is directed to check and verify and list for admission if office objections are complied on 2nd April. 2nd April.
59.
ಅರ್ಜನ್ ಆಗಿದೆಯಾ? ಸೋಮಶೇಖರ್ ನಾಯ್ಡು.
My lord, one submission, my lord. Serial number 7, when opposite advocate is also present before this court. Matter may be referred to the mediation, my lord.
Do not, Yadunandan. Or could the learned counsel for the appellant and the learned counsel for the respondent submit, so the parties may be referred to mediation. Hence, parties are directed to appear for mediation on
16/4, my lord.
16/4.
Grateful.
At 11 a.m.
My lord, serial number 61, my lord, appearing for the appellant. Senior counsel has some personal inconvenience today.
Madam, you have been saying this is the second time it's being
Next
listed.
week, my lord.
This is the second time.
Finally, next week, my lord. There's some personal inconvenience today, my lord.
Yaar senior counsel yaar
Emma Rajgopal.
is not well.
No, my lord, there's part-heard matters in 2 courts, my lord.
Last time when you were time then you have to pay. Mr. Rajgopal is averse to paying cost, but I can't help it.
My lord, one short accommodation.
We will give you accommodation, but you have to pay cost, madam. It doesn't come free.
My lord, any day next week, my lord.
Yavat, Pradeep, any objection? Learned counsel for the appellant seeks time. On the last date also, the learned counsel for the appellant had short time. So hence list on so and so, 2nd April, subject to payment of cost of rupees 2,000, payable to the clerks association. 5,000. Huh? What do you want?
My lord, no cost.
Without cost, no. 2,000 payable to the Advocates Clerks Association. Please.
59, no? Rajan,
59, here.
I'm sorry, I was little present.
Somshekhar Naidu. Arjan ಆಗಿದೆಯಾ? Arjan ಆಗಿದೆ ಅಂತ.
Then I'll come.
1,000 rupees and ಇಬ್ಬರಿಗೂ ಕಾಸ್ಟ್ ಹಾಕಿರಿ. Clerks Association. ಪಾಪ ಅವ್ರಿಗೂ ಏನೋ ಸ್ವಲ್ಪ.
ಅಲ್ಲ ಕೊಡ್ತೀನಿ ನಾನು. It's my fault. Little late I was there.
CB Manjunath.
Pronouncement of orders, 230 matters, serial number 69. Pradeep Saukar.
For the petitioner.
For the respondent.
Petition is dismissed.
Great.
Please.
Number 70, Lata Shetty.
Appear for the petitioner, my lord.
Petition is dismissed.
First door matter, serial number 45.
VB Sidramaya.
VB Sidramaya. First door matter, serial number 45.
VB Sidramaya. Barkoli. This is a plaintiff's appeal challenging the judgment and decree dated so and so. Sorry, challenging an order dated so and so, passed by so and so in OS number 169 of 2018, by which the plaint was rejected as it did not disclose cause of action and that it was barred under Order 23, Rule 3 of CPC. Next para. The suit in OS number 169 of 2018 was filed for partition separate possession of the plaintiff's 1/5 share in the A shell property and B shell property. Full stop. The plaintiffs claimed that they are the children of Chikka Timmaya, son of Dodda Timmegowda. Full stop. They claim that the A shell properties was purchased by their father in terms of a sale deed dated 14/4/1959, and after his death, they were in possession of the said property. They claim that the B shell properties were the undivided family properties of the plaintiffs and the defendants. Full stop. They claim that their uncle filed OS number 28 of 1991 before the Principal Civil Judge Junior Division Tumkuru against their father and his other brothers for partition. In the said suit, the properties involved were land in survey number 11/1 and 26/3 of the A schedule, 26/3, which are presently included in the A schedule. And another property which is shown as item number 6 in the B schedule. The said suit was compromised full stop. They claim that they are never allowed the defendants to divide the B shell properties as per the compromise decree drawn in OS number 28/91. Full stop. Therefore, they filed the instant suit for claiming their 1/5 share in the suit shell properties. Full stop. The defendant the defendant 1, 3, and 8 filed the written statement contending that the properties were already divided as per the compromise decree passed in OS number 28/1991, and that the said compromise was acted upon. Full stop. They claimed that once the properties were divided, there's no question of the joint family continuing, and hence claimed that there was no cause of action for the suit and that the suit was hopelessly barred by limitation, as the plaintiffs proposed to challenge a compromise drawn up in OS number 28/1991. Full stop. Based on these contentions, the trial court framed issues and set down the case for trial. The plaintiff was examined and he marked documents. And when the suit was listed for cross-examination of PW1, an application under Order 7 Rule 11A and D of CPC was filed by the defendants 1, 3, and 8 on the ground that the plaintiff did not disclose, on the ground that there was no cause of action to file the suit and the suit is barred by limitation, and also under Order 33 Rule 3A of CPC. Full stop. This application was objected by the plaintiffs, who claimed that the compromise decree in OS number 28 of 1991 is not lawful. Full stop. The trial court, after considering the contentions of the learned counsel for the contentions of the plaintiffs and the defendants 1, 3, and 8, passed an order allowing the application and rejecting the plaint under Order 7 Rule 11A and D of CPC. Being agreed by the said judgment order, the plaintiffs are before this court. Next para. The learned counsel for the plaintiffs contended that the decree in OS number 28/1991 is fraudulent, as all the properties of the family were not included in the said suit. Full stop. He claimed that though the plaintiffs had filed OS number 600/2015 for partition separate possession of all the properties of the family, the said suit was dismissed for non-prosecution. He contended that the defendants had selectively obtained a compromise decree in respect of valuable properties, and therefore the plaintiffs were advised to seek for their legitimate share in the suit shell properties. He thus contends that the trial court could not have rejected the plaint on the ground that it did not disclose cause of action and that it was barred under Order 23 Rule 3 of CPC. Full stop. Per contra, the learned counsel for the defendants 1, 3 and 8, submitted that the plaintiffs have filed a suit virtually challenging the compromise recorded in OS number 28/1991. He contends that the father of the plaintiffs was a party to the suit in OS number 28 of 1991 and that he during his lifetime did not challenge the correctness of the compromise recorded therein. Therefore, he contends that the plaintiffs who are claiming through the defendant in OS number 28/1991, cannot challenge the compromise reported in the said suit. He submitted that under Order 23 Rule 3, a separate suit to challenge a compromise on the ground that it is fraudulent is not maintainable, and hence the trial court was right in invoking Order 23 Rule 3 of CPC to reject the plaint. Full stop. I consider submissions of the learned counsel for the plaintiffs and the learned counsel for the defense 1, 3 and 8. Next para. But what about the other properties? What about the other 3 properties?
All these 3 properties are subject matter of earlier suit, my lord.
That is OS 600.
Yes.
But that was dismissed for non-prosecution.
No, earlier. The father enters into a compromise decree along with his
No, but
siblings.
in this suit, what are the suit properties? A property nalli, see, he says that the land in survey number
Lord, there are
11/1.
1/1.
11/1.
B schedule, A schedule properties.
Item number 1.
11/1.
And 26/3.
The survey number 13 is there.
Now, how in so far as survey number 13 is concerned, shouldn't the suit continue?
My lord, it is both these survey numbers are subject matters of earlier suit, my lord.
In OS 28?
Yes. Subsequently, my lord, pursuant to the partition decree, father expires.
So all these properties were subject matter of the old.
Yes.
The old suit 28/2000 decree idea nimatra. Now he says in the plaint in the first paragraph, page 3 nalli. He says in the said suit only 2 survey numbers 11/1 and 26/3 of A schedule and item number 6 of B schedule. Do you have a decree in OS 28 of 1991?
I do not possess the decree, my lord.
Ilva.
Your lordship would have the matter on Wednesday. I'll produce all the relevant records so that there is.
No, if otherwise the suit will have to be rejected only insofar as those properties.
These properties are concerned.
In respect of those properties which is the subject matter of the compromise.
Yes.
But if there are other properties, how can
that could be excluded? I'll ascertain.
List tomorrow. Yes. Dictation ಆಗೋಗಿದೆ ಅದಕ್ಕೋಸ್ಕರ.
My apologies.
Yes.
Serial number 60. GB Manjunath.
Mitturaj.
Respondent number 1.
plaintiff's appeal. Suit filed for partition. Partition and separate possession of 1/3 share each in item number 1 to 3.
ಅವ್ರದ್ದು ಯಾವ್ದು
1 and 3.
ಐಟಮ್ ಅವ್ರದ್ದು ಮಾತ್ರ ಕೊಡಿ. ಪ್ರದೀಪ್ ಸಾವ್ಕಾರ್, ಪ್ರಶಾಂತದ್ ಮಾತ್ರ ಕೊಡಿ. Yes.
Item number 1 and 3. Partition and separate possession of each 1/3 share. And IA1 find not to disperse the FD amount in favor to the third respondent lying in third defendant bank. So the trial court granted the decree in respect of item number 1 and item number 3, 1/3 share each. So far as item number 2 is concerned, the prayer was to declare that the sale deed dated 13/4/2012 executed by plaintiff's parents in favor of defendant number 2 in respect of the plaint item number 2 is not binding. The trial court granted the decree in respect of items 1 and 3 and in respect of item number 2 dismissed the suit, holding that the property sold by Siddharajamma, that is mother of the parents, is her self-acquired property. Hence, they are not entitled for.
Item number 2 ಬಗ್ಗೆ ಏನಿದೆ?
Item number 2 ne ಇದು land, 5 untas of land.
What is the declaration sought for?
Declaration sought for to set aside the sale deed. To declare that the sale deed executed by the plaintiff.
Not binding and
Not binding.
Set aside and ಕೇಳಿಲ್ಲ.
ಕೊಡಿ ಇದೆ LCR ಪೇಪರ್ ಬುಕ್ ಹಾಕಿದ್ಯಾ?
Plaintiff.
ಆಯ್ತು ಮುತ್ತುರಾಜ್ ಕೂತ್ಕೊಳ್ಳಿ. Take rest for some time.
ಆಗ್ಬೋದು.
Sale deed executed by the plaintiff's late father and mother 13/4 in favor of the defendant number 2, not binding by the plaintiffs. So now the RFA is only in respect of item number 2 only.
This appeal is filed with defendant number 2.
No. Plaintiffs have filed.
Plaintiffs have filed.
Plaintiffs have filed. Plaintiffs appeal.
ಅದು ಡಿಗ್ರಿ ಆಗಿಲ್ವಾ?
ಆಗಿಲ್ಲ item number 2 ಗೆ.
But what does the trial court say about item number 2?
Item number 2 trial court says that it is the self-acquired property of Siddharajamma.
ಅಲ್ಲ ಇದ್ರಲ್ಲಿ ಆಪರೇಟಿವ್ ಪೋರ್ಷನ್ ಎಲ್ಲಿ ಹೇಳಿದ್ದಾರೆ? ಆಪರೇಟಿವ್ ಪೋರ್ಷನ್ ಎಲ್ಲಿ ಹೇಳಿದ್ದಾರೆ?
The suit of the plaintiff is hereby partly decreed in the following terms. It is hereby declared that the plaintiffs are at page 72, my lord. Partition and separate possession of their 1/3 share of each in the plain schedule item number 1 property by meets and bounds. The defendant number 3 bank is hereby directed to release the fixed deposit amount which is plain schedule item number 3 property herein in favor of plaintiff number 3 who has been appointed as nominee, who in turn directed to distribute the said fixed deposit amount equally to an extent of 1/3 share to the plaintiffs 1 to 3. The plaintiffs are also entitled for equal distribution of savings amount lying in the savings account of the late Siddharajamma, maintained with defendant number 3 bank to the extent of 1/3 share each. Under the circumstances of the case, the parties are directed to bear their own cost.
Item number 2 ಬಗ್ಗೆ ಎಲ್ಲಿದೆ? Yes.
The plaintiffs are hereby directed to pay requisite court fee on their declaratory relief sought for with respect to plain schedule item number 2 property immediately.
ಎಲ್ಲಿದೆ ಐಟಮ್ ನಂಬರ್ 2 ಬಗ್ಗೆ ಎಲ್ಲಿದೆ?
ಕೋರ್ಟ್ ಫೀ ಕೊಡ್ಬೇಕಂತ ಅಷ್ಟೇ ಹೇಳ್ತಾರೆ ಅವರು.
Whether
ಐಟಮ್
suit is
ನಂಬರ್ 2
dismissed-
ಬಗ್ಗೆ
Whether suit is dismissed in respect of item number 2 or not. ಆಯ್ತು ಹೇಳಿ. This sale deed is executed by your parents.
Mother Siddharajamma.
So what is wrong with the order?
Wrong in the order is that, my lord, it is the joint family property of the Siddharajamma and Rudrappa, husband, parents. This property, the land in question is 5 guntas, suit has been filed for adverse possession, declaration that I am the perfected by title by adverse possession. This 5 guntas of land is in possession of the parents, Siddharajamma and Rudrappa. Siddharajamma suit has been filed to declare that we are in adverse possession, judgment and decree, for the declaration of judgment and decree. So the suit has been filed. Last occasion, your lordship asked me for the plaint. Pass on the plaint. In the plaint, my lord, in respect of item number 2 scheduled property, that your lordship will kindly see from para 2. Para 3, my lord. The plaintiffs respectfully submits that she is the owner of the scheduled property bearing survey number 139, 2 acres out of 2 acres, 2 guntas. Out of which 5 guntas situated at Yaradanahalli village, Attibele Hobli, Anekal Taluk, Bangalore district, which is more fully described in the schedule hereunder, referred hereinafter referred to the scheduled property. The plaintiff is in peaceful possession and enjoyment of the suit scheduled property since from past 13 years. Since 13 years back, the plaintiff has invested huge amount and improved the same and raised various crops in the suit scheduled property. The plaintiff perfected her right, title and interest and possession of the suit scheduled property by way of adverse possession. The plaintiff further submits that the defendant is no way manner of right, title and interest, much less possession in and over the suit scheduled property, and attempted to interfere with the plaintiff's peaceful possession and enjoyment of the suit scheduled property. That on 12/12/93, when the plaintiff is in peaceful possession and enjoyment of the suit scheduled property, the defendant along with his supporters, henchmen and other persons came near the suit scheduled property and attempted to dispossess the plaintiff from the suit scheduled property. The plaintiff resisted the illegal and unwarranted acts of the defendant with great difficulty, and finally the defendant left on the spot with a challenge that at any moment he may dispossess the plaintiff from the suit scheduled property. In that event, the plaintiff will be put to irreparable loss, injury and hardship will be put to hereunder, for plaintiff is a very poor lady having no support in the locality. But the defendant is a very powerful person in the locality, having the supporters of men, money and influence. If the defendant is not restrained by means of order of permanent injunction, definitely the defendant will be put to dispossess the plaintiff from the suit scheduled property. In that view, in that event, she will be put to irreparable loss, injury and hardship will be caused to her. The plaintiff has also approached the jurisdictional police for help. but the said police inter directed the plaintiff to approach the civil court as the matter is in civil nature. Hence, the plaintiff has no other alternative remedy except to approach this honorable court for the relief of declaration and permanent injunction. The cause of action for the suit arose on 12/12/93 when the defendant attempted to dispossess the plaintiff from the suit scheduled property and in subsequently within the territorial jurisdiction of this one. The suit for declaration and consequential relief of injunction is the court fee of rupees 25 so and so is here paid on the plaintiff under section 34B of the Karnataka. Wherefore, the plaintiff above named prays that this honorable court may please to pass a judgment and decree against the defendants for declaration, declaring that the plaintiff is the absolute owner in possession and enjoyment of the suit scheduled property by way of adverse possession. The permanent injunction restraining the defendants agents from so and so from acting on behalf of so and so from the plaintiff scheduled property. Award cost.
What is the mistake, sir? What is the, see, the property came to your mother in terms of a decree passed in OS number 903 of 1993.
Yes.
They have sold it to the defendant number 2. How do you say that you are entitled to a share there?
The reason is this, my lord. Siddharajamma, that is the mother, is not having any independent income. This property is not her Sridhana property or any.
Correct, but she is filed the suit for.
No. The suit has been filed by the family members in her name. That's all.
Yes.
She is not having any income. Out of the income derived from this one, it has been with
How old were
arrangement.
you?
It has been purchased.
How old were you in 1993? How old were you in 1993?
93, my lord, is younger.
2021 ಅಲ್ಲಿ.
22
ವರ್ಷ.
22 years.
22 years. And ಯಾರು ಇವರು 46, 37.
Father and mother, father has these properties has been acquired from the joint family funds, my lord.
Acquired ಅಲ್ಲಿ ಸರ್, it's a adverse possession.
ಅಲ್ಲ ಅಡ್ವಾನ್ಸ್ ಪೊಸಿಷನ್ ಬಟ್ ಪ್ರಾಪರ್ಟಿ ಅವರು ತಗೊಂಡಿರ್ತಾರೆ, ಅದು ರಿಜಿಸ್ಟರ್ ಸೇಲ್ ಡೀಡ್ ಆಗಿಲ್ಲ, ಇದಾಗಿರಲ್ಲ, ಆಮೇಲೆ ಅವರು ಅಡ್ವಾನ್ಸ್ ಪೊಸಿಷನ್ ಅದೆಲ್ಲ ಪ್ರೀಡಿಂಗ್ಸ್ ಅಲ್ಲಿ ಇಲ್ಲ. ಆಕ್ಚುಲಿ ಇಸ್ ಲೈಕ್ ದಿಸ್. So she has filed adverse possession.
Now we are in an appeal. We are in an appeal, so we are bound by the pleadings.
Yes,
made in the plaint.
compromise entered into compromise in the civil court and it is ended in compromise. They have left the 5 guntas of land in favor of us, in favor of Siddharajan. She was not having any income. She has not acquired this property. So family members were in possession and enjoyment, and suit has been filed by Siddharajamma. One of the family members has filed.
Yes.
So this is a property of the nucleus, from the joint family nucleus. It has been came into possession of the plaintiff's father and all.
ತಿರ್ಗಾ ನ್ಯೂಕ್ಲಿಯಸ್ ಅಂತ ಹೇಳ್ಬೇಡಿ. ಇಟ್ಸ್ ನಾಟ್ ನ್ಯೂಕ್ಲಿಯಸ್. ನೀವೆಲ್ಲ ಸೇರಿ ಮಾಡ್ತಿದ್ರಿ ಅಂತ ಹೇಳಿ. ನ್ಯೂಕ್ಲಿಯಸ್ ಅಂದ್ರೆ ಹೆಂಗ?
ನ್ಯೂಕ್ಲಿಯಸ್ ಅಂದ್ರೆ ಅದು ಅದಕ್ಕಿಂತ ಮುಂಚೆ ಅದು
ಜಾಯಿಂಟ್ ಕಲ್ಟಿವೇಟ್ ಮಾಡ್ತಿದ್ರಿ. So therefore it could not have been sold only by Siddharajamma. That is your case.
Yes.
Yes.
So this has been sold, my lord. That's why you have filed the suit for this one.
Let us see what you have said in the plaint.
Plaint at page 1. Plaint at page 1, my lord, paper.
What? Where have you said that this was jointly cultivated?
I will read the plaint, my lord.
What?
Para 3. Plaintiff state that the plaintiff 1, 2 and 3 are the sons and daughter of late Rudrappa and late Siddharajamma. The plaintiff's late father Rudrappa joined BSNL on 8/11/1978 and retired from his department on 31/12/2005. The plaintiff states that the defendant number 1 also employee in BSNL and he was very close associated and good friend of plaintiff's father late Rudrappa, and he used to come often and he assisted the plaintiff's father and mother's personal work, and he know the plaintiffs late father and mother's family properties of both movable and immovable. The plaintiff states that the plaintiff late father and mother had sufficient means and got movable such as gold ornaments in different types, and they had acquired the land with the aid and financial assistance of plaintiff's father late Rudrappa. The mother of plaintiff late Siddharajamma has acquired the land and obtained the land by financial assistance of late Rudrappa. Land bearing survey number 139/1 measuring 5 guntas of Edavanahalli, Attibele Hobli, Anekal Taluk through court decree in OS number 903 of 1993 by claiming adverse possession. The said late Siddharajamma being housewife in her lifetime. It is more fully described in the under mentioned suit schedule items. The plaintiffs late state that the father of the plaintiffs purchased the property on 2/11/2000 from previous vendor H.S. Nagasudramma, and plaintiff's father built the house measuring east to west 15 feet and north to south 28 feet. This is item number 1 property. The plaintiffs state that the plaintiff's late father, after retired from his service, plaintiff's father and mother with hard-earned money and savings was kept in the third defendant bank a sum of rupees 13,50,000 in the year 2008. The third defendant bank every month transferred the interest for SB account so and so. It is more fully described in the under mentioned suit schedule items since 2008 till 19th December 2020. That is third item of the property. The plaintiff states that the first defendant with coercion and undue influence and misrepresentation and misleading by the defendant number 1 without consent or without knowledge of Rudrappa and Siddharajamma, the defendant number 1 by woodwink, they inserted his name as nominee. The nominee is the trustee to look after the welfare, supervise the profounder and distribute the actual income of the profounder, depositor, and distribute the income to all the legal heirs of the deceased person, and also distribute class 1 heirs of the deceased Siddharajamma. Even the third defendant also hand in glove with the defendant number 1 to insert and to incorporate his name as a nominee in third defendant bank. The plaintiff states that the defendant number 1 used to visit often as a good well-wishers to plaintiff's house. The plaintiff's father and mother trusted the first defendant, but the defendant number 1 applied his fraudulent misrepresentation and coercion, inserted his name as a nominee with the third defendant bank, and also the defendant number 1 brainwashed and betrayed the trust of the plaintiff's late father and mother, allegedly registered the sale deed in his wife's name, that is second defendant, by fraudulent method on 13/4/2012 at the office of the sub-registrar Basavanagudi, Bangalore. The plaintiff's late father and mother has not executed their own accord the said alleged sale deed obtained by misrepresentation and misled by the defendant number 1 at the relevant time. No necessity of money to the plaintiff's father and mother. The alleged sale deed is not binding on the plaintiffs.
ಎಲ್ಲಿ ಹೇಳಿದ್ದೀರಾ ಜಾಯಿಂಟ್ ಕಲ್ಟಿವೇಟ್ ಮಾಡ್ತಿದ್ವಿ ನಮ್ಗೆಲ್ಲ ಇತ್ತು ಅಂತ ಎಲ್ಲಿ ಹೇಳಿ? ಯು ಓನ್ಲಿ ಸೆಡ್ that the sale deed was illegally executed
by the father, by the mother.
Sorry, where have you said?
Illa, that
ಮತ್ತೆ
that has not been stated.
If that is the case, then I think what this court has done is correct. And your father, your mother did not challenge the sale deed during their lifetime. They did not challenge their sale deed during their lifetime. How can you challenge it on the ground of fraud, illegality and all those stuff?
Even this is joint family property that is.
Sir, plaint ಅಲ್ಲಿ ಹೇಳಬೇಕು. Have you said in the plaint that this was cultivated jointly by all of us? We also put in our labor. Suit for declaration was filed on behalf of the family. Grant was on behalf of the family. ಎಲ್ಲಿ ಹೇಳಿದ್ದೀರಾ? He is the briefing advocate.
Yes.
He is a briefing advocate.
Conducted the track, conducted the case in trial.
ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಚನ್ನಬಸವಣ್ಣ ನೀವೇನಾ? ಮತ್ತೆ ಅಲ್ಲಿ ಎಲ್ಲಿ ಹೇಳಿದ್ದೀರಾ?
ಇನ್ಫಾರ್ಮೇಶನ್ ಬಂತು ಸಬ್ಮಿಷನ್ ಈಸ್ ಗುಡ್ ಫ್ರೆಂಡ್ ಆಫ್
ಸರ್, ನಿಮ್ ಕೇಸ್ ಏನು? ನಿಮ್ ಕೇಸ್ ಏನು?
ಏನಾಗಿತ್ತು ಅಂದ್ರೆ
ಅಲ್ಲಿ ಏನ್ ಆಗಿತ್ತು ಅಲ್ಲ, ಏನ್ ಬರ್ದಿದ್ರೆ ಹೇಳಿ.
ಬರ್ದಿರೋದು ಏನು ಕ್ಲೈಂಟ್ ಅಲ್ಲಿ ಏನ್ ಹೇಳಿದೆ ಅದನ್ನ ಡಿನೈ ಮಾಡಕ್ ಬರೋದಿಲ್ಲ.
ಕ್ಲೈಂಟ್ ಅಲ್ಲಿ ಏನ್ ಹೇಳಿದ್ರೆ ಡಿನೈ ಮಾಡಕ್ ಬರಲ್ಲ. ಕ್ಲೈಂಟ್ ಅಲ್ಲಿ ಏನ್ ಹೇಳಿಲ್ವೋ ಅದನ್ನ ಹೇಳಕ್ ಬರಲ್ಲ. ಕ್ಲೈಂಟ್ ಅಲ್ಲಿ ಏನ್ ಹೇಳಿಲ್ವೋ ಅದನ್ನ ಇಲ್ಲಿ ಹೇಳಕ್ ಬರಲ್ಲ. ನೀವ್ ಹೇಳ್ತಿರೋದು ಇಷ್ಟೇ, ನಮ್ ತಾಯಿಗೆ ಅಡ್ವರ್ಸ್ ಪೊಸಿಷನ್ ಮುಖಾಂತರ ಬಂತು. ಬಂದ ಮೇಲೆ ನಮ್ ತಂದೆಗೆ ಡಿಫೆಂಡ್ ನಂಬರ್ 1 ತುಂಬಾ ಕ್ಲೋಸ್ ಆಗಿದ್ರು, ಇಲ್ಲಿಗಲ್ ಆಗಿ ಬರ್ಸ್ಕೊಂಡ್ಬಿಟ್ಟಿದ್ದಾರೆ ಅಂತ ಹೇಳಿದ್ರು. Therefore, you want the sale to be set aside. Is that sufficient?
Executive P 18 for me. And to Perus, after death of father, the plaintiff, he sent one letter. He defendant one who sent one letter. FD ತಗೊಂಡೋಗಿದ್ರು. He say ಬೈಂಡಿಂಗ್ ಸಿಗ್ನೇಚರ್ ಕೊಡಿ, FD ರಿಲೀಸ್ ಮಾಡ್ಕೊಡ್ತೀನಿ ಅಂತ ಒಂದು.
ಆಯ್ತು, ಅದು FD ನೀವು ಬಂದಿದೆಯಲ್ಲಪ್ಪ.
ಬರೋದಲ್ಲ.
FD ನಿಮಗೆ ಶೇರ್ ಕೊಟ್ಟಿದ್ದಾರೆ.
ಶೇರ್ ಕೊಡೋದಲ್ಲ. ಯಾವಾಗ ನಮಗೆ ನಾಲೆಡ್ಜ್ ಬಂತು ಇವರು ಅವರು ಡಿಪೆಂಡೆಂಟ್ ಒಂದು ಈಗ ಏನ್ ಕ್ಲೋಸ್ ಫ್ರೆಂಡ್ಸ್ ಆಗಿದ್ದಾಗ ಈ ಚಿನ್ನವನ್ನು ತಗೊಂಡೋಗಿದ್ದಾರೆ 150 ಗ್ರಾಮ್, ಅದು PCR ಹಾಕಿದೆ. ಆಮೇಲೆ ಒಂದು ಕೊಡ್ತಾರೆ ಲೆಟರ್ ಕಳಿಸ್ತಾರೆ ಅಂತ ವಾಟ್ಸಪ್ ಅಲ್ಲಿ ಹೋಗಿ ಎಲ್ಲ ಕೇಳ್ತೀವಿ, ಫ್ಯಾಮಿಲಿ ಫ್ರೆಂಡ್ ಆಗಿ ಕೇಳ್ತೀವಿ. ಏನಂತ ಒಂದು ಲೆಟರ್ ಕಳಿಸ್ತಾರೆ, ನೀವು ಬೈಂಡಿಂಗ್ ಸಿಗ್ನೇಚರ್ ಕೊಡಿ, ನಿಮ್ ತಂದೆ ಮಾಡೋ ಸೇಲ್ ಇರ್ಲಿ. ಅವಾಗ ಸೇಲ್ ಸಿಗ್ನೇಚರ್ ಕೊಟ್ರೆ ನಾನು ನಿಮ್ಗೆ FD ತೊಗೊಂಡು ಇಟ್ಕೊಂಡು ಅವ್ರ ಕಸ್ಟಡಿ. ಅವಾಗ ನಮಗೆ ನಾಲೆಡ್ಜ್ ಬಂತು ಸ್ವಾಮಿ, ದಿಸ್ ಇಸ್ ದಿ ಫ್ಯಾಕ್ಟ್ ಆಫ್ ದಿ ಕೇಸ್.
ಕನ್ಫರ್ಮೇಶನ್ ಡೀಡ್
ಅವರು ಆಮೇಲೆ ಒನ್ ಮೋರ್ ಥಿಂಗ್ ಇವರನ್ನ ಎಕ್ಸಿಕ್ಯೂಟಿವ್ P 8 ಅಲ್ಲಿ ಯಾವ ಎಕ್ಸ್ಟೆಂಟ್ ಚೀಟ್ ಮಾಡಿದ್ದಾರೆ ಡಿಫೆಂಡೆಂಟ್ 1 ಅಂತ ನಾನು ಸುಳ್ಳಲ್ಲ. ಎಕ್ಸಿಕ್ಯೂಟಿವ್ P 8 ಅಲ್ಲಿ ಹೇಳಬಾರ್ದು ಕೋರ್ಟಲ್ಲಿ ಆತನ ಮಿಸ್ಲೀಡ್ ಮಾಡಿ ಮಿಸ್ಗೈಡ್ ಮಾಡಿ ಆ ಸಿದ್ದರಾಜಮ್ಮನಿಂದ ಎಕ್ಸಿಕ್ಯೂಟಿವ್ P 8
ಕರೆಕ್ಟ್ ರೀ, ಅದನ್ನ ಬಾಯ್ ಬಿಟ್ಟು ಹೇಳ್ಬೇಕಲ್ವೇನ್ರಿ ಪ್ಲೈಂಟ್ ಅಲ್ಲಿ.
ಏನಾಗಿದೆ ಸ್ವಾಮಿ, ಅವರು ಆಗಿ ಕೋವಿಡ್ ಅಲ್ಲಿ ಕೆಲವು ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಸಿಕ್ತು, ಕೆಲವು ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಸಿಕ್ಕಿಲ್ಲ. 2015 ಅದನ್ನ ನಾನು ಟ್ರಾನ್ಸ್ಪರೆಂಟ್ ಆಗಿ ನಾನು ಹೇಳ್ಬೇಕು ಕೊಟ್ಟಿಲ್ಲ, ನಾನು ಸುಳ್ಳು ಹೇಳಕ್ಕೆ ಇಷ್ಟಪಡಲ್ಲ.
ನೀವು ಸುಳ್ಳು ಹೇಳಕ್ ಸುಳ್ಳು ಹೇಳ್ತಿದ್ರಂತ ಯಾರು ಹೇಳಿದ್ರು? ಕೇಸ್ ಬಿಲ್ಡ್ ಮಾಡುವಾಗ ಕಿಟಕಿಯಲ್ಲಿ ಇಡಬೇಕು, ಒಂದು ಮನೆ ಕಟ್ಟದಂಗ ಅದು. ಇಟ್ ಇಸ್ ಲೈಕ್ ಬಿಲ್ಡಿಂಗ್ ಎ ಹೌಸ್. ಮನೆಯಲ್ಲಿ ಕಟ್ಟಬೇಕು, ಕಿಟಕಿಯಲ್ಲಿ ಇರಬೇಕು, ಬಾಗ್ಲಲ್ಲಿ ಇರಬೇಕು, ಬೆಳಕು ಎಲ್ಲಿಂದ ಬರಬೇಕು, ಟಾಯ್ಲೆಟ್ ಎಲ್ಲಿ ಇರಬೇಕು ಅಂತ. ಇಟ್ ಇಸ್ ಲೈಕ್ ಬಿಲ್ಡಿಂಗ್ ಎ ಹೌಸ್. ಯು ಆರ್ ನಾಟ್ ಇವನ್, ನಿಮ್ ಕೇಸ್ ಏನು ಅಂತ ನಿಮ್ಗೆ ಸರಿ ಗೊತ್ತಿಲ್ಲ. How to frame a suit you do not know. Suit na ಹೆಂಗೆ ರೆಡಿ ಮಾಡಬೇಕು ಅನ್ನೋದೇ ಗೊತ್ತಿಲ್ಲ ನಿಮಗೆ. And you filed a suit. ಮನೆ ಕಟ್ಟೋದು ಹೆಂಗೆ? ಪ್ಲಾನ್ ಹಾಕಬೇಕು, ಫೌಂಡೇಶನ್ ಹಾಕಬೇಕು, ಹೌದಾ ಇಲ್ವೋ? What is the foundation for your case?
On that relevant time, he lodged a complaint before the police station. ಗುಣಮುಂಡೆ ಪೊಲೀಸ್ ಅವ್ರು ಕರೀತಾರೆ. ಅವಾಗ ನೀವು ಬನ್ನಿ ಅಲ್ಲೂ ಸೈನ್ ಕೊಡಿ, ಅವಾಗ ನಮಗೆ ನಾಲೆಜ್ ಬಂತು ಸ್ವಾಮಿ. ಅವಾಗ ಕೋವಿಡ್ ಅಲ್ಲಿ ನಮಗೆ ಡಾಕ್ಯುಮೆಂಟ್ ಸಿಕ್ಕಿಲ್ಲ ಕೆಲವೆಲ್ಲ.
ಎಸ್, ಅಷ್ಟೇನಾ?
ಎಕ್ಸಿಕ್ಯೂಟಿವ್ P 9 ಅಲ್ಲಿ ವೆರಿ ಕ್ಲಿಯರ್, ಯಾವ ಫ್ಯಾಮಿಲಿ ಫ್ರೆಂಡ್ ಆಗಿ ಬರ್ತಾ ಇದ್ರೆ ಇವರಿಂದ ತಗೊಂಡೋಗಿದ್ದಾರೆ ಪ್ರಯರ್ ಟು ದಿಸ್ ಅಲ್ಲಿ ಇದು ಡೀಲ್.
P9, your lordship will kindly see page 171. 171. ನಮ್ಮ ಹತ್ರನೇ ದುಡ್ಡು ತಗೊಂಡು ಹೋಗಿ ಸಾಲ ಕರಾರ್ ಪತ್ರ ಬರ್ಕೊಟ್ಟಿರೋದು.
ಎಕ್ಸಿಬಿಟ್
P9 page 171.
ಓದಿ ಏನು?
2008 ಇಸ್ವಿ ಜೂನ್ ತಾರೀಕು 13ರಲ್ಲಿ ಬೆಂಗಳೂರು ನಗರ ಕೊತ್ತನೂರು ಗ್ರಾಮ ಕಾಟಿರಮ್ಮ ಬಡಾವಣೆ ಮನೆಯ ನಂಬರ್ 9ನಲ್ಲಿ ವಾಸವಾಗಿರುವ ಕರಡಪ್ಪನವರ ಮಗ ನಾಗರಾಜ ಆದ ನಾನು ಬೆಂಗಳೂರು ನಗರ ಬನಶಂಕರಿ 2ನೇ ಅಂತ ಕದಿನೇನಹಳ್ಳಿ 8ನೇ ಅಡ್ಡ ರಸ್ತೆ ನಂಬರ್ 133 ರಣಧೀರ ಕಂಠೀರವ ರಸ್ತೆಯಲ್ಲಿ ವಾಸವಾಗಿರುವ ರುದ್ರಪ್ಪನ ಹೆಂಡತಿ ರಾಜಮ್ಮ ಉರ್ಫ್ ಸಿದ್ದರಾಜಮ್ಮನಿಗೆ ನಾನು ಬರೆದುಕೊಟ್ಟ ಸಾಲದ ಕರಾರು ಪತ್ರದ ಕ್ರಮವೇನೆಂದರೆ, ಅದಾಗಿ ನಾನು ನನ್ನ ಕುಟುಂಬದ ಹಣಕಾಸಿನ ಬಿಕ್ಕಟ್ಟು ಅಂದರೆ ನನ್ನ ಹೆಂಡತಿ ಈರಮ್ಮನ ಕಾಯಿಲೆ ಖರ್ಚಿಗಾಗಿ ಹಾಗೂ ನನ್ನ ಮಕ್ಕಳುಗಳಾದ ರಂಗನಾಥ, ಕೃಷ್ಣವೇಣಿ, ಲಕ್ಷ್ಮೀ ನರಸಿಂಹ ಇವರುಗಳ ಶ್ರೇಯೋಭಿವೃದ್ಧಿಗಾಗಿ, ಅಂದರೆ ಸ್ವಂತ ವ್ಯಾಪಾರದ ವ್ಯವಹಾರಕ್ಕೆ ಜರೂರು ಹಣ ಬೇಕಾಗಿದ್ದ ನಿಮಿತ್ತ ನಾನು ನನ್ನ ಆಪ್ತ ಸಹಿತ ರುದ್ರಪ್ಪ ಭಾಗವತರ ಧರ್ಮಪತ್ನಿ ರಾಜಮ್ಮ ಉರುಫ್ ಸಿದ್ದರಾಜಮ್ಮನಿಂದ ಸಾಲವಾಗಿ 6 ಲಕ್ಷ ರೂಪಾಯಿಗಳನ್ನು ನಗದಾಗಿ ಕೇಳಿ ಪಡೆದುಕೊಂಡಿರುತ್ತೇನೆ. ಸದರಿ ಸಾಲದ ಅಸಲು ಹಣಕ್ಕೆ ಬ್ಯಾಂಕ್ನಲ್ಲಿ ಕೊಡುವ ಬಡ್ಡಿ ದರದಲ್ಲಿ ಬಡ್ಡಿಯನ್ನು ಸಹ ಕೊಡುತ್ತೇನೆ. ಅಸಲು ಮತ್ತು ಬಡ್ಡಿ ಹಣವನ್ನು 4 ವರ್ಷಗಳಲ್ಲಿ ಸಾಲ ತೀರುವಳಿ ಮಾಡಿಕೊಡುತ್ತೇನೆ. ಹಾಗೂ ಈ ಪತ್ರದಲ್ಲಿ ಸಾಲ ತೀರುವಳಿ ಶರ ಬರೆದುಕೊಟ್ಟು ಅಸಲು ಮತ್ತು ಬಡ್ಡಿಯನ್ನು ನಿಮ್ಮಗಳಿಗೆ ತೀರಿಸುತ್ತೇನೆ ಎಂದು ಒಪ್ಪಿಸಿ ಈ ಕರಾರು ಪತ್ರವನ್ನು ಬರೆದುಕೊಟ್ಟಿರುತ್ತೇನೆ. ಈ ಸಾಲದ ಕರಾರು ಪತ್ರವನ್ನು ಸಾಲಗಾರರಾದ ನಾಗರಾಜಾದ ನಾನೇ ಈ ಪತ್ರವನ್ನು ಖುದ್ದು ಟೈಪ್ ಮಾಡಿಸಿರುತ್ತೇನೆ.
This is in 2008.
Yes.
How are you linking this with item number 2?
Prior to alleged execution of sale deed ಇವಾಗ ದುಡ್ಡೇ ಇಲ್ಲ ಅವನ ಹತ್ರ. ಈ ದುಡ್ಡು ತಗೊಂಡು ಫ್ಯಾಮಿಲಿಗಳಿಗೆ ತಗೊಂಡೋಗಿ ಮತ್ತೆ ಕೂಡ ಇವ್ರನ್ನ ಮಿಸ್ಪ್ರೆಸೆಂಟ್ ಮಾಡಿ
ಆಯ್ತಪ್ಪ, ಈ ಎಕ್ಸಿಬಿಟ್ ಪಿ ನಲ್ಲಿ ದುಡ್ಡು ವಾಪಸ್ ಬಂತ ನಿಮ್ಗೆ?
ಕೊಟ್ಟಿದ್ದಾರೆ. ಎಕ್ಸಿಬಿಟ್ P9 ಅಲ್ಲಿ P18 ಅಲ್ಲಿ ಕನ್ಫರ್ಮ್ ಮಾಡಿದ್ದಾರೆ. P18 ನಾನು ವಿಟ್ನೆಸ್ ಕನ್ಫರ್ಮ್ ಮಾಡಿದ್ದೀನಿ. ಇದನ್ನ ಕೊಟ್ಟಾಗ ಅಂತ
ಎಕ್ಸಿಬಿಟ್ P9 ಅಲ್ಲಿ ನಿಮ್ಮ ತಂದೆ ತಾಯಿ 6 ಲಕ್ಷನ ನಾಗರಾಜು ಕೊಟ್ಟಿದ್ದಾರೆ. ಅದನ್ನ ವಾಪಸ್ಸು ನಿಮಗ್ ಬಂದಿದ್ಯಾ?
ಬಂದಿದ್ದಕ್ಕೆ ನಾನು ಕ್ರಾಸ್ ಮಾಡಿ ನಾನು ಪಾಸ್ಬುಕ್
ಬಂದಿದ್ಯಾ ಅಲ್ವಾ ಫಸ್ಟ್ ಹೇಳ್ರಿ.
ಆಮೇಲೆ ಬಂತು.
ಯಾವಾಗ ಬಂತು?
ಪಾಸ್ಬುಕ್ ಅಲ್ಲಿ ಕನ್ಫರೆಂಟ್ ಆಗಿದೆ ಸರ್, ನಾನು ಹೇಳ್ಬಿಟ್ಟು ಯಾವಾಗ ಅಂದ್ರೆ
30/5/2012 ಸೇಲ್ ಡೀಡ್ ಆಗಿದೆ ಯಾವತ್ತು?
ವಿಟ್ನೆಸ್ ಕನ್ಫರೆಂಟ್ ಮಾಡಿದ್ದೀನಿ. ಸಾಲ ತಗೊಂಡು ನೀವು ಕೊಟ್ಟಿದ್ದೀರಪ್ಪ.
ಇದು ಸೇಲ್ ಡೀಡ್ ಮಾಡ್ಕೊಟ್ಟಿದ್ದು 13/4/2012. ಸೊ ಅಲ್ಲ
ಹೌದು ನಮ್ಮ ಕಂಟೆನ್ಷನ್ ಏನ್ ಸ್ವಾಮಿ ಇರ್ಬೇಕಾದ್ರೆ ಇಂತ ದುಡ್ಡೇ ಇಲ್ಲ ಸೇಲ್ ಡೀಡ್ ಮಾಡ್ಕೊಳ್ಳೋ ಟೈಮ್ಗೆ ನಮ್ಮ ಹತ್ರ ದುಡ್ಡು ತಗೊಂಡೋಗಿದ್ದೀವಿ.
ಬರ್ಕೊಳ್ಳಿ. ದಯವಿಟ್ಟು ಸ್ವಲ್ಪ ಪ್ಲೈಂಟ್ ರೆಡಿ ಮಾಡುವಾಗ ಸ್ವಲ್ಪ ಹಿಂದು ಮುಂದೆ ನೋಡಿ 2-3 ಸತಿ ಡ್ರಾಫ್ಟ್ ಮಾಡಿ, ಹಿಂಗಾದ್ರೆ ಹಿಂಗೆ ಹಿಂಗಾದ್ರೆ ಹಂಗೆ ಅಂತ ಯೋಚನೆ ಮಾಡಿ ದಯವಿಟ್ಟು ಹಾಕಿ. ಡೋಂಟ್ ಫೈಲ್ ಪ್ಲೈಂಟ್ಸ್ ಲೈಕ್ ದಿಸ್, ವೆರಿ ಪೋರ್ಲಿ ಡ್ರಾಫ್ಟೆಡ್. ಸ್ವಲ್ಪ ಯೋಚನೆ ಮಾಡಿ.
Relying on the one judgment of the 2026-1 AKR High Court ಮೇಲೆ
ಒಂದು ಪ್ಲೈಂಟ್ ಟೈಪ್ ಮಾಡಿ 3 ಸತಿ ಕರೆಕ್ಷನ್ ಮಾಡ್ರಿ ಮಿಸ್ಟರ್ ಬಸವಣ್ಣ. 3 ಸತಿ ಕರೆಕ್ಷನ್ ಮಾಡಿ. ಅವರು ಪ್ರತಿವಾದಿಗಳು ಏನೇನು ಹೇಳಬಹುದು ಅಂತ ಊಹೆ ಮಾಡಿ. ಸುಮ್ನೆ ಟೈಪಿಸ್ಟ್ ಟೈಪ್ ಮಾಡಿಕೊಟ್ಟ ನೀವು ತಗೊಂಡು ಫೈಲ್ ಮಾಡಿದ್ರಿ. ದಿಸ್ ಇಸ್ ವಾಟ್ ಹ್ಯಾಪನ್ಸ್. ಯೋಚನೆ ಮಾಡದೆ ಫೈಲ್ ಮಾಡಿದ್ರೆ ಹಿಂಗೆ ಆಗೋದು.
Hindu law, partition joint family property purchased by a Hindu widow in the name of her minor son.
Sir, this is a adverse possession, sir. This is not a joint family property. ನಿಮ್ಮ ತಾಯಿಗೆ ಅಡ್ವರ್ಸ್ ಪೊಸಿಷನ್ ಬಂದಿರುವಂತ ಪ್ರಾಪರ್ಟಿ ಜಾಯಿಂಟ್ ಫ್ಯಾಮಿಲಿ ಪ್ರಾಪರ್ಟಿ ಹೆಂಗಾಗುತ್ತೆ?
ಅಲ್ಲ, ಫಸ್ಟ್ ಅದು ಅವರು ಎಲ್ಲರೂ ಸೇರಿ
ಅದನ್ನ ಹೇಳಿದೀರಾ?
ಕಾಮನ್
ಹೇಳಿದೀರಾ?
ಹೇಳಿಲ್ಲ
ಎಲ್ಲಿ ಹೇಳಿದಿರಾ? ಅಷ್ಟು ಹೇಳಿದ್ರಲ್ಲ, ಇದೆಲ್ಲ ಜಾಯಿಂಟ್ ಫ್ಯಾಮಿಲಿ ಒಟ್ಟಿಗೆ ಮಾಡ್ತಿದ್ವಿ, ನಮ್ಮ ಅಮ್ಮನಿಗೆ ಒಬ್ಳಿಗೆ ಮಾರಾಟ ಮಾಡಕ್ ಅಧಿಕಾರ ಇಲ್ಲ ಅಂತ ಹೇಳಕ್ಕೆ ನಿಮ್ಗೆ ಏನ್ ಪ್ರಾಬ್ಲಮ್ ಆಗಿತ್ತು? ಏನ್ ಪ್ರಾಬ್ಲಮ್ ಆಗಿತ್ತು? ಬರ್ಕೊಳ್ರಿ. The plaintiffs in OS number 935 of 2021 on the file of so and so have filed this appeal challenging the judgment and decree dated 3/7/2023 by which their suit for partition separate possession in respect of 3 items of suit properties was decreed in part, and the suit in so far as item number 2 was dismissed. Next para.
The matter is remanded, my lord. We will amend.
Again remand enilla sir.
Amend the plaintiff because she is not
Partition
having any
henceforth be
income.
referred to as they were arraigned before the trial court. Yes. Next para. The suit in OS number 935 of 2021 was filed for partition separate possession of the plaintiff's 1/3 share in the suit real properties, and to declare a sale deed executed by the parents of the plaintiffs dated 13/4/2012 in favor of the defendant number 2 as not binding upon them. Full stop. Next para. Plaintiffs claimed that their mother social properties, full stop. This appeal is only in respect of the dismissal of the suit insofar as suit item number 2 is concerned. And therefore, the narration of facts shall be only in respect of item number 2. Next para. Plaintiffs claimed that the suit item number 2 was land bearing survey number 139/1 of Yadavanahalli, Attibele Hobli, Anekal Taluk. They claim that their mother had filed OS number 903/1993 for a declaration that she had perfected her title to the said property by adverse possession. Full stop. The said suit was decreed, in terms of which, she derived 5 untas of land in the said survey number. Full stop. They claim that the defendant number 1 was a friend of their father and was also working in the same place where his father was working. Full stop. They allege that the defendant number 1 used to visit their house often and was a well-wisher to the family. Full stop. They claim that their parents trusted the defendant number 1, but he fraudulently and illegally obtained a sale deed dated 13/4/2012 in respect of the suit schedule item number 2 in the name of his wife. Full stop. Plaintiffs claim that their parents did not execute the sale deed on their own accord, but had executed, but were misled by the defendant number 1, as at the relevant time there was no necessity for the plaintiff's father and mother to sell the suit item number 2. With these contentions, the plaintiffs claimed that they were not bound by the sale deed dated 13/4/2012 and that they are entitled to a share therein. Full stop. Next para. The suit was contested by the defendant number 1 and 2. Who contended that the suit schedule item number 2 is the self-acquired property of the mother of the plaintiffs 1 to 3, and that she sold it for valuable sale consideration of rupees 6,50,000 to the defendant number 2 in terms of a sale deed dated 10/4/2012. Full stop. They claim that the father of the plaintiff 1 to 3 had also consented to the said sale by attesting the document as a consenting witness. They therefore contended that the sale deed dated 13/4/2012 is binding upon the plaintiffs and they are not entitled to a share in the suit schedule item number 2. Based on these contentions, the trial court framed the following issues. Copy mode. In support of the case of the plaintiffs, the plaintiff number R. Dinesh. Plaintiff number 1 was examined as PW1 and he marked exhibits P1 to P20. Full stop. Who is PW2? PW2 here?
PW2.
PWD ನ್ಯಾಯ ಮಾಡೋದಕ್ಕೆ ಹೋದಾಗ ಅವರು PWD ಅದನ್ನ ಕಾಪಿ ಕಳಿಸ್ಕೊಡ್ತಾರೆ ಸರ್ ಮೊಬೈಲ್ ಇಂದ ಅವ್ರಿಗೆ ಕಳಿಸಿ ಇವ್ರು ಇಂಟರ್ನ್ ಇವ್ರಿಗೆ ಕೊಡ್ತಾರೆ ಅದನ್ನ ನಾನು 35B 65B
Yes. PW2
ನಾಗೇಶ್
is a resident of the, is a neighbor, is a neighbor of the plaintiffs. Full stop. The defendant number 1 was examined as DW1 and he marked exhibits D1 to D13. Full stop. Based on the oral and documentary evidence, the trial court held that the plaintiff is not entitled to, plaintiffs are not entitled to held that held that the mother of the plaintiffs had filed OS number 903/1993 against Mr. R. Muniappa to declare that she had perfected her title to the said property by adverse possession and for perpetual injunction, which culminated in a compromise on 25/1/1994, in terms of which, the plaintiff's mother was given away the schedule item number 2, suit item number 2. Full stop. The trial court therefore held that the plaintiff's mother was the full and absolute owner of the property of the suit item number 2. Full stop. It also noticed the evidence of PW1, who deposed that he did not know about the decree passed in OS number 903 of 1993. He even termed the compromise entered into in OS number 903 of 1993 as fraudulent. He also denied that his mother had acquired title to the suit property in terms of a decree passed in OS number 903 of 1993, and that it was the self-acquisition of his mother. The trial court therefore held that there is no evidence adduced to believe that the defendant number 1 had obtained the sale deed dated 13/4/2012 in respect of the suit item number 2 in the name of his wife fraudulently or by coercion, threat or undue influence. The trial court therefore, the trial court also held that the sale deed was executed on 13/4/2012 while the suit for declaration that the sale deed is not binding upon the plaintiffs was filed in the year 2021, which was hopelessly barred under Article 58 and 59 of the Limitation Act, and consequently dismissed the suit insofar as item number 2 is concerned and decreed the suit insofar as item number 1 and 3 are concerned. Being agreed with the said judgment and decree, the plaintiffs are before this court. Next paragraph. The learned counsel for the plaintiffs contended that the suit property was cultivated by the plaintiffs and that the suit in OS number 903 of 1993 was filed on behalf of the family, and the compromise decree which culminated in 5 guntas of land being granted, being given away to the mother of the plaintiffs was in fact in favor of the family, and therefore it had to be construed as a property belonging to the joint family. As a result, he contends that the plaintiffs mother and father alone could not have conveyed the suit property without the consent of the plaintiffs. It is also claimed that the defendant number 1 had received a sum of rupees 6 lakhs as loan from the parents of the plaintiff, which is evident from Exhibit P8. He contends that the said amount was paid back to the parents of the plaintiffs on ಯಾವತ್ತು ವಾಪಸ್ ಕೊಟ್ಟಿ ದುಡ್ಡು after the execution of the sale deed, meaning thereby that the defendant number 1 did not have sufficient funds to purchase the property, and hence the sale deed dated 13/4/2012 executed in favor of the defendant number 2 was without consideration, and that the defendant number 1 had taken undue advantage of his relationship with the parents of the plaintiffs. He also contends that there was no need for the family to encumber the suit item number 2 as the family was affluent. Full stop. With these contentions, the learned counsel for the plaintiffs submitted that the trial court must have decreed the suit in respect of item number 2 also. Per contra, the learned counsel for the defendant number 1 and 2 submitted that the suit is highly belated in as much as the parents of the plaintiffs had executed the sale deed in respect of suit item number 2 on 13/4/2012. Full stop. The plaintiffs were all the plaintiff number 1 deposed that he was already earning in the year 2012, while the other plaintiffs were also capable of challenging the judgment and challenging the alienation made in favor of the defendants 1 and 2. However, they did not take any steps during the lifetime of their parents to challenge the sale deed dated 13/4/2012. He contends that the parents of the plaintiffs did not make any attempts to challenge the sale deed dated 13/4/2012 if it was obtained fraudulently by the defendants 1 and 2. Full stop. As a matter of fact, he contends that the father of the plaintiff was also a consenting witness to the sale deed dated 13/4/2012, thereby ruling out any foul play. Full stop. He therefore contends that the plaintiffs were ill-advised to file a suit for declaration that the sale deed dated 13/4/2012 is not binding upon them in the year 2021. Full stop. He submits that a perusal of the entire plaint does not disclose as to when exactly, the plaintiffs came to know about the sale deed dated 13/4/2012 and how the defendant number 1 and 2 had played fraud in obtaining the sale deed dated 13/4/2012. Full stop. He also submitted that when the plaintiff pleads fraud, he has to give necessary particulars as provided under Order 6 rule, CPC, Order 6 rule, CPC 16, huh? Rule 4 of CPC. Full stop. He therefore contends that the suit filed by the plaintiffs is speculative and is with an oblique intent to make unlawful gain. Full stop. He also submitted that the plaintiffs have not mentioned in the plaint that the suit item number 2 was cultivated by them, by the family, and that the grant of the suit item number 2 any to the benefit of the family. Full stop. He therefore contends that the suit is mischievous insofar as suit item number 2 is concerned and is designed only to harass and compel the defendant number 1 and 2 to part with the suit item number 2. Full stop. He therefore submits that the trial court was right in dismissing the suit insofar as suit item number 2 is concerned. Next paragraph considers submissions of the learned counsel for the plaintiffs and the learned counsel for the defendants 1 and 2. The only point that arises for consideration in this appeal is whether the plaintiffs had placed enough material on record to establish that the sale deed dated 13/4/2012 was obtained by the defendants 1 and 2 fraudulently, and also whether the plaintiffs are entitled to a share in the suit item number 2. Next para. A perusal of the evidence, a perusal of the plaint shows that the plaintiffs merely claimed that the defendants 1 and 2 brainwashed and betrayed the trust of the plaintiff's parents in obtaining an illegal sale deed dated 13/4/2012. Full stop. They are not set out the circumstances under which the defendant number 1 and 2 obtained the sale deed dated 13/4/2012. They have also not set out the means adopted by the defendant number 1 and 2 to obtain the sale deed dated 13/4/2012. They have not also set out the fraud played by the defendant number 1 and 2 in obtaining a sale deed dated 13/4/2012. Full stop. A reading of the plaint shows that the same is drafted casually without giving material particulars as to when and how the defendants 1 and 2 played fraud on the parents of the plaintiffs. Full stop. It is also relevant to note that the father of the plaintiffs, parents of the plaintiffs were alive. ಯಾವಾಗ ತೀರೋಗಿದ್ದು?
18 years.
Alive till the year 2018, huh?
18.
Till the year 2018.
14/11/2018. Father died on 14/11/2018. Mother died on 16/8/2018.
Till the year 2018. However, there is not a scrap of paper from the year 2012 till the year 2018 to show that the parents of the plaintiffs had ever considered the sale deed dated 13/4/2012 as fraudulent, or that the defendants 1 and 2 had obtained such a sale deed fraudulently. Full stop. It is undisputed that the suit item number 2 was obtained by the defendant, by the mother of the plaintiffs as in a settlement, in a compromise in OS number 903 of 1993, in terms of which, it was held that the mother of the plaintiffs had acquired title to the said property by reverse possession. Full stop. Therefore, the plaintiffs cannot contend that the suit property was a property that belonged to the family and that the compromise decree inure to the benefit of the family. Full stop. In addition, it is seen from the evidence of PW1 that he did not accept the fact that the suit item number 2 was derived by his mother in a compromise reported in OS number 903 of 2013. 903 of 93. 93. Full stop. He also did not accept the fact that his mother had filed a suit for declaration that she had perfected her title by adverse possession. Full stop. PW1 deposed that he was earning from the age of 22 years when he was earning from the age of 22 years. He was earning from the day he attained the age of 22. He deposed in his cross-examination, which is relevant, and he deposed in his cross-examination as follows. Anbuto, page 125, pencil mark. Page number 126 allo pencil mark. As regards the sale deed dated 13/4/2024, he deposed as follows, page number 127.
Item number 1, Swami.
2002
item number 1.
Item?
Item number 1 ಸಂಬಂಧಪಟ್ಟದ್ದು 211/2000.
I am not on 211, 13/4/2012. Full stop. Therefore, the plaintiff himself, PW1 himself is oblivious of the title of his mother to the suit schedule item number 2. He therefore cannot contend that the suit property was cultivated jointly by the family and that the grant and that the compromise in OS number 903 of 1993 inure to the benefit of the family. Full stop. The only circumstance that the plaintiff pressed into service is the evidence of PW2, who is a neighbor of the plaintiffs, who deposed as follows. ಈ ಮೆಸೇಜ್ ಏನಿದು? ವಾಟ್ ಇಸ್ ದಿಸ್ ಮೆಸೇಜ್? ಏನ್ ಮೆಸೇಜ್ ಇದು?
ಏನಾಗಿದೆ ಕೇಳಿದ್ದಾರೆ, ಈ ಬಾಂಡ್ ಕೂಡ ಎಲ್ಲ ಕೊಡಿ ಅಂತ ಕೇಳಿದಾಗ CW2 is one of the neighbor of the residence. ಅವಾಗ ಈ D1 ಏನ್ ಹೇಳ್ತಾನೆ, ವಾಟ್ಸ್ಆಪ್ ಅಲ್ಲಿ ಮೆಸೇಜ್ ಕಳಿಸ್ತಾರೆ, ನಾವು ಕಳಿಸ್ತಾರೆ
ಏನಂತ?
ಈ ತರ ಬೈಂಡಿಂಗ್ ಸಿಗ್ನೇಚರ್ ಕೊಟ್ಟರೆ ನಿಮ್ ಬಾಂಡ್ ವಾಪಸ್ ಕೊಡ್ತೀನಿ ಅಂತ. ಅದು
ಕನ್ಫರ್ಮೇಶನ್.
Yes. ಆ ಮೆಸೇಜ್ ಎಲ್ಲಿದೆ? ಇಲ್ಲಿ ಎಕ್ಸಿಬಿಟ್ P18.
Photocopy of.
ಎಲ್ಲಿದೆ P18?
Page 255. Page 255.
ಏನಂತ ಹೇಳ್ತಾರೆ? ಈ ತರ ಮಾಡ್ಕೊಡ್ಬೇಕು ಅಂತನಾ? Where is the message? Madam, PW2 was a neighbor of the plaintiffs who purportedly had received a message from the defendant number 1. On a WhatsApp, on his WhatsApp, enclosing a file containing an affidavit as at exhibit P18. Full stop. The other circumstance that the plaintiffs pressed into service was exhibit P8, which purportedly was a letter an agreement, a loan agreement dated 13/6/2008, executed by the defendant number 1 in favor of the parents of the plaintiffs, whereby he had received a sum of rupees 6 lakhs. P9, rupees 6 lakhs. It is contended that the defendant number 1 did not have funds, as the sum of rupees 6 lakhs was paid long after the sale deed dated 13/4/2012. Full stop. As stated earlier, the plaintiff's parents did not challenge the sale deed dated 13/4/2012 when they were alive till the year 2018. Therefore, to now accept the case of the plaintiffs that the sale deed was obtained fraudulently, would be too preposterous, and the sale deed in favor of the defendant number 1 cannot be upset on the contention on the claim of the plaintiffs that the defendants did not have money to pay the parents of the plaintiffs. Full stop. A perusal of exhibit P18, which is the affidavit purportedly sent by the defendant number 1 to PW2, only shows that the defendant number 1 had called upon the plaintiffs to ratify the sale deed dated 13/4/2012. Therefore, there was no material furnished by the plaintiffs to establish that the sale deed dated 13/4/2012 in favor of the defendant number 2 was obtained fraudulently by the defendant number 1, and hence the plaintiffs were not entitled to upset the sale deed and were not entitled to a share therein. The trial court has carefully considered the evidence on record and has rightly returned a finding that the plaintiffs are bound by the sale deed dated 13/4/2012 and are not entitled to a share therein. In that view of the matter, this appeal lacks merit and is dismissed.
In respect of limitation, my lord, the court has discussed.
Yes.
On the point of limitation, the court has discussed. It is barred by time, but there is no issue has been framed in respect of that.
Section 3 ಇದೆ. That also the court has considered. Even otherwise, the plaintiffs who had come of age in the year 2012, could not have waited for 9 years to file a suit for declaration that the sale deed dated 13/4/2012 was not binding upon them, and the suit was ex facie barred by the law of limitation. Yes. Yes, next.
61 and 62 are urgent. Serial number 63.
Chandan Rao.
Chandan S. Rao.
Srikanth S.
Scales claim.
Any praise time, my lord? 2000. You have to pay cost, mister. Last time also you have taken time.
Senior is not well, my lord.
No,
Next week we will ready to argue, my lord.
You can take time but pay cost.
2 times it has been urgent.
The learned counsel for the appellant again seeks time. It is seen that the appellant has consistently sought time.
It's a recovery of the amount.
It is seen that the appellant took time on the last date also. Hence, the request for adjournment is not justified. Nonetheless, as a last list on so and so, subject to payment of cost of rupees 2,000, payable to the 5,000 payable to the Advocates Clerks Association. 5,000, 2,000. 2,000. Yes.
Can you fix the date?
10th April.
Yes. Next. Sanjay Ji.
64 urgent. Serial number 65. Chandrasekhar C.
ಕೊಟ್ಟಿಲ್ವಾ ಆಯ್ತು ಬಿಡಿ ಆಯ್ತು ಮೇಡಮ್ in view of the disposal of the appeal, the order dated 12/3/2026, the imposition of cost of rupees 2,000 by order dated 12/3/2026 is waived.
My lord, serial number 65, I'm appearing for the respondent 1 to 4, my lords.
Yes.
Senior is held up in another court. I request for a short passover in this matter, my lords.
So 350, mister.
Indeed, my lord. He'll be there. He's held up in another court.
Learned counsel for the response 1 to 4 seeks time. List on so and so. What happened to the mediation?
I'm not aware of it, my lords. It's not succeeded, I assume. So hence it's not for defense right now.
Kumari Shilpa.
66. 14% Kumari Shilpa GG.
SG Lokesh. Yes.
Sir, last time I hand over the passbook, this paper book to the other advocate. The other advocate has not come.
Yeah, other advocate has come.
No, the last time it was a different person.
Well, all advocates will not look like the same. He is junior, another junior will come.
Okay, fine. Sir, coming to my case, before getting into the details, I would like to brief the overall scenario of the case. My grandfather has got 7 children. My father is the 7th one, last one. 3 sons and 4 daughters for my grandfathers. So after my grandparents gone away, division agide. Division avaru anna tabandiru 3 jana division ಮಾಡ್ಕೊಂಡಿದ್ದಾರೆ. ಇವಾಗ Sorry?
ಅವಾಗ
That is oral division. ನಾನ್ separate ಇದ್ದೆ, ಅವರು 2003 ಗಿಂತ ಮುಂಚೆ ಅವರ ಮಾಡ್ಕೊಂಡಿದ್ದಾರೆ. I was small.
ನಿಮ್ಮ ತಂದೆ ನಿಮ್ಮ ದೊಡ್ಡಪ್ಪಂದ್ರು ಎಲ್ಲ ಡಿವೈಡ್ ಆಗಿದ್ದಾರೆ.
ನಮ್ಮ ಗ್ರ್ಯಾಂಡ್ ಫಾದರ್ಸ್ ಪ್ರಾಪರ್ಟಿನ ನಮ್ ತಂದೆ ಪ್ಲಸ್ ನನ್ನ ದೊಡ್ಡಪ್ಪಂದರು ಅವರು ಡಿವಿಷನ್ ಮಾಡ್ಕೊಂಡಿದ್ದಾರೆ. ಐ ವಾಸ್ ನಾಟ್ ಇನ್ ಟು ಪಿಕ್ಚರ್.
ಯಾವಾಗ?
That should be 1995. ತುಂಬಾ early sir. That is they have done on their own long
ತುಂಬಾ
time.
early ಅಂದ್ರೆ ನಮಗ್ ಗೊತ್ತಿಲ್ಲ, ನೀವ್ ಹೇಳ್ಬೇಕು.
Okay, I can take it as around 1995, 98 ಅಲ್ಲಿ ಆಗಿರ್ತಾರೆ.
Yes.
ಸೊ ಅದಾದ್ಮೇಲೆ ಇವಾಗ ಪ್ರಾಪರ್ಟಿ ಮಾರಾಟ ಮಾಡಿರೋ ಕೇಸು ದೊಡ್ಡಯ್ಯ ಅವರಿಗೆ, ದಟ್ ಈಸ್ ಸರ್ವೆ ನಂಬರ್ 49/1 2 acres 33 ಗುಂಟಾಸು ಪ್ಲೇಟ್ ಅಲ್ಲಿ ಐಟಮ್ ನಂಬರ್ 2 ಇದೆ. ಅದು ನಮ್ಮ ದೊಡ್ಡಪ್ಪಂದಿರೋ ನಮ್ಮ ಅಪ್ಪ ಮಾತಾಡ್ಕೊಂಡಿರೋದು, ಅದು ನಮ್ಮ ಅಪ್ಪನ ಶೇರ್ಗೆ ಬಂದಿರೋ ಪ್ರಾಪರ್ಟಿ. ಅದು ನಮ್ಮ ಅಪ್ಪಂಗ್ ಒಂದ್ಸತಿ ಆ ಶೇರ್ ಬಂದ್ಮೇಲೆ ನನ್ ಬ್ರದರ್ಸ್ ನಾವೆಲ್ಲ ಡಿವಿಷನ್ ಆಗೇ ಇಲ್ಲ. ನಾನು ಸಮ್ ಫ್ಯಾಮಿಲಿ ಫೈಟ್ ಇಂದ ನಾನ್ ಸಪರೇಟ್ ಇದ್ದೆ. ನಮ್ಮಪ್ಪ 2014 ಅಲ್ಲಿ ಈ ಪಾಸ್ಡ್ ಅವೇ. When after passing away, death certificate is not linked. I will link it. It is there with me. ನಮ್ಮಪ್ಪ ಹೋದ್ಮೇಲೆ 2 years ಆದ್ಮೇಲೆ I asked, ನನಗೆ ನನ್ ಶೇರ್ ಕೊಡಿ, ಅರಳೆ ತೋಟದ್ದು ಫಸ್ಟ್ ಕೊಡಿ ಇಂದ. ಅವ್ರು ಅರಳೆ ತೋಟ ಲಾಂಗ್ ಟೈಮ್ ಬ್ಯಾಕ್ ಇಟ್ ಇಸ್ ಬೀನ್ ಸೋಲ್ಡ್. ಆಮೇಲೆ ದೊಡ್ಡಯ್ಯ ಅವ್ರನ್ನ ಹೋಗಿ ಕೇಳಿದ್ಕೆ ನೀವ್ ಯಾಕೆ ನನ್ ಸಿಗ್ನೇಚರ್ ತಗೊಂಡಿಲ್ಲ ಅಂದ್ರೆ ದೇ ಸ್ಟಾರ್ಟೆಡ್ ಟಾಕಿಂಗ್ ಟು ಮಚ್. ಓಕೆ, ಲೆಟ್ಸ್ ಟಾಕ್ ಇನ್ ದ ಕೋರ್ಟ್ ಅಂತ ಐ ಬಾಟ್ ದಿ ಪ್ರಾಪರ್ಟಿ ಇನ್ ದಿ ಕೇಸ್. ಪ್ಲಸ್
item number 3 and 4 ಮೇಲೆ court has
no sir, before proceeding I would like to say this more important points. ನನಗೆ ಮಾಗಡಿ ಸಿವಿಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಕೇಸ್ ಇನಿಶಿಯೇಟ್ ಮಾಡಿದಾಗ ನಾನು ರೀಡ್ ಮಾಡಿಲ್ಲ, ಏನು ಜಸ್ಟ್ ರೀಡ್ ಮಾಡ್ಲಿಲ್ಲ. ಇಲ್ಲಿ ಬೆಂಗಳೂರಿಂದ ಹೋಗ್ತಾ ಇದ್ದೆ, ಏನ್ ಅವ್ರು ಸೈನ್ ಹಾಕುಂತ ಇದ್ರ ಆಗ್ತಾ ಇದೆ, ಜಡ್ಜ್ ಮುಂದೆ ನಿಂತ್ಕೊಳ್ತಾ ಇದ್ದೆ, ಬರ್ತಾ ಇದೆ. ಈವನ್ ಮೈ ಓನ್ ರಿಟರ್ನ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಐ ಹ್ಯಾವ್ ನಾಟ್ ರೆಡ್. ಆಫ್ಟರ್ ಸ್ಟ್ಯಾಂಡಿಂಗ್ ಫ್ರಂಟ್ ಆಫ್ ದಿ ಜಡ್ಜ್ they used to please sign, I used to sign and come.
Madam,
So
that is your problem.
That I would like to bring it to your notice.
See, if you have believed your brothers, we can't help it.
Sorry?
If you have believed your brothers, we can't help it. Sign ಏನಕ್ಕೆ ಮಾಡ್ತಿದ್ರು ನನಗೆ ಗೊತ್ತಿಲ್ಲ.
ಅಲ್ಲಲ್ಲ ಸರ್, when it has been given to an other lawyer, ನಮ್ಮ ಮಾಗಡಿ ಸಿವಿಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಈ ಕೇಸ್ ಫೈಟ್ ಮಾಡಕ್ಕೆ, ಸೊ ಅವ್ರು ಏನ್ ನಮ್ ಲಾಯರ್ ನಮ್ಮ ಅಮ್ಮ ಅಪಾಯಿಂಟ್ ಮಾಡಿರೋರು ಅಡ್ವೊಕೇಟ್ ಏನ್ ಬರ್ದಿದ್ದಾರೆ ಅಂತಾನು ನಾನ್ ಓದಿಲ್ಲ.
ಓದ್ಬೇಡಿ ಅಂತ ಯಾರು ಹೇಳಿದ್ದು? ಓದ್ಬೇಡಿ ಅಂತ ಯಾರು?
That is the mistake I had put in my prior. Being an educated person, I didn't do that. That's a mistake has happened.
If you have committed a mistake, you have to pay for it.
It is not a mistake. I can say it is okay. Some trust is there. Yes, my mother would have narrated. My mothers are there, my brothers are there. Trust is there. I am in a safer hand. I used to go on signature. That prayer al nan hakidini very clearly. I have not read. Now I can get it. Coming to Vinita Sharma and Rakesh Sharma's case, Honorable Supreme Court has been told that the issue has come there whether the father has to be alive in 2004 or not. That is only the issue has come. Other than that, then Supreme Court told us no, it is irrespective whether father has to be alive or not. On 9 September 2005, the property right comes to the daughter by birth. ಆಮೇಲೆ ಇಂಡಿಯನ್ ಕಾನ್ಸ್ಟಿಟ್ಯೂಷನ್ ಹೋದ್ರೆ ಅದರಲ್ಲಿ 14 ಅಲ್ಲಿ ಹೇಳುತ್ತೆ ಜೆಂಡರ್ ಈಕ್ವಾಲಿಟಿ. ಸೊ ಜೆಂಡರ್ ಈಕ್ವಾಲಿಟಿ ಇಸ್ ದೇರ್ ಫ್ರಮ್ ದಿ ಅರ್ಲಿಯರ್ ಇಟ್ ಸೆಲ್ಫ್. They would have not implemented. They would have considered on that. And plus, Karnataka Hindu Succession Act 1995 alle Rashtrapati avರದು signature agide. Yes, the Hindu Succession Act under section 6 alli male lineage succession act bari male idakke hogutte. But even we to eradicate dowry system and other things, they are introduced. The girl has got a unmarried girl has got a right.
Yes.
There are so many points. Other point is 3 acres land now. They have sold it only for 1,42,000. There is huge disparity. Even market price martogbidi. Even to the government guidelines, Not even 1% is matching. So how all this injustice can be rectified? And yes, as a person, I did not got my family this thing. After 10+2, I started working. Everything I have done on my own.
Yes.
How can this can be? I need a justice on this. At least go to Constitution Article 14. It says gender equality. Maybe 1947 we got the independence. There is lot many things. They would have not bought the law so forcefully. They bought it in 2005. Yes, after 2005, there is practically on ground level, I can see there is lot of control has come in the system on the ground level. Equal gender now, the females works, male works, the family, both of them are working. It is going on good. Hope that this law has been not misused by females. It is good, but it would have bought earlier itself.
Where are you working?
I'm working in Resource E-Waste Solutions Private Limited.
Suppose if your employer,
I'm an employee.
you're the employee. Suppose if your employer tomorrow brings or issues a order saying that henceforth all employees will have to give will have to give some contribution towards some fund with retrospective effect from 10 years back. 10 ವರ್ಷದ ಹಿಂದೆ ಪ್ರತಿ ವರ್ಷನೂ ಇಷ್ಟಿಷ್ಟು ಕೊಡಬೇಕು ಅಂತ ಅಂದ್ರೆ what would you do?
Sir, the comparison is not
No, I'm not comparing.
It's a property, sir. It's a property.
I'm not comparing, madam. I'm not comparing. Tomorrow, if your employer says that we intend to buy a building for the employees.
Okay.
Where you will be housed, you will be given an independent accommodation, you'll be given good facility. So what we will do is, with effect from 10 years from today, you will start paying every year so much from out of your salary, will start deducting with retrospective effect. How would you feel?
If it is, see, to answer this question, point number one, I would like to say mine is a property case and the employee
I'm not comparing.
accommodation, it's a comparison is not very rash.
I'm not comparing. You are comparing. I'm not comparing. How would you say? What would you feel?
I will check it out. I will calculate what I'm staying in a rent or whatever the house. If I contribute this much, what is the current property value? How much is my expenses? If I find it feasible, yes, I will take a call.
No, you will say that I'm ready to pay henceforth. From today onwards, I'll start paying. But if you ask me to pay from 10 years hence or since.
But still I will take a call. I will still analyze 10 years back. There are two options. One, I will take, if it is, anybody says just you start from paying now, it's very, anybody can do, that's a very common thing. When the question comes 10 years back paying, I will sit and calculate. If I say 10 year 2000 cost, this much is the amount. What if I am getting this accommodation? What is my expenses? What is my current price? If everything is really feasible to me, I'm ready to pay.
Yes.
It depends, it is an in-depth analysis I have to do. Yes. What is my current expenses? What is the current property value? How much I'm spending? Where I'm getting? Which location? New construction or construction facilities? Everything I'll get into the details. If it is feasible, yes, worth paying retrospective, I will definitely pay. And I'm owning a property. If we're paying that, I'm owning a property.
Yes. I'm sorry to suggest you. I'll take it back. You can argue the matter.
So, sir, your main point is the article, Indian Constitution article is section, 11, 12, 13. It covers in that in depth. It says gender equality. Gender equality, it is there based on that. Why they have not taken my signature? That too, I am an unmarried daughter. I got a full right only. I'm still there with them. And then 2005, this Vinita Sharma case came. It's not a much difference. It's hardly in a question of 9 months difference, 1 year difference. People are aware of that. I'm not come 30 years, 40 years, I'm coming here and asking. It's a negligible period. And at least Karnataka Act, they have to see. Karnataka Supreme Court should appreciate the Karnataka Hindu Succession Act, Amendment Act 1995. Supreme Court is bought little later. Karnataka government is bought earlier.
When did your father die?
2014, sir, May.
2014.
After my father passed away, then no, in 2016, that too I said, I went and asked. My brother said, I cannot go from Bangalore to Magadi, get all the documents ready. I said, my brothers, please keep all the documents ready. I will come and sign it. Whenever my date was there, I used to go stand, sign it and come. That's all, nothing else. I never read anything. Then they gave the decree for other properties. But my main suit is for 49/1 property. There they have misled so many information, which I am here to answer those questions.
Yes. Is that all?
This is what currently I'm saying. When the question keeps coming, I'll keep answering.
Yes. No, you please argue your case.
So I want my portion.
Your suit is dismissed in item number 2 on the ground that your father, your brothers had sold item number 2 to Dodaya on 19/12/2003, at which point in time the Hindu Succession Amendment Act 2005 had not come into force.
Yes.
So please answer that question.
So, yes, not coming to force. They have told it has not come to the force, but they have not told anything that, but why that 2005 force very clearly says, after Vinita Sharma case and Doddama case, there are so many, there is a slight confusion. Finally, Vinita Sharma, Rakesh Sharma case has been cleared all the confusions of previous cases. Yes, daughter has got a birth, but co-partnership right in ancestral property by birth. If it is by birth, then all the whatever the transaction has been taken place prior to 2005, everything comes into the picture. If the one word by birth, it carries a complete meaning. Transactions would have taken place before, prior to 2005. Everything comes into the picture. Why the word by birth matters? It's a birth. It's a very, very valid, it covers everything. Anywhere in India or world, you get by birth means it's a by birth.
Unfortunately, the law is against you.
Law, they have framed it because there are so many cases would have happened. Case like me.
Madam, we are bound by the judgment of the Supreme Court. Supreme Court says that any alienation made before 20th December 2004 is saved and will not be affected by the Act 2005.
I will catch on the word of a by birth. Daughter has got a co-partnership right by birth. I will catch on that word itself, sir.
Yes, everything is considered.
And then Supreme Court is not telling it's a married daughters or an unmarried daughter. I carry a weightage daughter. They're supposed to take. Sir, it matters, sir.
It doesn't matter.
It matters.
In the eyes of law, it doesn't matter.
Sorry?
Married or unmarried.
It matters.
It doesn't matter.
Matters, sir.
It might matter to you, madam, but in the eyes of law, it doesn't matter.
In the eyes of law, it should matter. It should matter. Why it is not mattering? Because the unmarried daughter is there. She should be taken care. The property is taken. It's a worth of lakhs, and it's not a small, sir, this is not a small transaction. It's a worth of, property. It is of a 3 acres. ತಗೊಳಕ್ಕಿಂತ ಮುಂಚೆ ಜುಟ್ಟು ಜನವಾರ ಯಾರು ಎಲ್ಲೆಲ್ಲಿದ್ದಾರೆ ಎಲ್ಲ ಚೆಕ್ ಮಾಡಬೇಕು. It is their responsibility, sir. I'm not talking some small things worth of 10,000. It's a question of a property. It is, it will stay. They should see ಜುಟ್ಟು ಜನವಾರ ಅದು ಎಲ್ಲಿ ಏನಿದೆ connections ಎಲ್ಲ ನೋಡ್ಬೇಕು, sir.
Yes.
And then at least 1995 only Karnataka government has bought that, unmarried daughter has got a co-personary right in the ancestral property.
You should have filed a suit then itself. Why did you keep quiet? You should have filed a suit.
Sir, now kelsa ಮಾಡ್ತೀವಿ. Now it's
ನೋಡಿ ಎಲ್ಲದಕ್ಕೂ
ಬೆಳಗ್ಗೆಯಿಂದ ಸಾಯಂಕಾಲವರೆಗೂ ಕೆಲಸ ಮಾಡಿ we will be checking in the calendar. ಯಾವತ್ತು ಭಾನುವಾರ ಬರುತ್ತಪ್ಪ ನಿದ್ದೆ ಮಾಡಿದ್ರೆ ಸಾಕು ಅಂತ ಲೆವೆಲ್ ಅಲ್ಲಿ ಇರ್ತೀವಿ.
ಅದೇ ತರ ನಿದ್ದೆ ಮಾಡಿ.
Practical problem, sir. Sir, ನಾವು ಕೆಲಸ ಮಾಡ್ತಾ ಇರ್ತೀವಿ. It's coming to me. I don't know about macro level. Micro level I'll be searching ಯಾವಾಗ ಹಾಲಿಡೇ ಬರುತ್ತೆ, ಯಾವಾಗ ಸಂಡೇ ಬರುತ್ತೆ, ನಿದ್ದೆ ಮಾಡೋಣ ಅಂತ. So that much I'm not killed. Yes. Parents ancestral property ide when my father passed away, avaga all this came into picture.
Please take this, madam. We'll decide this case. If you are agreed, you can take it to the Supreme Court. Yes, Barkul.
But it is 1995 is also been considered. Why?
Yes,
why
that is also considered by the Supreme Court. That is also considered. That's also ನೀವು ಫುಲ್ ಓದ್ಲಿಲ್ಲ ನೀವು. ಒಂದು ವಾರ 15 ದಿನ ಟೈಮ್ ಕೊಟ್ಟಿದ್ದೀನಿ ನಿಮಗೆ. ನಿಮಗೆ ಶನಿವಾರ ಭಾನುವಾರ ಹುಡ್ಕೊಂಡು ರಜಾ ತಗೊಂಡು ಮಲ್ಕೋತಿದ್ದೀರಾ, ಓದ್ತಾ ಇಲ್ಲ.
ಅಲ್ಲ ಸರ್, ಇಟ್ ಇಸ್
ಜಜ್ಮೆಂಟ್ ಕೊಟ್ಟಿದ್ದೆ ತಾನೆ, ವಿನೀತಾ ಶರ್ಮಾ ಕೊಟ್ಟಿದ್ಯಲ್ಲ, ಓದಿದ್ರ ನೀವು?
ವಿನೀತಾ ಶರ್ಮಾ ಕೇಸ್
ಫುಲ್ ಓದಿದ್ರ?
Sir, I have read it. It is one word which is favorable to me, irrespective of whatever father is alive or dead or by birth.
ಫುಲ್ ಓದಿದ್ರ ಓದ್ಲಿಲ್ವಾ?
ನಾನು 5-6 ಸಲ
ಎಸ್ ಆರ್ ನೋ ಓದಿದ್ರೆ ಓದಿದ್ದೀನಿ, ಇಲ್ಲ ಇಲ್ಲ ಅರ್ಧಂಬರ್ಧ ಓದಿದೆ, ಅರ್ಧಂಬರ್ಧ ಓದಿದ್ದೀನಿ ಅಂತ ಹೇಳಿ.
Transactions prior to this.
No, have you read? No, why don't you answer?
Yes, I have read. I have seen some YouTube videos. I have taken this.
Have you read the judgment fully?
Fully I have not read.
ಹೇಳಿ ಮತ್ತೆ.
Then plain copy ni taskoltini sir. I will get a certified copy from the Supreme Court.
I will give you a certified copy only.
Please give me the certified copy that Vinita Sharma should be a married person. Why? I just want to please, I want this honorable court to answer me. Unmarried daughter has got an ancestral right in co-personary right in ancestral property.
Yes. You are the only unmarried daughter who is saying that married daughters should be differentiated from unmarried daughters.
Sir,
all married daughters will say that you can't differentiate, discriminate us. We are just like sons.
ಅಲ್ಲ ಸರ್, ಮ್ಯಾರಿಡ್ ಅವ್ರು ಆಗಿ ಖರ್ಚು ಮಾಡಿ ಅದು ಕೊಟ್ಟು ಇದು ಕೊಟ್ಟು ಎಲ್ಲ ಮಾಡಿದ್ದಾರೆ. ದೆನ್ ಐ ಆಮ್ ಎನ್ ಅನ್ಮ್ಯಾರಿಡ್ ಡಾಟರ್, ಐ ಗಾಟ್ ಎ ರೈಟ್, ವೇರ್ ಶಾಲ್ ಐ ಗೋ? ಅದಕ್ಕೆ ಇವಾಗ 140 ಕೋಟಿ ಜನಸಂಖ್ಯೆಗೆ ತಗೊಂಡ್ರೆ 140 ಕೋಟಿಗೆ 150 ಕೋಟಿ ಮದ್ವೆ ಆಗಿರ್ತಾರೆ. ಸೊ ಅದ್ರಲ್ಲಿ ನಾನು ಒಬ್ಳೋ ಇಬ್ರು, ಐ ಆಮ್ ಸಾರಿ ಟು ಸ್ಪೀಕ್ ದಿಸ್, ಅದ್ರಲ್ಲಿ ನಾನು ಒಬ್ಳೋ ಇಬ್ರೋ ಇರ್ತೀನಿ. ದ ಜಜ್ಮೆಂಟ್ ಹ್ಯಾಸ್ ಟು ಬಿ ಕ್ಯೂರೇಟಿವ್ ಟು ಮೀ. ಇಟ್ ಹ್ಯಾಸ್ ಟು ಬಿ ಕ್ಯೂರೇಟೆಡ್. Cases barde irbodu. There may be a lot of cases when it has come front of the honorable court analyzing. Point number 1, it is 1,42,000 is so much. I can't even say so less even compared to the government guidelines. So, plus I'm an unmarried daughter. So
the plaintiff in OS number so and so on the file of so and so has filed this appeal challenging the judgment and decree dated so and so by which the suit for partition was decreed in part and decreed in part insofar as item numbers 1, 3 to 6 and dismissed insofar as item number 2 is concerned. Next para. The party shall henceforth be referred to as they were arraigned before the trial court. Next para. The plaintiff is the daughter of the defendant number 1 and Govindaya, while the defendants 2 and 3, defendant number 2 is the brother of the plaintiff. 2, 3 and 4 are the brothers of the plaintiff, while defendant number 5 is the beneficiary under a gift deed dated 30/3/2011 executed by her husband (Doddaya), who had purchased suit item number 2 from the plaintiff's father defendants 3 and 4 in terms of a sale deed dated 19/12/2003. Full stop. The plaintiff claimed that the suit properties are ancestral and joint family properties. She claimed that her father died on 19/5/2014, leaving behind him his wife, bracket defendant number 1, and three children who succeeded to the suit properties.
No, 3 children, 4 children. sir.
4 children. ನೀವು 3 ಅಂತ ಬರ್ದಿದ್ರೆ ಅದಕ್ಕೆ to succeed to the suit properties. She claimed that after the death of her father, she and the defendants 1 to 4 continued to be in possession of the suit properties, and that there was no partition of the suit properties. She claimed that she had an equal share in the suit properties, and that after the death of her father, the defendants 1 to 4 were managing the suit properties. She thereafter she came to know that the defendants 1 to 4 were mismanaging the suit properties and were misutilizing and misapplying.
Sir, no, that sentence is wrong. To be give a kind
Madam, you have
information,
written
that
there.
sentence is wrong.
That is
That's
what
why,
is-
sir, the mistake is happened. I am here to answer. It is not mismanaging. Nam father kinta sai
I will
kinta
only record what is mentioned in the plaint. ನಿಮ್ಮ ಕೇಸಲ್ಲಿ ಏನ್ ಹಾಕಿದ್ರೋ ಅದನ್ನೇ ಬರಿತಿರೋದು.
That is been drafted.
Yes,
Draft
yes.
has not been seen. I want to correct
Was
the draft.
mismanaging the suit properties and misusing the suit shall joint family income for their illegal activities.
Excuse,
Full
sir.
stop. Do you have the copy of the
Sentence
plaint?
has to be corrected, sir. The draft
Odi
has
madam
been
nindu
done, sir.
Plaint odi.
Allah, sir, that's why I told
Plaint ಅಲ್ಲಿ ಇದೆಯೋ ಇಲ್ವೋ?
before. Sir,
Plaint ಅಲ್ಲಿ ಇದೆಯೋ ಇಲ್ವೋ?
ide. But before getting into the details, I have explained this honorable court, sir. I have not read the draft. Being a
So
this thing.
who asked you to file this plaint?
Sorry.
Who asked you to file this plaint?
My mother in Magdi, she hired some advocate and they drafted it. I never read because it's in the hands of my father, my brothers and somehow, very comfortable just to
Legal
go on
activities.
signature.
Full stop.
Actually,
She
the
claimed-
whole plaint has to be corrected.
He claimed that the defendants 1 to 4 abused her and claimed that she has no right to question the management of the suit properties. The plaintiff therefore demanded her share in the suit properties on 1/5/2015, which was flatly refused by the defendants. She claims that she is an unmarried, she's a spinster and residing in Bangalore, and taking advantage of her absence, the defendants 1 to 4 were attempting to alienate the suit properties. She alleged that she came to know that suit item number 2 was sold to one Mr. Doddaya by the plaintiff, by her father, as well as the defendants 3 and 4 on 19/12/2003.
Sir, could I correct your one sentence,
Full
please?
stop.
Apart from the
Thereafter,
plaint,
they said Doddaya gifted the suit item number 2 to his wife, bracket defendant number 5, in terms of a gift deed dated 30/3/2011. Full stop. The plaintiff therefore claimed that the said sale deed and the gift deed were all behind her back, were all brought behind, were all brought out without her notice, knowledge, and consent, and that the said sale deed and the gift deed does not bind her. Consequently, she sought for a partition separate possession of her 1/4 share in the social properties and to declare the sale deed dated 19/12/2003 executed by her father, defendants 3 and 4 in favor of Doddaya as not binding on her. Full stop. The suit was contested by the defendant number 5, who admitted that the suit item number 2 was conveyed to her husband Doddaya, and that he executed a giftee dated 30/3/2011. She claimed that the plaintiff was aware of these transactions and therefore she is not entitled to any share in suit item number 2. Full stop. She also claimed that the revenue records of suit item number 2 were transferred to the name of the defendant number 5 and that she had raised a mango garden in the suit property. Full stop. With these and similar other contentions, she contended that the plaintiff is not entitled for a share in suit item number 2. Based on these contentions, the trial court framed the following issues. The plaintiff was examined as PW1 and she marked exhibits P1 to P12, of which P1 was the giftee dated 30/3/2011, while P2 was the sale deed dated 19/12/2003. P3 to P6 were the mutation register extracts. P7 to P11 were the RTCs of the suit shell properties and P12 was the family tree. Full stop. She examined a witness as PW2 who deposed about the properties being held by the family. Full stop. The special power of attorney holder of the defendant number 5 was examined as DW1 and she marked exhibits D1 to and he marked exhibits D1 to D4. A witness was also examined as DW2 who spoke about the possession of the defendant number 5 in the suit item number 2. Based on the oral and documentary evidence, the trial court held that the plaintiff had proved that she is entitled to a share in suit items 1, 3 to 5, 3 to 6. However, insofar as suit item number 2 is concerned, it held that the said property was sold by the father of the plaintiff and her brothers for family necessities. Prior
No, it
to
is
family necessities on 19/12/2003, which was prior to the Hindu Succession Amendment Act 2005 coming into force. Full stop. It therefore held that the plaintiff is not entitled to a share in the suit item number 2 and thus decreed the suit in part and declared that the plaintiff is entitled to 1/5 share in suit items 1, 3 to 6 and dismissed the suit insofar as suit item number 1, 2 is concerned. Being agreed by the same, the plaintiff is before this court. Next para. The plaintiff who has appeared in person submitted that the plaintiff is an unmarried daughter.
Yes.
And therefore she has to be separated as she has to be considered as a separate and distinct person who is and must be treated on par of a son. Should be treated on par with a son, and that she is entitled to claim a share in the suit item number 2, notwithstanding the sale deed dated 19/2/2003 brought about by her father and her brothers. She also contends that the Hindu Succession Amendment Act 2005 brought in gender equality by treating a son and a daughter on par insofar as it relates to succession to properties. She therefore contends that that she is entitled to a share in the suit property, notwithstanding the sale deed dated 19/12/2003 executed by her father and her brothers. Full stop. She also contends that what is your
Karnataka Hindu Succession
she
Act
also contends
1990.
that the Hindu Succession Karnataka Amendment Act 1994
Under section 6, they brought the changes stating that unmarried daughters has got a co-personary right in ancestral
had
property.
recognized the right of a daughter to claim partition, and that
to eradicate dowry system that is there in the
And that she is entitled to a share in the suit properties by applying the Hindu Succession bracket Karnataka Amendment Act 1994. Full stop. Per contra, the learned
and
counsel
then
for the
articles
defense.
are article
She
Indian
also
Constitution
submits
article.
that depriving the plaintiff of her share in the suit property would be denying her right to equal share in the suit properties and would amount to discrimination between a son and a daughter.
There is a disparity in the price. Disparity in the
also
price
contends
has
that
to be mentioned.
She also contends that the sale deed dated 19/12/2003 is ex facie fraudulent in as much as the suit item number 2 is sold for a sum of rupees
42,000.
1,42,000, which was far less than the price it commanded in the market.
2 acres 33 for
Stop.
2 acres 33
Hence, she
guntas.
contends that the sale deed dated 19/12/2003 is unconscionable and is designed only to deprive the claim of the plaintiff in the suit item number 2.
And then Vinita Sharma's case and Vinita Sharma and Rakesh Sharma's case, Honorable Supreme Court says that unmarried daughter has got a co-personary right in ancestral property by birth.
Yes.
That's my word
Per
has to be
contra, the learned
included in
counsel
that.
for the defendant number 5 submitted that the the husband of the defendant number 5 had purchased the suit property from the plaintiff's father and their brothers on 19/12/2003, at which point in time, the plaintiff did not have a right in the suit shell properties. He therefore contends that the trial court had rightly held that the plaintiff is not entitled to a share in the suit properties in view of the exception to Section 6 of the Hindu Succession Amendment Act 2005. He therefore submits that there is no error committed by the trial court warranting interference. Next paragraph. The only point that arises for consideration is whether the plaintiff is entitled for a share in the suit shell item number 2, which was sold on 19/12/2003 by the plaintiff's father and her brothers. Question mark. Next para. Could read Hindu section.
And one
ಇದರಲ್ಲಿ ಎಕ್ಸೆಪ್ಷನ್ ಅಲ್ಲ ಪ್ರೊವಿಷನ್ ಟು ಸೆಕ್ಷನ್ 6 ಅಂದ್ಬಿಡಿ 6 the plaintiff fact that the suit item number 2 was sold by the father of the plaintiff and the brothers and her brothers was known to the plaintiff is evident from the averment made in the plaint where she states as follows. The plaintiff has obtained the RTCs and other title deeds relating to the suit shell properties. It has come to the knowledge of the plaintiff that one of the suit shell properties bearing survey number 49/1 was sold to one Doddaya by the plaintiff's father, defendant number 3 and 4 on 19/12/2003. Full stop. As held by the full stop. The Hindu Succession Amendment Act 2005, recognized the right of daughters to an equal share in ancestral properties, like a son, subject to certain conditions set out in proviso to Section 6(4) of the Hindu Succession Act, which reads as follows. Copy of.
So 2005 says it's by birth, Vinisha Sharma's latest judgment. Once it is been by birth.
6(5) and 6(5) and alienation 6 proviso B to Section 6(4) of the Act 19 of the Act 2005. Full stop. The reason for prescribing a cutoff date is to protect alienations made lawfully by the members of the family and to protect purchasers of such properties. Full stop. Therefore, the contention of the plaintiff that she is a unmarried daughter and that she should be granted a share in the suit item number 2, notwithstanding the sale date dated 19/12/2003, cannot be accepted. The contentions urged by the plaintiffs are already is no longer res integra in view of the judgment of the apex court in the case of Vinita Sharma versus Rakesh Sharma. Therefore, we do not see any error. Therefore, this court does not see any error in the judgment and decree of the trial court refusing to partition the suit item number 2, warranting interference in this appeal. Hence, this appeal lacks merit and is dismissed.
Sir, please add one more sentence. Whatever the drafting and everything, it is not being read by the appellant. And it
Where
is.
have you said?
I am not satisfied,
Where have you
sir.
said? Where have you said in the appeal?
Sir, appeal may
Appeal ಅಲ್ಲಿ ಎಲ್ಲಿ ಹೇಳಿದ್ದೀರಾ?
you'll know.
ಎಲ್ಲಿ
One
ಹೇಳಿದ್ದೀರಾ?
ನಿಮಿಷ. ನನ್ನ prayer ಅಲ್ಲಿ ನೋಡಿ. Prayer, please look
ಅಪೀಲ್
into
ಅಲ್ಲಿ
my.
ಎಲ್ಲಿ ಹೇಳಿದ್ದೀರಾ?
Sir,
ನನಗೇನು
I have
ನನಗೇನು
told in
ಗೊತ್ತಿಲ್ಲ. ನಮ್ಮ
appeal
ಅಣ್ಣ
prayer.
ತಮ್ಮಂದ್ರು.
Appeal prayer ಅಲ್ಲಿ ಹೇಳಿದ್ದೀನಿ sir. One ನಿಮಿಷ. I will take out the prayer. To 81. One ನಿಮಿಷ.
Where have you said in the appeal that your mother got it drafted? Lawyer ನಿಮ್ಮ mother ಇಟ್ಟಿದ್ದು ನನಗೇನು ಗೊತ್ತಿಲ್ಲ. ನಾನು ಶನಿವಾರ ಭಾನುವಾರ ಕಾಯ್ತಾ ಇದ್ದೆ. ಎಲ್ಲಿ ಹೇಳಿದಿರ?
No sir, I have told this casual. This is the. One second, sir. You see my prayer.
Yes, sorry.
Sir.
Yes, next.
Number 67, Leelavati PC, Vinay Swami.
Leelavati.
Sir, one more thing I have to say. That word is not been allowed me for a debatable where Vinita Sharma's case, which says,
Madam,
answer,
the
daughters
law
has
is
got by
settled.
birth, sir.
See, we don't have right to unsettle the law. If you want to challenge it, take it to the Supreme Court. We'll all be happy if your rights are recognized. Take
But
it to the
still,
Supreme Court.
there are appeal in judgment, whatever the trial court has been, judgment has been given. One word judgment I have answered. You are not looked into my appeal, what I have answered. It's just for one argument is been concluded. Please look into my this thing. What and all I have, one judgment I have answered, sir.
Please argue. I will note everything. You please argue. What is it you want to argue?
I'm coming to the appeal, this thing, one judgment sentence I have answered. 1 second, give me 2 seconds, 52, it's appeal. Brief facts of the case. It is submitted that the original suit is in this matter was, I will come into the, straight away go to the grounds. On 19, I am reading 56, page number 56.
Yes.
Point number 4. On 19 December 2003, executed the sale deed for the survey number 49/1 by appellant Kumari Shilpa's father, late Govindaya, to late Doddaya. Document number, I have written the document number, stored in CD so and so and dated 19 December 2003. Same property, late Doddaya executed the gift deed to his wife Srimati Anuman Arasamma on 20th March 2011. So the survey number, next point number 2, survey number 49/ sold to late Doddaya by appellant father and brothers, late Govindaya and sons. The purchaser called all the 3 brothers, father, mother and appellant Kumari is not being called. Why? Father, mother and brothers, and got the survey number 49/1 registered in sub-register office Magadi in favor of late Doddaya, name leaving the legal heir and unmarried daughter of late Govindaya. Photos and signatures are captured in sale deed at sub-register office Magadi and left the legal heir and unmarried daughter of seller late Govindaya Appellant Kumari, Shilpa, Gigi, why they left, why they took my brother's signature, why they left me. And point number 6, family partition done by appellant father, late Govindaya and his brothers before property sold to the Doddaya. That is the judgment copy, what I am reading. Before solding to Doddaya, 49/1 scheduled property. Comes to the share of affluent father late Govindaya. ನನ್ನ ಅಪ್ಪ ನನ್ನ ದೊಡ್ಡಪ್ಪಂದಿರು ಮಾಡಿರೋ ಪ್ರಾಪರ್ಟಿ ಶೇರ್ಸ್ ಅಲ್ಲಿ ಈ ಸರ್ವೆ ನಂಬರ್ 49/2 ನನ್ನ ಫಾದರ್ ಬರುತ್ತೆ. ನನ್ನ ಫಾದರ್ ಇಂದ ನಮ್ ಬ್ರದರ್ಸ್ ನಾನು ಪಾರ್ಟಿಷನ್ ಮಾಡಿಲ್ಲ, ನನಗೆ ಗೊತ್ತೇ ಇಲ್ಲ. ಐ ಆಮ್ ಸ್ಟೇಯಿಂಗ್ ಇನ್ ಬ್ಯಾಂಗ್ಳೂರ್. So coming to next, appellant Kumari, Shilpa, Gigi and our brothers, there is no partition taken place in appellant first brothers given the letter. Partition na tagondilla. Nan first brother, defend number 2, Anumanta Raju, he has given the release deed of this release deed ಕೊಟ್ಬಿಟ್ಟಿದಾನೆ. ಅದರಲ್ಲಿ ನನಗೆ ಶೇರ್ ನನ್ನ ಅವನು ಹೊರಟೋಗ್ಬಿಡ್ತಾನೆ, ಇನ್ ಮಿಕ್ಕಿದ್ರಲ್ಲಿ ನನ್ ಶೇರ್ ಬೇಕು. So letter stating that discharge of his rights and pertaining to his inheritance.
So ultimately, it all comes to the boils down to the same thing. We are sorry, we can't help you. It boils down to the same thing.
I have answered 1-1 trial court of the 1-1 judgment. If I don't ask the question with the Honorable High Court of the trial court, where shall I go? This each and every point I have answered. I don't know how, sir, alli young trial court to the argumental, I am openly telling, repeatedly telling, alli nanu argumental illa, avru ಏನು even and written statement ಕೂಡ ನಾನು ಓದಿಲ್ಲ. Is that I made mistake, you are going to punish me on this?
Yes madam, if you commit a mistake you will be punished.
Okay fine,
if you commit a mistake
sir,
you will be punished.
why do I come to
ಆಯ್ತು, ನೀವು ಕೋರ್ಟ್ ಹೋಗಿ ಎವಿಡೆನ್ಸ್ ಕೊಟ್ರಲ್ಲ.
Okay, why do I come to the Honorable High Court? Because of the trial court and not satisfied the answer, that's why I had come to an honorable court.
Nobody is interested to injure you, or nobody is interested to reject your claim case without considering the merits. We will consider the merits of the case.
What is less, sir, on a special cases.
ನಮ್ಮ ತಾಯಿ ಹೋದ್ರು, ನಮ್ಮ ತಾಯಿ ಲಾಯರ್ ನಿಟ್ರು, ನಮ್ಮ ತಾಯಿ ರೆಡಿ ಮಾಡಿದ್ರು, ನಮ್ಮ ತಾಯಿ
it is a fact, sir. That is not okay, sir.
That is not the concern of the court, madam.
Sir, ಅದು ಒಂದು sentence, sir, ಅದು ಒಂದು sentence ನಾನು ಹೇಳಿದೆ, yes ನಮ್ಮ ಅಮ್ಮ ಮಾಡಿದರೆ, ಅದನ್ನು ಒಂದು sentence ಇಟ್ಕೊಂಡು the lakhs together of property cannot be derived to the conclusion. Each and every part of that, what is the judgment? Yes. I have answered each and every part. ಅದು ಒಂದು ಅಮ್ಮ ಹೇಳಿದ್ರೆ, ಅದು ಒಂದು ಅಂತ ಹೇಳಿದ್ರೆ, I should not be deprived of such a huge property.
Next.
Number 67.
Yes, please.
See,
Number 67, Leelavati PC. Yes.
Sir,
can't help it, madam. Can't help it. If there's any way to help you, I would have helped you. There's no way I can help you. My hands are tied. The law is against you.
Please
take your chances. Go to the Supreme Court.
Why should I go to the Supreme Court, sir? I'll go to review petition, even double. There is other process. I will take it here only.
Please
and
do
then
it.
go.
Do it, madam.
Get it curated, sir. It's a on a special care. It says.
Madam, my hands are tied. Please understand. I am bound by the judgment of the Supreme Court in Vinita Sharma. I am bound by it. I am bound by the judgment of the Supreme Court. You are also bound. You should go to the Supreme Court and challenge it.
Sir, why
I cannot.
Sir, why the people are not looking into the by birth, the word by birth?
That is also considered by the Supreme Court. That is all even the Karnataka Amendment Act is also considered by the Supreme Court. Please have a look at the judgment. You do not have the time to read the judgment in Vinita Sharma. You come offhand. You say ardhambarda ಓದಿದೀನಿ.
ಅಲ್ಲ ಸರ್, ಓಕೆ, ಅದನ್ನ ಒಪ್ಕೊಳ್ತೀನಿ ಸರ್, ಅದನ್ನ ಒಪ್ಕೊಳ್ತೀನಿ. ಬೈ ಬರ್ತ್ ಅಂದ್ರೆ ಏನ್ ಸರ್ ಅದು? ಬೈ ಬರ್ತ್ ಅಂದ್ರೆ ಬೈ ಬರ್ತ್ ಗಿಲ್ಲ ಬರುತ್ತೆ ಸರ್ ಅದು. That sentence has to be explained now, sir.
Please start.
67.
ಬರ್ತ್ ಅಂದ್ರೇನು ಅದು ಸರ್?
For partition separate petition, this case dismissed. The partition suit mainly dismissed on mainly 4 grounds, my lordship. The first being
suit is for partition
separate petition, my lordship. And the difference 1 to 3 are the co-passers, my lordship. And difference 1 for the alleged purchaser or second alleged purchasers, my lordship. Difference 1.5.
Suit as ಏನಾಗಿದೆ?
ಅದರಲ್ಲಿ it was dismissed stating that there is no cause of action and based on the release date, my lordship. Exhibit D2, P6, Exhibit P6 and D2, my lordship.
You have executed a release deed.
No, my lordship.
Huh?
His father has
No, my lordship.
executed. Our father execute
It has not been proved by the defendants, my lordship. It has not been proved by the defendants 4 and 5, my lordship. Simply adducing the evidence, other than proving the evidence, my lord, exhibits, my lordship, the
No, you have filed a suit for declaration that the
partition separate position, my lordship. Not
Amma,
declaration.
you have filed a suit to declare
Yes, my lordship.
that the release deed dated 21/11/1985
Yes, my lordship.
and the partition deed dated 3/3/2004 are null and void.
Later, my lordship, after the amendment plaint, my lordship, we filed the necessary prayer, my lordship.
ಏನಂತ?
To declare, initially the prayer was only for the partition separate position, my lordship. Initially prayer, my lordship. Later on the case came to be dismissed, my lordship, for non-prosecution. Later it came to be restored. Later we went plaintiff.
Now, is it your case that your father did not execute?
Yes, my lordship.
Is it your case?
Yes, my lordship.
ತೋರ್ಸಿ ಎಲ್ಲಿ ಹೇಳಿದಿರ ಅಂತ. Where have you said that your father has not executed this release deed? ನಿಮ್ ತಂದೆ ಬರ್ಕೊಟ್ಟಿಲ್ಲ ಅಂತ ಎಲ್ಲಿ ಹೇಳಿದಿರಾ? ಕುಡಿಮ. Yes.
7 and 16 they are stated.
Loud,
Para
really?
7 of the plaintiff and also
Really?
in 16. Not in detail, but
Now let us see what they have said about
para
the
7.
release deed.
What is mainly belonging to the Mysore
ಮೇಡಮ್
election.
ರಿಲೀಸ್ ಡೀಡ್ ಬಗ್ಗೆ ಏನ್ ಹೇಳಿದ್ರ? ಪ್ಲೈಂಟ್ ಅಲ್ಲಿ ಏನ್ ಹೇಳಿದ್ರೆ ಓದು.
Mainly come to para 14 of 6, page 16, my lordship.
ಹಾ?
Para 14, my lordship.
ಪ್ಯಾರಾ 14.
Amended plaint copy, my lordship. Page 16.
ಆಯ್ತು ಓದಿ ಏನ್ ಹೇಳ್ತೀರಿ ಓದಿ.
The cause of action arose on first week of October 2003 when defendants refused to effect partition to the 1/4 share of the plaintiff's father in the joint family and joint Hindu undivided family whereas
ಕೊಡ್ರಿ ಇದು. ಓದಿ ಓದಿ.
in the joint Hindu undivided family where the said associated property belonged to plaintiff's great grandfather Mysore Lachendrappa. The plaintiffs approached the Honorable DSL and the same was pleased to alert one Kiran Kumar, advocate, dated as 14/10/2003 to file partition suit against defendants. Version of the allotment of Kiran Kumar, advocate from DLSC is produced as document number 4. The suit property comes within the jurisdiction of the Honorable Court.
ಎಲ್ಲಿ ಹೇಳಿದಿರಾ ನಮ್ ತಂದೆ ಎಕ್ಸಿಕ್ಯೂಟೇ ಮಾಡಿಲ್ಲ ಅಂತ?
Because we did not know, my lordship. We had no idea.
ಆಯ್ತು ಮೇಡಮ್ ನಿಮ್ಗೆ ಗೊತ್ತಾಯ್ತು.
Yes, ma'am.
ನೀವು ಸೂಟ್ ಫೈಲ್ ಮಾಡಿದಿರಾ ಟು ಸೆಟ್ ಅಸೈಡ್ ದ ರಿಲೀಸ್ ಡೀಡ್.
Yes, my lordship.
Have you said anywhere that my father has not executed this release deed ಅಂತ ಎಲ್ಲ ಹೇಳಿದಿರಾ? ಎಲ್ಲಿ ಹೇಳಿದಿರಾ? After you came to know this release deed, what are the steps that you have taken to find out whether your father has executed the document or not? Hmm.
When you come to para 17, my lordship.
Para 17. What?
The defendants are enjoying the plaintiff's further shares, including plaintiff's shares since 1985 to till date by created fabricated frivolous document dated 21/11/85 without coming to the knowledge of the plaintiff's father at all. Also, the defendants have not filed any declaration suit to that effect till date. Therefore, the so-called deeds are not binding on the plaintiff's plaintiff father. Hence, the defendants are entitled to pay messenger profits since 1985 to till disposal of the suit, including advocate fee along with interest 20 at 24%. The defendant failed to pay the same. The plaintiff, same to the plaintiff, the same may be referred to the defendant's share of social property, my lordship. So, coming to the knowledge, my lordship. So, coming to the knowledge of the plaintiff or plaintiff father, the sale deed has been drafted by the defendants. We came to know only of the filing of the release deed, my lordship.
That is
Along
80.
with the WS written statement, my lordship. Even in the cross examination, also, my lordship, the question was.
Suit is filed in which year? 2004.
2004, my lordship. And it came to be restored only in 2019, my lordship.
Yes. Bhagyalakshmi Leelamati Varaprasad. Yes, madam.
And my lordship, and the release deed, Alice release deed is a combination of a pre-dated stamp paper as a post-dated stamp paper, my lordship. And it is it has been purchased on so many dates. There are so many dates stamp paper, my lordship. Kindly come to the exhibits, my lordship.
Early the release deed adu?
D2.
Exhibit?
D2.
The date of execution of Alice release is on 21/11/1895, my lordship, and the stamp paper has been purchased on 26 November 1985, my lordship.
Yes.
There are many dates, my lordship. Even pre-dated stamp paper and post-dated stamp paper, my lordship. Even I filed application for the original sale deed to release deed to produce before this order of court, my lordship. Because the Xerox copy is not sufficient for the fair adjudication, my lordship. Kindly.
Yes, original ಏನಾಯ್ತು?
Original.
ನೋಡಿ D2 original ಅಂತ ನೋಡಿ.
No. See, back sheet the date of the sale deed is released is not properly stated, my lordship. In the Xerox copy, my lordship.
ಅಲ್ಲ original produce ಮಾಡಿದ exhibit court record ಅಲ್ಲಿ ಯಾವ್ದು exhibit D2 ನಾ?
Yes, my lordship.
Where is the original, mister?
Already
2 is the original.
ಎಲ್ಲಿದೆ?
Original sale deeds and all the original deeds are taken back by the respondents by my lordship.
Where is the original sale
Our
deed?
application ಹಾಕಿ dispose of case dispose
Return ತಗೊಂಡಿದ್ದೀರಾ?
return ತಗೊಂಡಿದ್ದಾರೆ. It is mentioned in the sale deed, sorry, in the judgment that original exhibit D2.
Yes.
Initially they produced the notarized copy, my lordship. Thereafter, after objection, my lordship.
Madam, mark ಮಾಡುವಾಗ did you object?
Yes, my lordship.
Have you objected?
Yes, my
ಇಲ್ಲಿ ತೋರ್ಸು.
And this the defendant's advocate stated that it is a registered date, so there is no objection is not maintainable, my lordship.
Madam, did you object?
Yes, my lord.
ತೋರ್ಸಿ. Mark ಮಾಡುವಾಗ if it was a certified copy or a photocopy,
The original copy was marked, my lordship.
original release deed was marked.
Yes, my lordship.
What steps did you take to establish that the signatures or the thumb impressions on the said document was not by your father? What steps have you taken?
The plaintiff strongly made an objection to that the release is not made by the plaintiff father, my lordship. And the
Madam, original document court ಮುಂದೆ produce ಮಾಡಿದೆಯಲ್ಲ?
Yes,
ಏನ್ steps ತಗೊಂಡ್ರಿ? To find out whether the signature or the thumb impression on exhibit D2 was not affixed by your father ಅಂತ ಏನ್ steps ತಗೊಂಡಿದ್ದೀರಿ?
There was only objection, my lordship, but the burden lies on the defendant because it is there.
Madam, this is not a compulsorily attestable document. Release deed is not a compulsorily attestable document. By producing this document, they have discharged their onus. ನೀವೇನ್ ಮಾಡಿದ್ರಿ? By producing the original of the release deed, they have discharged their onus. ನೀವೇನ್ ಮಾಡಿದ್ರಿ? ಇದಕ್ಕೇನಾದ್ರೂ ಕ್ರಮ ತಗೊಂಡ್ರಾ? ಈ ರಿಲೀಸ್ ಡೀಡ್ ಮೇಲೆ ಇರೋ ಹೆಬ್ಬೆಟ್ಟು ಸೈನು ಯಾರ್ದು ಅಂತ ವಿಮರ್ಶೆ ಮಾಡೋದಕ್ಕೆ ನೀವೇನೋ ಕ್ರಮ ತಗೊಂಡ್ರಾ?
In cross-examination and I put a question to the DW1, my lordship, that whether he was a party to the release deed, my lordship. He says everything no, my lordship. Purchaser, he is the second purchaser, my lordship. He is the second purchaser of the.
How would he know? How would he know?
That is my question, my lordship.
So therefore you should have.
Because, my lordship, the onus of burden of proof lies on the defendants, my lordship.
To prove what?
To prove the release deed, my lordship.
To prove the release deed. They have produced it. They have marked the release deed. They have marked the release deed. The release deed is duly executed. It is registered. How do you dispute that?
But they have not produced any witness to prove the same, my lordship.
Why should they? Why should they?
Because there is an objection from the plaintiff, my lordship, that their father has not executed the release deed, my lordship. Even I have filed the poster cover regarding the same, my lordship. Every month, different one, Rangata used to send the rent of the share of the plaintiff father, my lordship. Even it is on record, my lordship. And it is a disputed document shown to the DW1, my lordship.
You are ready or not ready?
Any tomorrow, my
You
lordship.
ready?
Any day, my lordship.
List tomorrow.
One proposal I have. Although his father had executed release date, subsequently your brothers ಏನ್ ಮಾಡ್ತಾರೆ, ಒಂದು ಪಾರ್ಟಿಷನ್ ಡೀಡ್ ಮಾಡ್ಕೊಂಡು ಮದರ್ಗೆ ಒಂದು ಶೇರ್ ಕೊಡ್ತಾರೆ, ಅನ್ನಪೂರ್ಣಮ್ಮ ಅವ್ರಿಗೆ. ಅನ್ನಪೂರ್ಣಮ್ಮ expires. There is a will set up, but it is not proved. But trial court holds that in the Annapurnama share, all the children will be entitled to one share anta. So Annapurnama has 5 children, 4 sons, including the father of the plaintiff.
The father of the plaintiff predeceased Annapurnama.
Allah, even then, because correct, but still we are ready to consider that whatever share Annapurnama's share partition deed alla Annapurnama ಅವ್ರಿಗೆ ಏನು share ಹೋಗಿದೆ, ಅದರಲ್ಲಿ 5 children would be entitled anta. There is an observation made in the.
Yes.
But a separate suit has to be filed because one co-personer is left out, Putlakshmi anta, ಇವರ ಸೋದರತ್ತೆ father ದಿನ ತಂಗಿ ಅವರು. We have paid 10 lakhs to her to get a confirmation deed because she had filed a separate partition suit in OS 8180.
Wait, the list tomorrow. Please come ready. Monday's criminal petition.
First of.
Oh no. Come tomorrow.
68, Somsekhar came. 68.
Came Somsekhar.
Lord, I have paid the cost, my lord.
Animsha Tali, please wait for your turn.
I have paid cost on 23, my lord. I filed acknowledgement also.
ಆಯ್ತು, ಅರ್ಗಿ ಒಂದು ಮಾಡಿ. ನಾನ್ ನೋಡ್ಬೇಕು, ನೀವ್ ಯಾಕೆ ನೋಡ್ತೀರಿ?
ಅಲ್ಲ ಸೀನಿಯರ್ ಇದೆ, ನಾನ್ ಟೈಮ್ ನೋಡ್ತಾ ಇಲ್ಲ. ಸೀನಿಯರ್ ಕೌನ್ಸಿಲ್ ಜಸ್ಟ್
ಇದರಲ್ಲ ಬಂದ್ರಲ್ಲ. ನಿಮ್ದೇ ಲಾಸ್ಟ್ ಮ್ಯಾಟ್ರ್ ಮಾಡಂಗಿದ್ರೆ ಮಾಡಿ ಒಂದು ಅರ್ಧ ಗಂಟೆ.
ನೆಕ್ಸ್ಟ್ ವೀಕ್.
Counsel for the appellant seeks time distance also. Final hearing ಅಲ್ಲಿ ಒಬ್ರು ರೆಡಿಯಾಗಿ ಬರಲ್ಲ. ಫೈನಲ್ ಹಿಯರಿಂಗ್ ಅಲ್ಲಿ ಒಬ್ರು ರೆಡಿಯಾಗಿ ಬರಲ್ಲ.
ಬೇಜಾರ್ ಏನಿದೆ ಅಂದ್ರೆ 2024 ಮ್ಯಾಟರ್ ಬೇಗ ಮುಗ್ದೋಗ್ತಾ ಇದೆ.
ಬಟ್ ಹೇಳ್ಬೇಕು ನೀವು, ಬೇಡ 2023 ರಾಷ್ಟ್ರ ಬೇಡ ಅಂತ ಹೇಳ್ಬಿಡಿ.
2010 ಮ್ಯಾಟರ್ ಇನ್ನು RFA ಗಳು ಹಂಗೆ ಉಳ್ಕೊಂಡಿದ್ದಾವೆ.
ಕರೆಕ್ಟ್, ಬಟ್ ರಾಷ್ಟ್ರ ಇರೋದು 2023 ಏನ್
ಕೊಟ್ಟಿದ್ದಾರೆ, ನಾವು ಮಾಡ್ಬೇಕು, ಏನ್ ಮಾಡ್ಬೇಕು?
ಕರೆಕ್ಟ್. ನೀವು ಹಂಗಂತ ಇಸ್ ದಟ್ ಎ ಜಸ್ಟಿಫಿಕೇಶನ್? ರಾಷ್ಟ್ರ ಇರೋದು 2023ನೇ, ಏನ್ ಮಾಡ್ಬೇಕು ನಾವು? List on phones on date put. Yes, madam. ಶಿಲ್ಪ ಅಲ್ಲ ನಿಮ್ಮ ಹೆಸರು? ಶಿಲ್ಪ ಹೇಳಿ.
Sir, I really, it is, in a one day argument's conclusion is just taken based on my trial court. No, sir, it is really not.
You want to argue again?
Argue again and please get into.
Tell me how much time you need. How much time do you need?
Next, we are in March. April month.
ಅಲ್ಲ ಮೇಡಮ್, ನಾಳೆಗೆ ಹಾಕೋತೀನಿ. ನಿಮ್ಗೆ ಎಷ್ಟು ಬೇಕು ಟೈಮ್ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಕ್ಕೆ? ಹಾಫ್ ಅನ್ ಅವರ್.
ಓಕೆ, ಅಪೀಲ್ ಅಲ್ಲಿ ಜಡ್ಜ್ಮೆಂಟ್ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅವರು ಏನ್ ಹೇಳಿದಾರ ಅದು ಒಂದೊಂದಕ್ಕೂ ಆನ್ಸರ್ ಮಾಡಿದೀನಿ ಸರ್. ಪ್ಲೀಸ್ ಆನ್ಸರ್. ಅಂದ್ರೆ ನನ್ಗೆ
ನೋಡಿ ಆ ತರ ಒಂದ್ ನಿಮಿಷ ಹೇಳ್ತೀನಿ ಕೇಳಿ. ಕೊಡ್ರಿ, ಇದು ಕಾನ್ಸ್ಟಿಟ್ಯೂಷನ್ ಕೊಡಿ ಅವ್ರು. ಸ್ವಲ್ಪ ಪ್ಲೀಸ್ ಸ್ವಲ್ಪ ಓದಿ, ಇದನ್ನ ಓದಿ ಕೊಡಿ. 142 ಓದಿ ಪ್ಲೀಸ್. ಅಲ್ಲ ಆರ್ಟಿಕಲ್ 142 ಕೊಡ್ರಿ. ಸ್ವಲ್ಪ ತಾಳಿ ಮೇಡಮ್, ತಾಳಿ.
Please, it is article, constitution has given the structure on a case to case basis. It has to be curatively. Other ಎಷ್ಟೊಂದು
ಮೇಡಮ್, ಒಬ್ಬೊಬ್ರಿಗೆ ಒಂದೊಂದು ಅಂತ ಕಾನೂನು ಮಾಡಕ್ ಆಗಲ್ಲ. ಪ್ಲೀಸ್ ಹ್ಯಾವ್ ಎ ಲುಕ್ ಎಟ್ ಇಟ್. ಕೊಡಿ, ಓದಿ.
micro level something judgment has
The law applies to a particular class of people. So therefore,
I wanted to ask, I am talking to an honorable high court. See, law macro level ಅಲ್ಲಿ ಮಾಡಿರ್ತಾರೆ ಸರ್. ಹ್ಯೂಮನ್ ಬೀಯಿಂಗ್ಸ್ ಅಂತ ಹೋದ್ರೆ ನೀವು ಕೇಸ್ ಟು ಕೇಸ್ ಅನಲೈಸ್ ಮಾಡಿದ್ರೆ ಆ ಮ್ಯಾಕ್ರೋ ಲೆವೆಲ್ 1 ಬೇಸ್ಡ್ ಲಾ ಥಂಬ್ ರೂಲ್ ಮೇಲೆನೆ ಹೋಗಕ್ ಹೋದ್ರೆ ಅದು ಸಾಧ್ಯ ಇಲ್ಲ ಸರ್. ಇಟ್ಸ್ 1% ಅಂದ್ರೆ thousands reasons ಬರುತ್ತೆ. ಆ ಥಂಬ್ ರೂಲ್ ನ ಇಟ್ಕೊಂಡು
ಫಸ್ಟ್ ಒಂದ್ಸತಿ ಓದಿ ಆರ್ಟಿಕಲ್ 142 ಓದಿ ಮೇಡಮ್. ಫಸ್ಟ್ ಓದಿ.
This is
ಆರ್ಟಿಕಲ್ 142
Article 142.
ಓದಿ, ಕೆಳಗಡೆ ಇದೆ ನೋಡಿ.
Okay, 148(2). Enforcement of decree and orders of Supreme Court and orders as an discovery, etc. The Supreme Court, in the exercise of its jurisdictions, may pass such degree or make such order as necessary for doing complete justice in any cause of matters pending before it, and any degree to passed or order to made shall be enforceable throughout the territory of India in such manner as may be prescribed by or under any law made by Parliament until provision in that behalf is so made in such a manner as the president may be order or prescribed. Fine, it is for the whole jurisdiction ಹೇಳ್ತಾ ಇದ್ದಾರೆ.
ಜುಡಿಷಿಯಲ್ ಅಲ್ಲ ಮೇಡಮ್, ಸ್ವಲ್ಪ ನೀವು ಇಂಜಿನಿಯರ್. It is like talking something very strange to an engineer. Law and engineer doesn't gel well. If I as a lawyer, please wait. As a lawyer, if I were to talk of engineering concepts, you will mock at me. As a lawyer, if I were to talk of engineering concepts or managerial concepts, you will mock at me. Similarly, you are an engineer. You do not know the law. So whatever, engineer or a managerial, whatever.
Law is just based on it's a family, it's an institution.
ನೀವು ನಾಳೆ ಅರ್ಧ ಗಂಟೆ ಟೈಮ್ ಕೊಡ್ತೀನಿ. ನೀವು ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡ್ತೀರಾ? ಅರ್ಧ ಗಂಟೆ ಒಳಗೆ ಕ್ಲೋಸ್ ಮಾಡಬೇಕು. If you close it within half an hour, I'll keep it tomorrow. If you say you want more than half an hour, the same judgment will follow.
Half an hour, I'll do it.
Okay. Come at 2:30 tomorrow. I'll take your case at 2:30. By 3 o'clock, you should finish.
And my appeal has to be read one by one.
I will read it one by one only. You should finish by 3 o'clock. half an hour I'm giving you. Yes, you type mabadi nalige itಕೊಂಡು. Yes. I don't want to send you disappointed. That is why I'm giving you half an hour time. I don't want to disappoint you. You should not go out of the court with a heavy heart thinking that the judge did not hear me properly.
Yes.
So therefore, I'm giving you half an hour. Whatever point you want to argue, please argue tomorrow. Go out satisfied. Go out of the court satisfied that your concerns, your grievances were heard by the court. Understood? Naleg bani, 2:30.
ಬುಕ್ ತಗೊಳ್ಳಿ ಸರ್. ಸರ್ ಸೀರಿಯಲ್ ನಂಬರ್ 63 ಅದು ಸರ್ 63 ಸರ್ ಯಾವ ಡೇಟ್ ಸರ್ 63
68 ಸರ್ ನಿಮ್ದು ಸೆಕೆಂಡ್ ಏಪ್ರಿಲ್ 63 10th ಏಪ್ರಿಲ್ ಸರ್.
ಸರ್ ಅದು ಕಾಸ್ಟ್ ಯಾರಿಗೆ ಅಲ್ಲ ಕಾಸ್ಟ್ ಯಾರಿಗೆ
2000 ರೂಪಾಯಿ ಸರ್.
ಅದೇ ಯಾರಿಗೆ ಕಟ್ಟಕ್ಕೆ ಇವ್ರು
ಅಡ್ವೊಕೇಟ್ ಕ್ಲರ್ಕ್ ಅಸೋಸಿಯೇಷನ್ ಸರ್.
ವಿತ್ ಇನ್ ಟೈಮ್ ಏನಿಲ್ಲಲ್ಲ
10th ಏಪ್ರಿಲ್ ಒಳಗಡೆ ಕಟ್ಬೇಕು ಸರ್.
ಓಕೆ ಓಕೆ